Hey, my beautiful friends. Hey, everybody. Hey, 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 hey. It is Thursday morning. Are you guys ready for some speed watch Daybell? Want to speed watch some Daybell? How are you guys doing this morning? Hey, QB. Yes, put your DNA all over that like button. Please, please, please. By the way, you guys, I completely forgot and I did not end the poll the other day for Daybell when the question was, how do we think Tammy died? Was it, I think I had like 3 different options. One was poisoned, one was natural causes, and the third option was suffocation. And I don't remember the exact, when I checked it afterwards, I don't remember the exact vote numbers, but the vast majority of you voted for suffocation, asphyxiation. The biggest chunk of you did. So, but yeah, I just wanted to remind myself to tell you guys that. So there you go. While you're at it, please do all the other YouTubey things like subscribe and share to let others know about our channel. Thank you. And we do have an awesome channel over here. Officially, we have hit the 400 subscriber mark. It happened last night. I'm so excited. So excited. Yeah, I just can't hide it. You know, I know, I know, I know. I want you. I want you. Hey, Margaret. Hey, Henny. Hey, Henny. Hey, Gail. Good morning. Hey, Miss King. Sherry. Sherry. Hey, Lauren. How are you guys? Hey, Gail says, I can finally spend all day with y'all. My best friend from high school has been here for the past 3 days. We had the best time. I miss them already, but I'm so tired. I'm just going to relax and hang out today. Oh, that's awesome, Gail. That's pretty cool. I'm glad you got to spend all that time with them. That sounds amazing. QB says, hello, hello, y'all. Welcome on in. Welcome on in. Come on in. Get your cup of coffee. Or a Pepsi if you're Morgana. Or Dr. Pepper for some of you guys that like Dr. Peppers. QB says, Pryor is supposed to rest today. Yes. Oh, Margaret says, I'm going into work shortly. Late today. Oof. Hey, Spins. Hey, hey, hey. Hey, hey, hey. Yeah, 400. We finally hit the 400 mark. We did. We did. Thank you, guys. Yes, 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 yes. All right. So, lots of celebratory things, you guys. Wow. Today we hit 400. Tomorrow is the big day here. We have a high school graduate and an 18-year-old. Mm. Mm-mm-mm. It's enough to break a mama's heart. Happy and sadness at the same time, right? It's like, where does all the time go? Where does the time go? I'm telling y'all, if you got youngins, don't blink. Don't blink. Okay. We are adding Daybell to the stream here, and we're going to speed watch day 28, which was yesterday. And then we can get through, then we will get caught up today as well. That would be awesome sauce, right? That would be awesome sauce. Awesome sauce, awesome sauce. Okay, so I'm going to hit the play button so we can get through this mighty quick. Okay, I'm going to put it on 1.25 and we'll get on with the program. Okay, let me put it on that now before I forget. 1.25, and here we go. Let's speed it up.
Thank you. Good morning. We've got our jurors lined up, I believe. So if everyone would just remain standing, we'll have them brought in.
Yes, right. Miss King, take pictures every minute of the day. It does go so fast.
All right, wait.
Ah. You should what, QB? What should you do?
Here's off right there, for you, Honor. Thank you. Please be seated.
Oh, blue, black tie.
All right. Good morning, everyone. We're on the record on case CR 22-21-1623, State of Idaho versus Chad Daybell. This is continuing with the defense case in chief. The court would note the jurors are all present and accounted for, and the court received the declaration that they followed the court's admonishing instruction when we broke for the day yesterday. So I want to thank the jurors again for continuing to follow that instruction from the court. At this time, the court also notes there's a courtroom conduct order in effect for all of those in attendance. And Mr. Pryor, I believe the defense is now ready to call the next witness. Is that correct?
Yes, Your Honor.
Go ahead and call your witness.
And Judge, may I have the court's permission to approach the podium?
Yes.
He's a
Thank you, Your
lemon
Honor.
head, Margaret. That's what his problem is. Oh, is it echoey? Dang it. Hold on. Shoot.
It's the state police run them. It's the state police run them.
Mr. Wood, I apologize for the interruption. Could I have a quick sidebar with counsel, please?
How about now? Well, can't hear nothing now with them not playing. Them not saying nothing. Hold on. Let's wait till they get going again. Wait, why are we 5 hours and some minutes in? What's the heck with that? That should not have happened. What in the world?
W. Boyce, Judge presiding. Thank you. Good morning. We've got our jurors lined up, I believe. So if everyone would just remain standing, we'll have them brought in.
Okay, is it echoey now? Wait till they start talking. Hold on. This audio is going to be the death of me, man. It's going to be the death of me.
Chad Daybell. This is continuing with
Okay.
the defense case in chief.
So now,
the jurors
let me
are
know
all
if it's
present and accounted
echoey,
for, and the court
but
received
also, can you hear me
declaration
over
that
the
they
stream?
followed the court's admonishing instruction when we broke for the day yesterday. So I want to thank the jurors again for continuing to follow that instruction from the court. At this time, the court also notes there's a courtroom conduct order in effect for all of those in attendance. And Mr. Pryor, I believe the defense is now ready to call the next witness. Is that correct?
Yes, Your Honor.
Go ahead and call your witness.
And Judge, may I have the court's permission to approach the podium?
Yes.
Thank you, Your Honor.
Okay, good deal. Hey, Mickey Jor.
Judge, the defense would call Patrick Eller.
Very well.
And Judge, while we're waiting for Mr. Eller, I have exhibits 137, 138, and 139, 139 being in a plastic container. My understanding is that the state has no objection to the admission of these exhibits.
All right, the witness is here. Let's go ahead and have the witness sworn, and then we'll take up the matters of the evidence.
Do you solemnly swear or affirm that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth? So help you God? Yes, ma'am.
Yes. All of them? Yeah.
All right, at this time, I believe as Mr. Eller's being proposed as an expert, I don't think the exclusionary order would apply here in this matter, so I won't do that line of questioning. If you'd like to inquire on direct, you may. Mr. Pryor, I know you've potentially offered some exhibits here. If you'd like to start with those to get them admitted, if they are going to be admitted, we could begin there, or you can begin with direct.
Okay. And Judge, 137 would be Mr. Eller's report. 138 was only for demonstrative purposes as part of the cast evidence. That was what Officer Stubbs and Officer Balance had testified to. And then 139, Judge, would be Mr. Eller's video presentation, which I understand the state is, I'll let them speak for themselves, I guess.
It's the state police run them.
Would I apologize
It
for
did
the,
it again.
sidebar?
Dang it. Hold on. Why does it keep jumping like that? Oh, it's making me mad.
Could begin. I believe as Mr. Eller's being proposed as an expert, I don't think the exclusionary order would apply here in this matter, so I won't do that line of questioning. If you'd like to inquire on direct, you may. Mr. Pryor, I know you've potentially offered some exhibits here. If you'd like to start with those to get them admitted, if they are going to be admitted, we could begin there, or you can begin with direct.
Okay. And Judge, 137 would be Mr. Eller's report. 138 was only for demonstrative purposes as part of the cast evidence. That was what Officer Stubbs and Officer Balance had testified to. And then 139, Judge, would be Mr. Eller's video presentation, which I understand the state is, I'll let them speak for themselves, I guess.
All right, let's take those in turn. On the offered first exhibit 137, it's been offered. And who's going to be conducting cross on this witness?
I will, Your Honor. And I would just inquire of Mr. Pryor if the issue we discussed previously was taken care of in that exhibit, and if it is,
Yes, Judge.
then the state does not have any objection to any of those exhibits.
Okay, exhibit 137, exhibit 138, and exhibit 139 are each admitted. You can begin with your direct then, Mr. Pryor.
And Judge, I believe the clerk may have put the wrong tag. Demonstrative 139. My 139 would be the audio presentation, so those guys need to switch.
All right, we'll straighten those out. And Mr. Pryor, if you could pre-mark exhibits, that would be helpful, so the clerks aren't required to do that while they've got their hands full doing other things here during trial, please.
And Judge, I'm going to ask at some point to be using the Elmo device as far as Mr. Eller's report, but with the court's permission, I'd like to proceed with my direct examination.
All right, you can go ahead and get started with direct.
Thank you. Would you state your name, spell your last name for the record for me, please?
Yes, sir. My name is Patrick Eller, E-L-L-E-R.
And may I call you Patrick?
Yes,
We know each other, so you've been retained as an expert in this case, is that correct?
yes, I have.
Okay, and Patrick, can you tell me a little bit about what you do for an occupation?
Yes, I am the CEO and principal digital forensic examiner for a company called Metadata Forensics, LLC, which is based out of Richmond, Virginia.
And what type of business is Metadata Forensics engaged in?
So Metadata Forensics is a full service consulting and training firm that does digital forensics on devices. We do expert testimony. We do training for law enforcement, attorneys, victim advocates. We examine any device that contains data or any data that's turned over to us.
Okay, so it's a broad range of anything that's an electronic or digital of any kind. Your firm engages in the investigation, discovery, and reporting of what findings you find as a result of being provided that data. Is that right?
Yes, that's correct.
Okay. Can you tell me a little bit about your education?
Yes. So I have a undergraduate degree in criminal justice from Troy. And then I have a master's in science and digital forensics from the University of Maryland, Global Campus. Outside of that, I have numerous digital forensics training courses and certifications over a 15-year period.
Okay, can you tell me, and you talked a little bit about the training, can you talk to me about a little bit about your previous experience in terms of uh, uh, government affiliations?
Yes, so I spent 20 years in military law enforcement for the Army. Throughout that time, I served in positions of just a regular police officer, through criminal investigator, through supervisor, supervising general crimes, drug crimes, and then finally computer crimes. When I finished my career with the Army in 2019, I was the command digital forensic examiner over the digital forensics program for the entire U.S. Army criminal investigation program.
Okay, and in terms of education and training of other entities, can you discuss that a little bit?
Yes. So throughout my career and even currently under my current company, we continue to train attorneys, both civilian and military, and we also still train law enforcement, both military and civilian law enforcement, through the National Forensics Academy, through the United States Army Military Police School, in digital evidence and all types of crimes.
Are there any certifications that you have that you can discuss today?
Yes, so I've been previously certified as a digital forensic examiner and computer crimes investigator through the Defense Cyber Training Academy in Lincoln, Maryland, and then I also have multiple vendor certifications as well.
And if I understand correctly, I can't recall if you previously talked about you running the General Army's entire forensics examination department. Was that discussed?
Yes, that was my final position in the Army. So from the last 7 years that I was in the Army, I helped build out the digital forensics program for the Army Criminal Investigation Division at Quantico. And then we spread it across the globe, building multiple locations out with digital forensic support across the Army.
And then you mentioned the fact that you have educated lawyers, law enforcement, other entities. Are you currently in the business of teaching and educating at this point?
Yes, we do about 25 to 30 classes per year for legal entities and law enforcement entities in the field of digital forensics investigations.
And what about any professional associations?
Yes, so I'm a fellow with the American Academy for Forensic Science in the digital and multimedia section. And the affiliation there is, that's a decade worth of
That's
work to
funny.
get to the status of
Stranger
fellow.
danger,
I've
stranger
spent time
danger.
as the chair of that section. And then I've also was affiliated and have been a previous commissioner for the Forensic Science Education Accreditation. That is the program that accredits the forensic science programs at universities across the country.
And engaging in your profession, does that require any specialized knowledge or understanding?
Yes, it does.
Can you discuss that with me briefly?
So with digital forensics, the use of digital data that the average person uses on a daily basis, I equate it to the best scenario is the iceberg effect. So part of an iceberg that you would see above the water, the 10% of it, is the amount of data that individuals would typically deal with on a device any given day. The 90% of it below the water that you don't see is the data that we specialize in looking at and getting to the metadata in order to do what's called attribution. And attribution is just the ability to say what the data actually means or what it doesn't mean or what it shows or what it doesn't show.
So when you use the term metadata, for someone like me, or maybe not even someone like me, someone who's at least somewhat educated in phones and electronics, what does metadata mean?
Metadata is simply data about data. And so as an example, if you have a picture, you see the picture, but the metadata is all the information that made that picture become a picture. Dates, like date and timestamps, location data, information about the device that would have created that image, information about if the image has been manipulated, if it's been changed, if it's been filtered, if it's been cropped, has the date been changed, all the information that gets tracked by the operating system when using data is what metadata is.
Now I'm going to get off the subject a little bit and move towards this concept of the manner in which you can identify certain phones through metadata. And what are the different ways that you can identify either a location or find that a phone is in a particular area, and what sources of information do you use?
So when you talk about locating phones, there are multiple sources. One being the device itself contains location data. The other are cellular providers who maintain certain amounts of data about the transmission of information between the device and the carrier that travels through towers and switches that they maintain. And then there's also metadata that's maintained by all of the applications on the phone, depending on what you choose to share as the settings with that application. There's data that you can request from Google, from Apple, from Meta, from Twitter. All of the individual applications also store data.
And if you were to identify the best source of information to identify the location of a phone, what source would that be?
In my opinion, the best source would be the phone itself. And I understand that there are settings that you can turn on and off about location data. However, there's data that is still being tracked within the device itself by the operating system in the phone that can be retrieved as well. That comes down to what they call native location data. Native location data is data that's populated on the device that is actually showing where a device would be.
Okay. And then what other sources can you use to identify the location, or at least a close proximity of what the location of a phone is?
So you can use information that is captured by the phone manufacturer or the operating system on the phone, be it iOS for Apple or Google for most of the other devices that are used across.
Okay. Now, an interesting question I have is, what if I have Verizon and another phone has Apple or T-Mobile? Does that change whether you can access it through Google?
It does not change. It just changed what they would store because it depends on what you're using on the device itself.
Okay.
So AT&T can have Android phones and Apple phones. Verizon can have Android phones and Apple phones. And so if you have an Android device, you would have some Google information because you're required to have that Gmail address in order to register the device.
So in other words, regardless of whether you, well, I
Is
guess
the
I'll rephrase
speed
this. So in
okay
other
for you
words,
guys?
by just having an Android device,
1.25.
you're required to have a Gmail account. In that sense, Google can track you regardless of through your Gmail account, correct?
Yes, they would have information about you registering the device. They would have information about what services you've enabled, what services you haven't, and then they would have what you're allowing to be stored.
Okay. Now, in terms of disabling a device,
Yes.
is it as simple as on my phone as just pulling my phone out and saying settings and turning off location?
So that is one way
Okay,
to
good deal.
turn off information. But the thing with Google is, as far as Google goes, is there's also web and activity information. There are settings within your Google account that you have to change, not just turning off location services on the device itself.
So if someone were even trying to disable their phone, it's more than just flipping to a page and saying disable.
Well, you could just turn the device off.
Okay. Or you do the turn off the location.
Correct.
Okay. Okay. Now, I want to discuss with you, as part of your review, do you recall what documents and pieces of evidence you observed and examined as part of this case?
Yes, there are a lot. I mean, if you're talking about a specific item, because there were a lot of devices, a lot of data that was turned over to be reviewed, that was gathered through Google, through Apple, through devices, through other sources.
Okay. Now you, as part of this examination and as part of my office asking you to review this information, did you have an occasion to review some what is called geofence evidence?
Yes, I did.
Talk to me a little bit about, in what would be my term, simpler terms, about what is geofence evidence?
So geofence evidence is, it's not something that Google intended to even be used in this manner, but the point behind that is geofence allows you to take a location, put a radius around it, and submit a search warrant in order to gain information about devices that would have passed through that geofence or within a certain proximity of that geofence.
Okay. And Judge, before I go any further, I don't have a direct recollection. Did we admit 137, 138, and 139?
We did.
Okay, thank you, Judge, Your Honor. Now, you had an opportunity to also listen to the testimony of Officer Stubbs, is that correct?
Yes, that's correct.
And then Officer Balance, is that correct?
Yeah, agent balance. Yes,
Agent Balance?
yes, that's correct.
And you had an opportunity to, examine what their testimony was in terms of what they presented to this jury, is that correct?
Yes, that's correct.
Can you testify about some of the conclusions you drew from listening to their testimony?
So, well,
Let's
Objection, that's overly broad.
talk about their location data in terms of their geofence testimony about Alex Cox's phone on, let's say, September 9th.
okay.
Go ahead.
What would you like to know about it?
Well, I'd like to know what you took an opportunity to examine the geofence evidence from September 9th and listen to the testimony of Officer Stubbs. Is that correct?
Yes, I did.
Did you find anything of interest in terms of his testimony that caused you to conduct further review?
Yes. So in listening to the testimony about how the geofence was done and what was returned as part of the search warrant from Google and the geofence, I went back and looked at the return data that was given back by Google for the geofence, and I found that there were more devices than what were actually requested to be identified.
And we previously marked Exhibit 138, and I can put up on the screen and tell me which of these screens we want you to examine. Judge, if I could use the HDMI,
Yes, if you're going to
I'll let
publish,
you know when I'm ready, Judge.
which exhibit are you publishing?
138. And not yet, Judge. It's and Judge, if we could at this point. Now you recognize this document, is that correct?
Yes.
And that was the document from Sergeant Stubbs, is that correct?
Yes, this was a search and a season search warrant that was submitted to Google to get the device IDs, or excuse me, to provide information about these individual device IDs that were returned from the first part of the Google geofence search warrant that produces anonymous device IDs that are assigned by Google.
Okay, and then if we look under the words, which are right in the middle of the screen, premises, that's addressed to the Google.
Yes, it is.
And then just below that, there's a line that starts with the word 11.
Yes.
And what does that involve?
So there, what's being requested are information about who those device IDs belong to.
Now, I need you to talk a little bit about that, okay? About the concept of device IDs. That ID doesn't necessarily mean it's a phone number, does it?
No, that ID is Google assigned anonymous numbers that only Google can trace that number back to an individual user.
Would this be properly characterized as a security issue with Google?
I can't say why they do that, but this is why they provide, when you submit the geofence, they provide you a list of these numbers, and then you have to submit a second search warrant like this one in order to get information about who the subscribers were that are linked to those numbers.
So if I understand correctly, and please correct me if I'm wrong, at this point, there was a search warrant issued by Detective Stubbs, is that correct?
Yes.
And it was sent to Google, and he identified 11 IDs that he'd like some information on?
Yes, that's correct.
Okay. And then, and the manner in which he would choose these 11 IDs would be what?
So I can't speak to his exact manner. Based on the testimony that I reviewed, it said that they took all the data and put it in a system and attempted to identify the ones that had commonality.
Okay, and when we talk about commonality, what does that mean?
So commonality would mean that based on the review of my understanding of what they did was they were trying to show devices that would have been in multiple places.
Okay. Okay, and the information that they're including is described in A, B, C, and D, is that right?
That is the information they're requesting.
The information, the name, the address, contact, that sort of stuff.
That's correct.
Okay. And then at some point, as we scroll down, there is information provided. And can you talk a little bit about this information?
Yes. So in the far left column where it says device ID, that is the device IDs that we were talking about just a few seconds ago, further up. And then from there, the time and date is the date and time of when that device ID would have been seen inside of the radius that they provided for their initial search warrant for the geofence. And then you'd have the latitude and longitude, which would be the location data. The source of that action, or the source of why this was recorded or where it was from, would be Wi-Fi, GPS, and then that map display radius is their margin of error.
Okay, and Judge, does he have a red?
Laser pointer?
Yes.
I think there is one there.
Okay, and if you really slowly again, because just to making sure that we track us, could I have you go over that again and starting with the device ID with the laser pointer?
Yes. So the device ID right there explains that anonymous number that is assigned by Google, that only within their records where they store this information are they able to link this back to an individual device.
Okay.
The next column over with the time and date, that is the time and date of this information here, which is the location and the source of that information, and then the margin of error that was recorded for the information here by those devices to be associated with that initial geofence warrant that was submitted for the radius of what they were searching for on that particular day.
So if I understand, we have the device ID on the left, which is under the word location 1. The next would be the date. And in this particular screen that Officer Stubbs requested, looks like September 9th of 2019 and at 9:18. Is that correct?
I see 919 as the first entry.
19. Oh my goodness, I need my glasses. 9:19. 38, it looks like. Is that correct?
Yes, that's correct.
And then when we're talking about the longitude and latitude, do you recall what location Officer Stubbs was interested in?
That would be the Chad Daybell residence.
Okay, and you reviewed this data as part of your review of this case. Is that correct?
Yes, I did.
And you reviewed this information that Officer Stubbs and one of the other officers, Balance, testified to regarding this information as well. Is that correct?
Yes, I did.
Okay, what did you find in terms of your investigation of note in your review?
So in my investigation,
Hey,
looking at
sweet
this
Brenda. Good to see
information,
you.
and going to not just this paper copy of this record, but looking at the actual
You're never
return that
late.
came back
They only
from
just
Google
started
that
really
these
not
records
too
were
long ago.
contained in, there was a lot of other devices, and there was devices prior to 919 on September 9th, as well as devices within there's more records that were actually provided than what you would see here.
Okay, so to put this in plain English for me to understand and for everyone else to understand, what this data shows is that these are IDs of phones that are in the proximity of the Chad Daybell property or on the Chad Daybell property on 9/9 of 2019, correct?
Their devices, yes.
For devices. So this list of things that you have in front of you include all of the device IDs that somehow registered at or near the Chad Daybell property on September 9th.
This does not include all of them. This includes only the ones that they were asking to be identified.
Okay, and we're going to get to that in a minute, but I want to put this in context a little bit. So if depending on the radius, if a phone was either on the Chad Daybell property at any time or was near the Chad Daybell property, depending on the radius, you would get an ID of some sort. Is that correct?
That's correct.
And what is the source of that ID? Where is that ID coming from? How is that ID arriving? Is that through the Google app?
It is through all of the information that Google tracks from a device.
And when they're saying the ID, that could include someone who doesn't turn off their Facebook location. Is that fair?
It could be, yes.
That's someone who doesn't turn off their location on their Gmail. Is that correct?
Yes.
That's someone who could do something with their Twitter or any other app that they have on their phone and they just fail to disengage.
Objection leading.
Sustained.
Would it be that if there's a failure to disengage any location data on any of the apps, that you would get an ID number?
Objection leading.
Sustained.
What would be the process of obtaining IDs other than turning off the location device on a phone?
So this information that's being tracked across this, for instance, if you were to connect to a Wi-Fi signal from a device, you would also generate a field within this. And so it's not just the device itself, but what the device is doing and what information Google is populating within their records about what's going on that device.
Okay, so when we look at the numbers that are provided here, these are all a series of numbers.
Yes.
You testified that this wasn't an exhaustive list. What do you mean by that?
So the full list of devices, actually, it was returned in spreadsheet format. And when sorted, you would see one by the order of time and date, because you can see here a lot of these are out of time and date. Like it's not in time date sequence, it's in device ID sequence.
Okay. Did you engage in any attempt to format them in a certain way?
Yes, I did.
And what did that involve?
So I took the spreadsheet that was returned by Google and I filtered the information based on the time and date so that it went in chronological order. And I was able to then identify the device of Alex Cox based on the information that was provided within their reports. And then I was able to take the device IDs that are further up in the pages of this search warrant and identify those in those records as well, commingled with all of the other records that were provided by Google.
So you recall the testimony of Officer Stubbs, is that correct?
Yes, I do.
And there was a representation regarding finding Alex Cox's ID among these searches as one of the pertinent phones located as part of this search warrant. Is that correct?
That's correct.
As part of this search warrant, did you recall any comments or do you recall any testimony as to whether or not there was any ID or information to suggest on 9/9 Chad Daybell's phone was also part of the location data?
I do not recall hearing that it was. What I recall from the testimony was the results of the Google search.
Objection, non-responsive.
Overruled.
Go ahead, officer. Or
The
officer,
results
I'll
of the
defer.
Google search showed that the only device that they were able to place with the association at the Chad Daybell residence was that of Alex Cox.
And that was at 9/9 of 2019?
That is correct.
So what we're saying is that on 9/9 of 2019, with all of this information from, and again, what was the starting time of this again?
On this
On
particular,
9/9, the earliest location information?
I
do you
believe it was 9/19.
recall? Okay.
It's at the top, but
And then this went well through 11:58 or 12 o'clock that day at the very bottom of the screen. Is that right?
yeah, well, this is not in chronological order. So I can't tell you the exact final time, but it was, yeah, sometime after 12 o'clock.
Third one from the bottom, it looks like I have a 12:10. Is that what that
Yes,
looks like?
I see that.
Okay. So if I understand your testimony, is that on 9/9 at approximately 9:19 through 12:10, there is no identification data showing that any device owned by Chad Daybell is on his property. Is that correct?
Yes, nothing in the evidence showed that.
Okay. And again, we talked a little bit about the ability to disengage that information and turn off your phone. That's possible, correct?
Yes,
He could have been there and he turned his phone off, right?
yes,
He could have been there and he turned his location off, correct?
yes,
He also could have taken the time to disengage each and every one of the apps to make sure there's no location data, correct?
yes.
Is this an easy task to do?
It's not easy to turn off all of it other than turning the device itself off.
Okay. 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 Did you have an occasion to do further review in terms of the scope of what you observed in terms of radius on this particular day?
Yes, I did.
And what did that involve?
So what I did was, as part of the filtering of the raw data that was returned by Google, not only did I put it in chronological order, but you'll see, if I can point, some of the radiuses that were returned or requested to be identified are showing 4,000 meters, 8,000 meters from the radius that was requested as part of the geofence. What I did instead of going that far out is I went and I filtered it down to 10 meters or less throughout this record and identified 19 devices from the Google record on 9/9 that would have been 10 meters or less in margin of error radius. And that's what the record showed, 19 total.
So 19 devices that appear to be within 10 meters or less of a range. Now we need to talk about the area that we're talking about. So when we're describing it, it would be like a box. Would that be correct?
So the way they did it was a single point of reference. They just provided a single latitude and longitude and asked for a 250 meter radius around that.
Okay. And when we're talking 250 meters, if my math is correct, that's 3 feet, approximately 3 feet per meter,
Approximately.
750 feet from a certain point.
Yes.
And where is that certain point on the Daybell property on September 9th? Do you recall?
I don't recall the exact point, but I believe it was in the backyard.
Okay. Okay. And you recall Officer Stubbs' testimony pointing to somewhere in the vicinity of a fire pit or a pet cemetery?
Yes, I do.
Okay. So when we're talking about 250 meters, we're talking about phones that could identify or be in the area within 750 feet on their initial search. Is that correct?
Yes, that's correct.
And then you took the liberty of narrowing that down. Is that correct?
Yes, I did.
And the process of narrowing that down, is that a complicated process or is it a matter of moving numbers?
Yes, so it's not complicated. They provide you the data in a spreadsheet format. And so you would turn on the filters and then select the column, and all of the numbers in this column here that show the radius would come up, and you would just deselect all and only select the ones that are less than 10 or less for the number. And then the spreadsheet would readjust and show you only those devices.
So when you're lowering the number, and explain that to me, I don't want to suggest anything to you, and I want to be educated on this. When you're lowering that number, you're drawing a location closer to that fire pit and that fire pit area. Would that be fair?
Yes, it's the margin of error. So that margin of error, the smaller the number, the closer to the radius it would be.
Okay, so when you narrowed the margin of error, and again, what did you narrow it down to?
10 meters or less,
And again, tell me what approximately in feet, what 10 meters is.
approximately 30 feet.
Okay, so approximately 30 feet from the fire pit,
Well, it'd be 30 feet from the radius,
30 feet from the radius. And we don't know, and what would the radius again be?
250 meters.
So 750 feet.
That's correct.
And then within 15 feet beyond that, that would be where the margin of error,
30 feet.
30 feet beyond, 10 meters,
Yes, that's correct.
30 feet, excuse me. That's why I didn't excel in math.
Good grief,
Or
Pryor.
computers. So from the radius, we then have a margin of
Way to
error
cause
of approximately
confusion.
30 feet beyond the 250-meter radius around Chad Daybell's fire pit. Is that right?
That's correct.
And then what did you find when you narrowed the radius down to include the 30 feet of margin of error?
19 unique devices during that time period.
Okay. And at that point, when you say 19 devices, do you know what the phone numbers of those devices are?
I do not.
Was there a further inquiry by Officer Stubbs regarding that?
Yes, there was.
And how many devices did he pursue of those 19 that were within the Daybell radius of his property?
So according to the testimony, he stated there were 12. The search warrant that is part of this record that you're seeing on the screen says 11. But then he says that he never got an answer from Google until he finally got a hold of someone from Google, and they made him shrink it. So he says they dropped off 2, making it 10 for the return.
Okay. And is that a common thing for Google to do?
So it is common for them to try and shrink your radius on the first search warrant of when they're providing these records, but I have not found it common for them to try to shrink the number of devices that you're asking for identification on that would be within your proximity.
So when Officer Stubbs did this warrant, your testimony is that there were 19 devices within that radius, correct?
Of 10 meters
Of
or
10
less.
meters. And then Officer Stubbs elected to pick 11 of those according to the warrant.
According to the warrant, it says 11, yes.
So he excluded 8 of those. Is that right?
No.
What did he do with the other 8?
Oh, you mean excluded from
From his
the actual data?
the actual data?
Yes, I don't know. They were not submitted. Those device IDs were not submitted for identification information.
Okay. So at this point, we don't know what the identification though, but Officer Stubbs identified that they were not of interest. You recall that?
Well, he stated that.
Objection, misstates testimony.
Overruled. Excuse me.
Go ahead.
What I remember of it is that he stated that we're not, based on the commonality, this is what they came to.
And when he's talking about the words commonality, what is he referring to?
The process that they chose to use to try to place the devices in multiple places that were associated with this return.
Okay, so in the multiple places, do you recall which of those multiple places were?
In this particular return, the data would have been the Chad Daybell residence and the Lori Vallow residence.
So in case there was some commonality in those 2 residences, the other 8 were excluded on that basis. Is that what you're saying?
I don't know why he chose to exclude them. I just know that they were not submitted as part of this warrant to Google.
So if an odd number of the device that wasn't at Lori Vallow's residence or whoever ticked off at Lori Vallow's residence, ticked isn't the right word, clicked or identified there, and it was just an odd vehicle that showed up at Chad Daybell's driveway, that would not have commonality. Would that be fair?
I don't know their method that they chose to do the commonality.
Okay. Would this be standard practice to do that?
Objection calls for speculation. He doesn't even know the reasoning behind what they did.
It's sustained.
Would in your practice of evaluating evidence, would that be a practice that you would engage in?
No, it's not.
Why would that be?
I would have asked for the identifying information for all of them in order to identify the individuals that would have been within that proximity
And why would you do that?
as part of investigating the crime.
To determine exactly who was there?
Well, to determine who the information belonged to and what they may know, yes.
Okay, so it's part of expanding the scope of what you're trying to learn about the case. Would that be fair?
That's correct.
So in other words, by ultimately excluding one phone just because it didn't happen to identify at Lori Vallow's residence, but it identified at Chad Daybell's residence, it still could be relevant to this investigation and provide information.
Objection leading.
Sustained.
Would the lack of contact with one of the common residences potentially still be useful?
It could be.
Okay. Now I want to go above the data that you have, and then if you get the pointer out again, if you would help me.
Sure.
At the very top number, I can't read the ID number under the blue, the very top one. You don't need to read it, but that's the first entry that you were provided. Is that correct?
That is not the first entry in the records.
Okay. Oh, the earliest entry would be what?
I would have to look at the record to remember, but it was before 9/19.
Okay. Would it have been helpful to have records earlier in the day for any purpose?
Yes.
And what would the purpose of having requested earlier records than at sometime at around 9 for purposes of evaluation?
You could also identify devices that would have been there prior to that time.
So if for instance, if Mr. Daybell's device was there prior to 9 o'clock or was identified prior to 9 o'clock, that would have been one of the devices that you would have been able to locate or at least identify?
You would have the device ID and you'd have the ability to submit it to find out subscriber information. Yes.
And to your knowledge, that wasn't done?
Not to my knowledge.
Okay. And to your knowledge, again, there was no, based on the testimony of Agent Balance and Officer Stubbs, there was no identifying information that put Chad Daybell on the property at 9/9/2019. Is that correct?
That is correct.
I'd like to move down to, if we can. I may have the wrong, and Judge, could I just have a moment, please? And
Yes.
just turn the HDMI off? And the light on, maybe? Can I just have a moment, Judge? I'm having some issues.
You're having issues, all right, Prior.
Can't get this out of the way, and I can't get this other one out. All right, thank you. This is a numbers file, so it's kind of like Excel.
Prior.
Can I see what that is? I've done a bunch of times. It's got all that. I just need to be. But I'm ready. Sorry.
That's fine.
I apologize for the delay. Now we're looking at the date of 9/23. Is that correct?
Yes, that's correct.
And again, if you have the pointer, I can narrow this down again, hopefully. And again, if we can go through the analysis, we have the device ID, and if you would use the pointer and do that for me, if you're able to.
It's right there, that column.
Okay, and then the date would be again what?
9/23/2019.
And then we have the next would be the longitude, latitude,
The next would be the time.
the time, I'm sorry. And then the longitude or the latitude and then the longitude.
That's correct.
And then the last one would be the radius.
You have the source, which is GPS or Wi-Fi, and then you have the radius.
Okay,
And then the last column is a column that I added.
okay. So what's the relevance of 923 in terms of this investigation? Do you recall?
The relevance?
Would that have been the day that the remains of JJ Vallow were found on Chad Daybell's property?
Yes, that's correct.
Objection misstates evidence. That wasn't the day that JJ Vallow was found there.
Yeah, sustain and strike that question.
In any event, the significance of the 923, did you again listen to the testimony of Dave Stubbs and Agent Balance?
Yes, I did.
And this chart represents what?
This chart represents the information that was returned by Google for the geofence warrant based on a location at the Daybell residence for 923 during that time period.
Okay. And again, what did you find of significance in this information?
So this is the non-filtered radius version, but in this information here, as with the color coded, the yellow information, and this is also not time sorted either. But what I did is it was time sorted to chronological order, thereby showing the exact process by which those IDs would have been near that radius.
Okay. And the source of that information on your yellow, it says something about Homer at the very right-hand side.
Yes, Homer J. Maximus,
And then in parentheses, you have a name.
Alex Cox.
Okay. And would it suggest then that the yellow highlighted is the source information of Alex Cox's phone on the Daybell property on 9/23/19?
That's the information that's associated with that Gmail. Yes.
And then in the green, what does that indicate?
The green indicates that is information, device IDs that were submitted to have requesting information, subscriber information provided back as a return based on this information.
Okay. And again, did you do your analysis in terms of trying to determine whether this is a complete list of all of the phones that had contact at that time?
Yes, I did.
And what did you find?
So this chart should be the complete list.
Okay.
The charts that I placed and provided was the complete chart.
Okay. And what does that mean?
That it has all of the records that would have been provided by Google at that time.
Okay. And as a review of this, was there any further follow-up as to identify these ID numbers to your recollection?
Only the ones in green and also the one in yellow.
Were there other phone records that, for whatever reason, were not
Thank
included
you,
in
Mickey
the
Jor.
search
I'm
for,
super
identification
excited.
of those ID numbers on that
Thank you,
chart?
thank you, thank
No,
y'all.
not phone numbers, but device
Phone
IDs.
devices,
Device IDs.
device IDs.
Yes.
And how many of them were there?
On 923, I would have to look. If this is the entire chart that I provided, you would look at the white boxes for the unique numbers. You would have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
So there were to be 10 other devices that were not included for information to obtain. Would that be fair?
That's correct.
But there were how many, if you could count for me in the green, that they decided to do for further inquiry?
On this particular day, based on what I'm seeing on the screen, there were 1, 2, 3, 4, 5, 6.
So if I understand correctly, there were 16 devices that indicated phone location data at or near the Daybell property on the 23rd of September. Is that correct?
Adding in yes, that's correct.
That would include Alex
Thank you
Cox's
too,
phone data at that
Kayleen.
point, correct?
That's correct.
Yay.
Did
Thank
at any
you.
point you take the task of narrowing the radius to try to what I'm not sure what the proper word is, narrowing the radius to maybe exclude others that were not as close?
Yes, and I correct that. Including Alex Cox, it would be 17.
Okay. So again, did you narrow the radius to maybe refine your results?
I did.
What did you find then?
So as you would see within this chart, if you were to remove the numbers that are more than 10, you would see 1, 2, 3, 4, 5, 6, 7. Oh, excuse me. 1, 2, 3, 4.
Okay, so there'd be 4 devices that once you excluded, and again, the radius that you used to exclude would have been what?
10 meters.
So again, 30 feet from the location point, is that correct?
That's correct.
Okay. And of those 4, how many of those within the 10 meters were sent for further identification?
None to my knowledge.
So when you have 4 phones that are within the 30 feet of the area set by Officer Stubbs, of those 4, they chose not to try to identify those phones. Is that what you're saying?
Objection, that misstates Stubbs' testimony.
Sustained.
Was there any indication that they pursued the identification of the 4 phones within the 10-meter radius that you just identified?
No.
Is there any indication through the testimony of Officer Stubbs or Belance that any phone device of Chad Daybell was located on that property on 9/23 within the time range you set forth here?
Nothing in the evidence I was provided or reviewed.
I'd like to, and Judge, I think I'm done with the HDMI, if that's okay.
Okay, we'll unpublish.
And I do need the Elmo on, Judge. You prepared a report in contemplation of testimony in this case, is that correct?
Yes, I did.
And that was previously marked and accepted as Exhibit 137. Judge, I took the liberty of providing the state with a paper copy. I'd ask permission that I think the state can acknowledge that the paper copy is directly identical to the 137 exhibit that I've submitted and has been accepted by the court.
All right, counsel, I need a sidebar before we get into publishing on that report, please.
Sidebar City. Everybody taking a quick little stand-up break. Stretch it out, stretch it out, stretch it way out. No worries, Kayleen. I love when people work and lurk. Love it, love it, love it. Thank you for coming. Thank you for being here. Yes, you guys, don't forget. Leave your fingerprint on the like key button, on the thumbs up button. We appreciate it. Super duper appreciate it. Super duper. See if I can zoom it past this little sidebar city here. Zoom, 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 and a zoom, zoom. Okay.
All
And
right, the court had a sidebar and we discussed Exhibit 137. There are some redactions already in that exhibit. However, there's going to need to be some additional redactions. And so in order to accomplish that before publishing, at this point, we are going to take a recess to allow for redactions on the exhibit. And then once we get those done and redacted, you can continue with your direct and publish the exhibit. It has been admitted, but we'll make those corrections before they're published to the jurors. So we'll take a morning recess at this time in order to accomplish that, and we'll come back on. We'll just let the jurors in the gallery know when we'll be ready to continue.
all right, so they're going to take their little quick break, and we are going to fast forward through, and they're back already. See how quick that is? It moves so quick when we're able to speed watch. I love that so much.
We'll have them directed into the courtroom.
All right, here we
All right,
go.
thank you. We've got our jurors lined up, so please remain standing. We'll have them directed into the courtroom, please.
All right.
What are your thoughts on the whole cell phone pinging situation here?
Thank you. Please be seated.
Can't wait to see who crosses this dude.
Okay, we're back on the record on CR 22-21-1623, State of Idaho versus Chad Guy Daybell, continuing with direct examination of Mr. Eller. The exhibits been taken care of on 137 and admitted. So, Mr. Pryor, if you'd like to continue with your direct, you may.
And Judge, could I have use of the Elmo? May I?
Yes.
And before we start with that, I just want to recap a little bit. You had mentioned that from your review of the devices and the data that was provided, that Chad Daybell's, there was no indication of a phone associated with Chad Daybell was indicated on September 23rd, 2019 and September 9th, 2019 on the Chad Daybell property. Is that correct?
That's correct. No device ID.
Did you happen to look as part of the, and I guess we'll start with this, there was a significant amount of data that was provided to you, is that correct?
Yes, there was.
And in one instance, there was a sizable amount of data, terabytes on one particular indication, right?
Yes, I believe it was approximately 10 terabytes.
And 10 terabytes would fill a room about what size? Paper to paper.
The way that, we've typically described that is if you were to take the Library of Congress, if it was all printed, just 1 terabyte would fill it.
Okay. So 10 times the Library of Congress is what you were reviewing. Okay. As part of your review, did you look at the status of any of the devices of Mr. Daybell in relation to the time of September 9th and September 23rd?
Yes, I looked at the return data for the chad.daybell@gmail.com, the information pertaining to that email account.
Would you be able through that email account to determine whether or not Mr. Daybell's account was enabled or not enabled?
I can say yes.
And when you say yes, does that mean that the account was enabled?
So the account itself was enabled and it lists the services that would have been part of that account.
Okay, and when we use the term that it's enabled, what does that mean?
That means it's active.
Does that mean it's receptive to gathering information?
Yes.
Okay. I'd like to switch gears a little bit and go to the report that you prepared as part of your help in this case with me. Do you recall that report?
Yes, I do.
Judge, if I could have the Elmo again, I'm sorry.
You may.
Now we're looking at information as it relates to, I'll refer first to September 6th of 2019. Do you see that?
Yes.
And what does this information represent?
It represents information that was returned by Google for the homermaximus@gmail.com location data.
And whose phone would be assigned to the Homer J. Maximus at gmail.com?
Alex Cox.
So I start with September 6th of 2019, and it looks like it says 124254 on September 6th. And what does that information suggest?
That information suggests that there was a location point located in the records for a device associated with that account to be at or near the Chad Daybell residence at that time.
Now at 1242, it says Chad Daybell residence with that longitude and latitude.
That's correct.
Would that suggest that that device was on the Chad Daybell residence on September 6th at that time?
Yes, it would suggest it was there on the property.
And then again at 1244?
Yes, that's correct.
And then again at 1251?
Yes, that's correct.
Then at 1253?
That's correct.
Now, is there any way to determine between those times whether or not at any time between the minutes between those that that device left the residence?
No.
Okay. And then at 1255, the device associated with Alex Cox placed him on the residence or south of the residence?
That's correct.
And you put it something called Salem Pines Lane, is that right?
Yes.
Okay. Any information that, do you have any information to suggest that Chad Daybell was at that location on September 6th?
I do not.
Okay. We'll go to September 9th. And on September 9th, are we still talking about the device associated with Alex Cox?
Yes, that's correct.
And at that point, we have a 9:15:43. It looks like it says south of Chad Daybell residence. You see
Yes,
that?
that's correct.
And then at 9:21:36, Chad Daybell residence, correct?
Yes,
Now, I want to go back to the geofence. And when you talked about the geofence and the identifiers, the indication is this 921 is consistent with what Officer Stubbs had indicated. And Officer Balance indicated about the locator ID on the Daybell property. Is that correct?
that is
I'm going
correct.
to object to that question. Nick, Balance did not testify about the geofence.
Sustained.
Officer Stubbs testify about the geofence?
Yes, that's correct.
And then again, we show the device at 9:22:50 again, indicating the device is at the Chad Daybell residence.
That's correct.
And then at 9:26, there's a indication that the device is at the residence.
That's correct.
And then there's a gap between 9:26 and 10:39. Between 9:26 and 10:39, is there any indication that the device would still be at the Chad Daybell residence?
There's no data to show that it was there, but there's also no data to show it was not.
So it's undetermined as to whether or not the device was there or not.
That's correct.
Would it be unusual for there not to be some sort of a ping or indication that the device was there?
It depends on what's being used on the device or if the
Okay.
device is powered on.
Okay. And then we go to 10:41. So between 9:21 and 10:39, well, from 9:21 to 9:26, for that 5 minutes, we know the device was at or near the Chad Daybell residence, correct?
Can you repeat that question?
Between 9:21 and 9:26, we know that the device was at or near the Daybell residence. Is that correct?
Yes, there were 3 location points that showed that.
Okay. And then from 9:26 to 10:39, we can't say one way or the other where the device associated with Alex Cox was in terms of that property. Is that correct?
That's correct, not from this data.
Okay. And from 9:39 to 10:41, at that point, the device at 10:41 appears to be in the vicinity of the Daybell residence.
That's correct.
Do you recall what vicinity it was in?
I believe it was without seeing the map that associated with this, but I believe it was near the front of it.
Okay. And then at 10:43 again,
Yes, that's correct.
and then at 10:57, we're back at the residence. Is that right?
That's correct.
And then from 10:57 to 11:39, you have some movement. Is that correct?
Yes,
So at 10:57, there's some movement. And then 11:39, you have it in the vicinity. Is that correct?
that's correct.
And then moving on, you have it north of the residence. Is that right?
That's correct.
Now, I went back with you with the, in terms of Alex Cox's device showing that he's at least partially between 9:21 and 10:57. He was on the property and potentially off the property during that time, correct?
Could be.
Okay. And are you aware of any communications between, any communications in terms of text messages or emails that were sent from the Chad Daybell device?
Yes,
And would those emails or text messages that were sent, would those have indicated a identification number and a location through Google by the use of that device?
they could have.
And at no point did they indicate that by the sending of a text message through the Chad Daybell device, that he was in the vicinity of the Chad Daybell property. Is that correct?
No records that I was provided showed that.
And again, September at 2:30, we have west of the Chad Daybell residence. Is that correct?
That's correct.
And then south of the Chad Daybell residence?
That's correct.
If you don't have a specific recollection, but if you do have a recollection, you know how far he was from the residence?
I don't remember.
Okay. And again, we discussed this through your geofence testimony about the device of the Alex Cox device indicating that the device was on the Chad Daybell residence on September 23rd, correct?
That's correct.
And on September 23rd, you also testified that there is no geofence evidence or indication through Google or any electronic evidence suggesting that on the 23rd of September, Chad Daybell's device was there as well, correct?
No evidence I reviewed could place him at the residence.
Okay. And again, we place him at the residence from 10:55 to approximately 10:12. Is that correct?
That would be 9:55.
I'm sorry, I said 10. Not, thank you for correcting me. 9:55 to 10:12. Is that correct?
That is correct. Multiple time points in that time period.
We then go to the September 25, 2019. Do you see that?
Yes,
And again, we have the indication of Alex Cox's device on the Chad Daybell residence.
that's correct.
And that would have been from 10:05 on the 25th of September. Is that right?
That is correct.
To 10:24 on the 25th of September. Is that correct?
That's correct.
And again, we're referring to October 9 of 2019. And that would have been the date of the alleged paintball incident. The time that we have for Alex Cox, we didn't place him at any time on October 9th on the Daybell property. Is that correct?
The records did not.
But the records did show that he was south of the residence at 450, correct?
Yes, it did.
And then south again for someplace at 501 at a place called Salem Pines Lane.
That is correct.
So we have him there for 11 minutes south and east of the Daybell property, correct?
That is correct.
What is the radius for all of these?
I would have to look at it, but I believe it's 1.4 miles.
Okay. So 1.4 miles from the Daybell residence, that would be the marker for what you use to establish contact or lack of contact.
That's the radius we used around the Daybell residence to associate to whether there was a time point that would be associated with this data.
Now, previously you saw from I believe it was Officer Stubbs, they used a 2.6 or 3 mile radius for theirs in terms of the location data for Mr. Daybell. Is that,
Objection misstates the evidence.
Sustained.
do you recall what the radius that was used by Officer Stubbs in his report?
250 meters.
250 meters. And the significance of going out to a larger radius would have been what?
It would just capture more location points of the device.
Does it affect the accuracy by just expanding the radius of how far you go out to determine this?
No,
So there's nothing in terms of accuracy that changes as a result of just going further out to try to gain more location points for, at least for Alex Cox's phone. Is that correct?
that's correct. The accuracy would be a separate reading. This was just putting points within a specific radius.
Okay. And then we didn't include this on the report, but you also reviewed information as it related to October 19th in regards to the device of Alex Cox. Is that correct?
That's correct.
And what were your findings in regards to October 19th?
There was no indication that it was at or near the property based on our findings, which is why it's not in our report.
Okay. And then when you say that there was no indication that the Alex Cox device was there on the 19th, that is within a 1.5 mile radius of his property?
1.4.
1.4 mile radius of his property?
That's correct.
I want to talk to you a little bit about the concept of drive testing.
Okay.
You heard some testimony previously about the drive testing that was conducted as part of this case. Do you recall that?
Yes,
And in your review, did you come to some determinations as to what your understanding of what they did in terms of the drive testing?
yes, I did.
What indications did you arrive at?
So the drive testing that was completed showed the coverage area for multiple towers surrounding that area. What that does is it shows you the coverage area that could be used by a device. It does not show you RF signal strength or signal strength from a device, but also what the coverage area does is from a drive test just allows you to see where you would be able to potentially reach a tower if you were to utilize your device across the cellular network.
Okay. So in other words, when you're talking about towers, if there's a certain angle, and let's say it's a 120-degree angle,
Yes,
that angle goes out for an extended period of time.
it does.
And wherever there may be overlap or otherwise, the distance that goes out determines a significantly large area for cell tower testing, right?
That is correct. And the difference in listening to the testimony about the drive test was when it was discussed about,
Objection, this is non-responsive to a question.
Sustained.
So based on the testimony that you heard about the drive testing, what were your concerns?
my concerns were the 5 degrees beam width difference that was reported between 2019 and 2020.
Okay. And when you say 5 degrees difference, what would that affect?
Well, it wasn't explained which way it was 5 degrees. So when you look at that sector, it's 60 degrees counterclockwise and 60 degrees clockwise. And without knowing the 5 degrees that it was off, it could change dramatically that coverage area, depending on how far away a device would have been from the tower when it was made from that sector.
So for the use of drive testing, would that be, and given what you just given what you just stated, would that cause a concern about the reliability of drive testing?
It wouldn't cause a concern for reliability about drive testing itself. I would just wonder if the 5 degrees was taken into account for the mapping of the drive testing
Okay.
for presentation purposes.
Is drive testing considered a scientific test?
Drive testing is used by the mobile network carriers and providers to test tower coverage for signals.
It's not to be used to determine the location of a device to any extent of accuracy. Would that be fair?
The drive test itself can't locate the device. It only shows tower coverage.
Okay. There was some discussion about something called gladiator forensics. You recall that?
Yes.
And you recall that I believe it was Agent Balance talked about the availability of gladiator forensics to the public to test devices.
Yes, that's correct.
Did you look into the availability of gladiator forensics for someone like your corporation or the public?
I did.
And what did you find?
They responded to me that it is law enforcement and government only.
So is there any way to challenge the reliability of gladiator forensics or their testing without a law enforcement license to do so?
Not with their tool.
Okay, so in other words, when some of the testimony regarding data, regarding phone coverage, regarding all of those things, you wouldn't, given that they use the tool of gladiator forensics, you would not be able to challenge, and we would have to rely on solely what they claim to be the information. Would that be correct?
You can take that data and map it utilizing other tools, but that doesn't mean that the algorithms that their tool is using will be the same. So the results may or may not show based on what is being set up inside the tool by the manufacturer for the parsing of that data. So not testing it with the same tool does not necessarily give you a reliable accuracy based on the tool they used.
Okay. So if there was a representation that gladiator forensics could be purchased by anyone for use, would that have been an inaccurate statement?
Objection, misstates the testimony. That was never said.
Sustained.
Do you recall Officer Blends talking about the availability of gladiator forensics?
I do.
And what do you recall him saying?
He said that their tools are not, but the tools that you use to do drive testing, meaning the antennas, the signals, and they talk about it, being calibrated by Rhodes and Schwartz for the drive test tools, which I also reached out through Rhodes and Schwartz and through their distributors and was told that I could not purchase those either.
So we have to rely on law enforcement's representations as to the total accuracy of anything they're suggesting. Would that be fair?
Yes.
Can I utilize the Elmo again?
Yes.
Thank you, Your Honor. There was some reference here to based on records that you obtained about communications. Do you recall who these communications were?
You're talking on the screen, September 1st, October 31st?
Yes.
Like through those dates?
Yes.
Yes.
Did you detail the communications that took place when Alex Cox was identified to be at the vicinity or in the vicinity of the Daybell residence?
I did.
Okay. And you identified those by date, is that correct?
Yes, that's correct.
So on September 9th, there's one voice call. Is that correct?
That is correct.
On September 22nd, there were 8 text messages, 1 voice call.
That is correct.
On September 23rd, there was 1 voice call.
That is correct.
And October 9th, there's 13 text messages, 0 voice calls.
That is correct.
You didn't identify, those could potentially be to a number of different people. Would that be fair? They aren't necessarily Alex Cox calling the same person, right?
They are not.
Okay. And that was based on the data that you had at the time, is that correct?
That is correct.
And Judge, at this time, I have no further questions.
All right, thank you, Mr. Pryor. All right, Mr. Wood, cross-examination.
If I can be handed Fence Exhibit 139.
Yes.
And Your Honor, because of the digital nature of that, it may take me a minute to set up.
Okay.
And if I could also be handed States Exhibit 156 and 229 and 186.
All right, we'll work on getting those located and getting them delivered to you, Mr. Wood.
Thank you. And if it's all right, I'm going to wait to start until I have the exhibit so I can do it in a succinct fashion.
That's fine. We'll go ahead and get things located and wait.
They were on a break. Looks like they're trying to get things together, right? Rob Wood is going to try to get his stuff together. It cracks me up though, because you have the 2 prosecutors there, Rob Wood and Rocky Wixom, and then you've got the dude on the stand right now who has bald hair and a beard and mustache and glasses, and they just look like triplets. They look like triplets. I love it. I love it. I love it. I know that they don't look anything alike in person, like up close, but from a distance and with a fuzzy, janky court camera,
Good morning, Mr. Eller.
Morning, sir.
they look
Am I
the
pronouncing
same.
that correctly?
Yes, sir.
You don't need to call me sir.
Just habit.
I get it.
Look at Chad
I
smile.
want to talk to you about September 9th,
See
2019 and the
Chad
work you did
smile
in
whenever
this
he
case
said
for
that.
for that
Watch.
date. Are you aware of the significance of the date of September 9th, 2019?
Yes.
Hold on.
Are you aware through your investigation of the last known
Let me rewind this. And whenever he says that about you don't have to call me sir or whatever, watch Chad smile. It's gross.
2019 for that date? I want to talk to you about, you don't need to call me sir. Mr. Eller,
Morning, sir.
am I
Now
pronouncing
watch.
that correctly?
Yes, sir.
Watch Chad.
You don't need to call me sir.
Just habit.
I get it.
Ugh, gross.
I want to talk to you about September 9th, 2019 and the work you did in this case for that date. Are you aware of the significance of the date of September 9th, 2018?
Yes.
Are you aware through your investigation of the last known sighting of Tylee Ryan?
I am.
And that was September 8th, 2019, correct?
That's correct.
In preparation for your testimony, you created, we just went over a written report you did. You created visual representations of the data you mapped, correct?
That's correct.
And Your Honor, may I publish?
Yes, which exhibit?
This would be State's Exhibit 139. And in fact, maybe we need to have a sidebar about the labeling of this because there's subparts on this exhibit. There's 14 subparts.
Previously admitted.
Yes, of 139 Defense Exhibit.
Okay, feel free to just continue, Mr. Wood. If we have questions, we can do
Okay.
a sidebar, but
Perfect.
if you can, for the clarity of the record, reference any sub-exhibits.
And I would list this as Defense Exhibit 139 Sub 3. And Mr. Eller, does this look familiar to you?
Yes, it does.
This is the report you created, correct?
This is a slideshow that represents data from the report, yes.
Thank you. That's the more accurate way to say it. What does this slide represent?
As far as,
What's the data being portrayed on that slide?
it's just showing locations.
And are these locations related to the Homer J. Maximus Google account?
Yes,
And I've clicked on, is this video, there's a video embedded in this.
That's correct.
Can you tell the jury what this video shows?
yes. The video would show the time frame represented and the points on when they would show on the map during that time frame.
All right. And this slide, what time frame does this cover?
I would have to see the slider for the video.
If I start playing it, would that aid you?
Yes,
I'm gonna play it.
that entry said 0915.
Okay. And is there indeed a label up here that says this is at Chad Daybell's residence?
That's correct.
I want to go back to earlier in the day. What does this video show? In fact, is it labeled?
It says video of all Google location data for September 9th.
So if we were to play this video, it would show all of the Homer J. Maximus location hits that you mapped out
For that date.
for that date. Correct, for September 9th. And
Yes.
did you put any limiting margin of error on these?
Yes,
Okay, and was that the 500 meters?
that's correct.
Thank you. So I'm going to start playing this video and I'm going to move it to about 2 minutes and 42 seconds. I'm going to start at 2:38. Can you make out what that data point is?
It is a Wi-Fi data point
Okay, and where is it located?
in the vicinity of Lori Vallow and Alex Cox's residence, I believe.
All right, and can you pinpoint at which residence it is at?
No. Not based on the visual representation on the screen.
Let me ask you this. Did you locate any data suggesting that the Homer J. Maximus account on the morning of September 9th, early morning of September 9th, went to apartment 175?
Did I map that out? No. I don't believe so.
Are you aware that a device associated with Homer J. Maximus was at 107, apartment 107, Alex's apartment, in the early morning of September 9th?
Correct.
And then in the early morning hours went to apartment 175?
That's correct. Yes.
And it was that, do you know approximately how long it was there?
Not without looking at the records.
Okay.
It was several hours, I believe.
Thank you. So he was there for some time in the early morning hours.
That's correct.
I want to talk about a little bit later in that day. You did some work detailing, Your Honor, if I could unpublish for a moment.
Yes.
phone calls that were made between Chad Daybell and Alex Cox, or numbers known to be associated with Chad Daybell and Alex Cox, correct?
That's correct.
Your Honor, if I could republish.
Yes.
This chart, this shows a calling number, or this shows a phone call at 8:11 a.m., correct?
Yes, it does.
And the calling number is 208-690-9374, correct?
Yes, that's correct.
And that is a number associated with Chad Daybell, correct?
Yes, that's correct.
And he calls 480-351-9120.
That's correct.
And that is a number associated with Alex Cox in the Homer J. Maximus account, correct?
That is correct.
And again, so that's at 8:11. Do you recall what time Alex Cox first shows up on Chad Daybell's property on September 9th?
I believe it is approximately 9:21.
So if we watched this video, you prepared it would tell us, correct?
I believe so.
And I'm going to pause when it first shows. So this data point that appears just south of Chad Daybell's residence.
That's correct.
And what is the time on that?
9:15.
All right. And what time was the phone call made from Chad to Alex?
I believe 8:11.
Yes, correct. Thank you. I'm going to play it again. And so what time
9:21.
does this show that Alex Cox's phone shows up on Chad Daybell's property?
9:21.
And this was also reflected in the cast report, correct, that you reviewed?
That's correct.
So just really quick, as we do this, the cast report used some different parameters than you did, correct?
That's correct.
So they used a 100-meter margin of error, and you used a 500-meter margin of error.
That's correct. There was 100 for that, 150, 250, 500 across all the different reports.
Right. And I'm just speaking about the cast.
Yes, that's correct.
And for different purposes, you might use a different margin of error, correct?
That's correct.
And at different points in an investigation, you might rely on different margins of error depending on what you're trying to do, correct?
Yes.
And so there's nothing invalid about using a 100-meter margin of error or a 500-meter margin of error, correct?
No, there's nothing invalid about either.
And Your Honor, I am going to now go to State's Exhibit 156, the cast report. And you reviewed this cast report, correct?
Could you clarify the exhibit number, Mr. Wood?
156.
156, thank you.
It's not sure. You reviewed this cast report, correct, as part of your investigation?
Yes, once I received it.
So, and you recognize this slide?
Yes, I do.
And this slide shows in general some of the same data we were just looking at on the slide you presented.
That's correct.
And so just again, on September 9th, what you've established and what's also in the cast report is that Chad Daybell made a phone call to Alex Cox at 11 a.m.
At 8:11.
Thank you, at
AM.
8:11 a.m. And then just a little more than an hour later, Alex Cox, or a phone associated with him or a device associated with him, shows up at Chad Daybell's property.
That's correct.
Are you familiar with the burial location of Tylee Ryan?
Based on the testimony and the evidence I reviewed, yes.
And in fact, did you map that out as well, correct?
That's correct.
And you would agree that some of these location points for the Homer J. Maximus account are in close proximity to both the burn pit on Chad Daybell's property and Tylee Ryan, and the final location spot for Tylee Ryan.
Yes.
As part of your investigation, you said you reviewed many devices
Devices and records, yes.
and records. Okay. In fact, real quick, I want to ask you about that. In your report, actually, I guess it's. Can you tell us approximately which devices you reviewed?
Oh,
Is it too large of a number?
it's a large list. I mean, it was almost 10 terabytes of data that was turned over.
Yeah,
And
massive undertaking, correct?
yes, absolutely.
And it's difficult for any one person to get through all of that material, correct?
I spent a lot of late nights over Christmas going through data that was turned over. Yes.
Did you review a cell phone belonging to Tammy Daybell?
I don't remember at this time.
That's fine. You talked about not having any information, any geolocation data from Chad Daybell that placed him on the property, correct?
That's correct.
Are you aware that he sent a text to his wife that placed him on the property?
Yes, but that doesn't place him on the property.
Are you aware that in his text, he talks about burning limbs in a fire pit?
Yes.
And are you aware that he talks about shooting a raccoon
Yes.
and that he talks about burying it in a pet cemetery?
Yes.
And are you aware that there was a pet cemetery on his property?
Yes.
And are you aware that that pet cemetery is the same location that Tylee Ryan was located?
Yes.
And are you aware, Mr. Eller, that upon finding that text message from Chad Daybell to his wife and combining that data with the data that you see right now and data that you've mapped as well, was how law enforcement
Judge,
found?
objection, speculation, and argumentative.
I'm asking if he's aware.
Mr. Wood, first, let me make a ruling, and before you make a response, please. So the objection is overruled.
Okay, I'll ask the question again. Mr. Eller, are you aware that upon finding that email, or I'm sorry, that text from Chad Daybell to Tammy Daybell sent on September 9th, and looking at that data with the data that's placed on the screen right now, similar to data you've mapped, was how law enforcement found Tylee Ryan?
No.
Would it surprise you that that information was how law enforcement?
Judge,
found
I'm
Tylee
going to
Ryan?
object at this point. Calls for speculation.
Sustained.
Let's talk about September 23rd. And Your Honor, if I could unpublish for a minute.
You may.
And I apologize for the pauses. There's just a lot of digital data to be working with.
Understand.
I'm going to start with what would be marked as Defense Exhibit 139, Subpart 13. And if I could publish at this point.
You may.
Mr. Eller, do you recognize this chart?
Yes.
And at the bottom of that chart, there's a call record that's been, there's some details provided for.
Yes.
Who is the calling number? Or I'm sorry, let me rephrase that. What is the calling number?
The calling number is 208-690-9374.
And is it correct that that number is associated with Chad Daybell?
Yes, that's correct.
And who is the call, or what is the called number?
480-351-9120.
And is it correct that that number is associated with Alex Cox?
Yes, that's correct.
And what time was that call?
0925.
And going back to your report on September 23rd, the information you were provided placed the Homer J. Maximus or a device associated with Homer J. Maximus on Chad Daybell's property that morning, correct?
Yes, that's correct.
And it first showed up at 9:55 in the morning, correct?
I believe so.
So we have a situation here similar to.
Objection, argumentative.
Sustained.
Okay. So there's a phone call made from Chad Daybell to Alex Cox at 9:25.
Yes,
Or numbers associated with them.
that's correct.
At 9:55, Alex Cox or a phone number or a device associated with them shows up on Chad Daybell's property.
That's correct.
Are you aware of the significance of September 23rd, 2019?
Yes,
What is that?
that is the day after the last sighting, I believe, of JJ.
Your Honor, if I could unpublish for a moment,
You may.
and I will be publishing from Defense Exhibit 139, Subpart 5. And Your Honor, if I could publish.
You may.
Mr. Eller, do you recognize this slide?
Yes, I do.
Could you read the label of it?
Video of Google location data at Chad Daybell's residence on September 23rd, 2019.
And you prepared this video by mapping
Yes, that's correct.
of Homer J. Maximus, correct?
That's correct.
So I'm going to push play. And can you describe where I just paused, what the data being presented is?
Yes, that is a Wi-Fi location point with an accuracy of 50 meters on 923 at 0955.
And I'm going to push play again. And can you describe the data being represented here?
Yes, that is a GPS location point on 923 at 956 with an accuracy of 4 meters.
And would you agree that that location is close to the final or the spot where JJ Vallow's body was found?
Yes,
In fact, could you point with your marker? I believe you have it marked on that screen. Could you point to the location of JJ's body? Okay, thank you. I'm pushing play again and stopping. And what's the data here?
that is a location point from a Wi-Fi source with a 100-meter accuracy on 923 at 957.
And so at this point, is it fair to say that that device could have been located anywhere within that circle?
Yes,
I'm pushing play again. What is the data being represented here?
that is a location point that's GPS on 923 at 1002 with 3-meter accuracy.
Thank you. And I'm pushing play again. And is this another spot you mapped? We don't need to list out all the details, but this was another
Yes.
spot you mapped. And this was at 10:05, correct?
That's correct.
Thank you. I'm pushing play again. This was a spot at 10:07 that you mapped.
That's correct.
It appears to be on the southwest corner of the property,
Yes.
but that's a 92-meter
Radius.
radius.
Yes.
Thank you. Again, one more spot that you mapped at 10:12.
That is correct.
So you would agree with me that the Homer J. Maximus account that you mapped on September 9th shows spots close to the location of Tylee Ryan's body where it was located, correct?
You said September 9th? Yes.
Yeah, I'm going back to September 9th. I'm not trying to confuse you.
Okay.
Going back to September 9th.
Yes.
And on September 23rd, the Homer J. Maximus account is located, shows at least 2 points very close to the location of where JJ's body was located.
Yes.
And on both those days, within close to an hour of when the Homer J. Maximus account shows up on Chad Daybell's residence, Chad Daybell called Alex Cox.
That's correct.
And let me be correct. Let me be specific. A phone number associated with Chad Daybell called a phone number associated with Alex Cox.
That's correct.
And just to be clear, you also, for this date, you also as well mapped out the whole day of geolocation data, correct?
Yes, that's correct.
And I'm not going to play it right now, but so that you could actually watch Chad Daybell's movements throughout the day.
Objection, Judge.
Overruled.
Judge, mischaracterization.
The question's not done yet, so at this stage, I'm overruling an objection. Go ahead, Mr. Wood.
Let me rephrase that. Either way, you can watch on these videos you prepared the location. I'm not going to say in real time because it's in shortened time, but of the location data of the Homer J. Maximus account.
That's correct.
And we talked about methodologies earlier, how sometimes in a different investigation, you might use one methodology, you might use something else for another investigation. And there's valid reasons to be using different methodologies, correct?
Yes.
And in this case, to determine when you would map out the Homer J. Maximus account as it relates to Chad Daybell's property, you drew a 1.4-mile circle around Chad Daybell's property.
That's correct.
And anytime the Homer J. Maximus account showed up in there, you would make note of that if it, well, let me rephrase that. And I think you know what I'm trying to say, right? Once the Homer J. Maximus account showed up in there, if it had less than a 500-meter margin of error, you mapped it.
Yes, that's correct.
Mr. Defense Counsel spoke with you briefly about October 9th.
Yes.
And I would know in your report, and it's in there, that you disagree with the FBI about the number of text messages that were exchanged between Alex and Chad.
That's correct.
Even based on what you found.
That's correct.
Yeah, and based on what you found, you show that 13 text messages were exchanged between Chad Daybell and Alex Cox on October 9th.
That's correct.
And you're aware that that same day, Tammy Daybell reported being shot at by a paintball gun.
I didn't know that it was shot at. That's not what my understanding of it is.
Okay. But you're aware there was that incident.
That's correct.
Okay. And at the time of that incident, the Homer J. Maximus account, as far as you can tell, was located in Rexburg, correct?
That is, well, what I can tell is that it was not within that radius.
Okay, that's fair. So it wasn't in that 1.4 mile radius.
That's correct.
So you didn't map out where else it went.
I did, but
Okay.
it was not reported for the purpose of that report for that radius around the
Okay.
residence.
So you for the purposes of your investigation, you mapped it out. It's not on your report.
That's correct.
And that's fair. Are you aware through the Homer J. Maximus account where Alex Cox went earlier that day in Idaho Falls?
I believe so, yes.
Are you aware that he went to a Sportsman's Warehouse?
Yes.
Did you review any reports on what he purchased while he was there?
I believe it was in the discovery, yes.
Okay. Now, with your 1.4 mile radius, that excluded the Homer J. Maximus account for October 18th, correct?
That is correct.
But are you aware, or were you aware, that the Homer J. Maximus account was located 2.5 to 2.6 miles just south of Chad Daybell's residence that night?
At Salem Church, yes.
Okay, thank you. And you're aware that multiple text messages were shared between Chad Daybell and Alex Cox that night?
Yes.
And they were on phones that they had both activated on October 9th. Were you aware of that?
Yes.
And is it because of the 1.4 mile radius that you did not include those text messages in your report?
That's correct.
Really quick on the geofence. Mr. Pryor talked with you about Detective Stubbs' testimony that Google informed him they would only return information on a specific number of Google IDs.
Yes, that's correct. I was a little confused at first because there's been a bunch of numbers and none of them were the same.
And it was your testimony that you're not familiar with Google doing that.
I'm not familiar with them limiting what we're asking them to describe or provide subscriber information for. That is correct.
But that doesn't mean that's not what they said to Mr. Stubbs.
That's correct. I've seen no documentation from Google that said that they asked for that either, though.
Okay, that was based on his testimony.
Correct. I'm just saying from the Google responses, their returns and the emails that went back and forth through LERS, I didn't see anything where they said that they were limiting that.
Okay. And again, that information is just based on Detective Stubbs' testimony.
Correct.
And you do agree that in that geofence, the Homer J. Maximus account does show up on Chad Daybell's property.
Yes.
In fact, it's similar to these areas you've mapped.
Yes, I think identical.
Yes. And are you aware of, through your review of the discovery, Alex Cox's relationship with Chad Daybell?
I believe he's his brother-in-law.
Well, he was his brother-in-law, correct?
Correct.
You're aware that Alex Cox is deceased?
Yes, sorry.
No, that's okay. Did you review any iCloud accounts belonging to Lori Vallow?
I did.
Did you listen to any audio of blessings being given by Chad Daybell?
Judge, I'm
to
going to
Alex
object at
Cox?
this point. It goes beyond the scope of direct examination.
Sustained.
May I briefly argue, Your Honor?
Yes, go ahead, Mr. Wood.
I'm asking him about digital evidence he's reviewed, which was the substance of his testimony.
Judge, that's a broad sweep.
Yeah, I think it's outside the scope of anything brought up on direct, Mr. Wood, at this point.
Okay, thank you. That's fine. And you testified you were unable to find any geolocation data for Chad Daybell?
That's correct.
And you're aware through your review that Chad Daybell used multiple phones?
Yes.
Your Honor, I have no further questions at this time.
All right, thank you, Mr.
I have multiple exhibits here to return to the court.
Very well.
Motion to approach the podium.
You may.
Mr. Eller, Prosecutor Wood indicated that there was a phone call at 8:11 from Chad Daybell to Alex Cox.
Yes.
Do you have any information that the warrants that they obtained from Google would have included data information from that phone call?
No.
In fact, there was no data information that they investigated regarding that phone call. Is that correct?
I believe that there would have been a record, a cell tower transmission record for the call.
Okay. But there would be no identifiable way to say the location of Mr. Daybell's phone. Is that right?
Not an exact location, no.
And then that applies to the 923 as well. Is that correct?
That's correct.
On those phone calls, is there any indication, in fact, all of these phone calls that were referenced, is there any indication whatsoever of what was discussed on those phone calls?
No.
And again, on 9/9 and 9/23, during the time that Alex Cox's phone is showing he's on the Chad Daybell property, do you have any electronic information or data of any kind to suggest the Chad Daybell's device was on the property at the same exact time?
No.
Nothing else, Judge.
Thank you. All right, that'll conclude the testimony of Mr. Eller then. Are we going to have him remaining under subpoena from the defense?
No, Judge, he's excused. Thank you, Mr. Eller, for the defense.
I'm sorry, but the only thing that proves to me is it still does not matter to me one way or the other if Chad was on the property when Alex was disposing of those two children's bodies. Either one of them. It does not matter to me if Chad was there or not. He still devised the plan. Alex was the muscle, right? We know that. We know that. Margaret says it's got to be difficult putting on defense expert witnesses after the prosecutions. You got to work to put on the reasonable doubt. Yeah. But like I said, for me, Margaret, I don't care. I mean, it doesn't matter one iota to me if Chad was on the property or not. He knew and he devised and he was on the phone with him saying, yeah, make sure you go over here and go behind this place and make sure you go behind that place and 100%. All right. All right. I'll hush my opinions and we'll get on with it.
Great.
The state doesn't have him under subpoena, Your Honor.
All right, thank you. That concludes your testimony. Thank you for appearing and testifying today. You can go ahead and step down.
Yes, Your Honor. Thank you.
You're welcome. All right, the defense may call its next witness, Mr. Pryor.
And Judge, I may need a minute to see if he's arrived.
Okay,
He's here. I've been told he's here. May I have again permission to approach the podium, Judge?
yes.
You got to put that money in the swear jar, Margaret. We have a cussy cuss jar over here.
And if the court would allow me, when I may proceed.
Yeah.
Judge, the defense would call Dr. Greg Hampinkian.
Very well.
Okay, I think if this is the guy with the long gray hair, he
And
has
Judge,
a
while we're
blue
waiting
shirt
for
on.
Dr. Hampinkian, there was a stipulated exhibit that the court had delayed ruling on. The Atria, it was a 49A. It's in the possession of the clerk. I'm asking at this point, my understanding is
that's
that by
him.
stipulation of the parties that exhibit would be admitted.
Which prosecutor's responding on this?
I am, Your Honor, not ask for a sidebar real quick.
Very well.
So this guy that's getting ready to come up, I watched a little bit of him last night, his testimony, and he's a forensics guy, but he doesn't come off as very convincing, I guess. I don't know. Margaret says, my mom has a swear jar. I just write checks at this point. Miss King says, I think he was a good witness, not just a paid expert. He seemed like he did try to give information he found. I agree, Jenny. Chad may not have done the killing, but was part of the planning. Yep. I agree. I agree. There's Mr. Larry Woodcock back there in the back, standing along the wall. He's there every single day, all day. Hmm. Okay, I'll go ahead and speed it up. I will go ahead and speed it up a little. Oh, hold on. All right. Get a
All
drink
right,
of your
thank you,
water,
counsel.
Lemonface.
After the sidebar, I'll suggest still we have the witness take the stand, and if there's a proposed offering of an exhibit, we'll take that up after the witness has been on the stand and under oath. So I know they were in the courtroom, Dr. Hampikian, as they go ahead and have him brought in, please.
Solemnly swear or affirm that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
You cracked me up, Margaret. You got that dusty water. No pie today, right, Brenda? No pie.
Good morning.
Morning.
Would you state your name and spell your last name for the record?
I'm Greg, Greg, Hampikian, HAM as in Mary, P as in Peter, IKIAN as in Nancy.
Okay. And it's Dr. Hampinkian, is that correct?
Yes.
Now, in full disclosure, we do know each other, don't we?
From this case, yes.
Okay. And how would you prefer, for purposes of this hearing, that I address you as either your first name, or was Dr. Hampinkian what you would prefer?
Probably given the formality, Dr. Hampikian, is what I'm used to.
So, Dr. Hampinkian, can you briefly explain to me your occupation?
I'm a professor at Boise State University. I have a laboratory there. We work on a lot of DNA projects, forensics, viruses, cancer, and I have a joint appointment. So I'm in the biology department, but I have a joint appointment in criminal justice so that I can take on some of their students for projects, occasionally lecture over there. And then I'm an adjunct lecturer at the University of Idaho College of Law. And then I also consult on cases like this, which are private cases. And I head up something called the Forensic Justice Project that deals with testing DNA in cases where people write in and say they're innocent, they've been convicted wrongfully.
And in that regard, with your forensics project, is that a nationally renowned project or organization?
It's funded nationally. We work right now in, I think, a dozen states, and we have a grant from the Department of Justice. They don't endorse anything I say. I always have to say that about my funding agencies. To work in 5 states in particular, doing DNA reviews of cases.
Okay, and there's no particular distinction. You will do work for defense work and you will do work for prosecution work. Is that fair?
Sure. Yes.
And have you testified previously in cases regarding DNA analysis?
Yes. Dozens of times. Yeah.
Okay. Okay. And can you briefly explain to me your educational background?
I have a PhD in genetics, a bachelor's in biology, a master's in genetics, all from the University of Connecticut in Stores. I've had postdoctoral training after that on a National Science Foundation grant in Australia, working on the Y chromosome, the male chromosome, and then more postdoctoral training in Massachusetts in developmental biology, and a lot of professional development around forensics. And that's mostly done through the American Academy of Forensic Sciences or some of our annual meetings.
Is there any special accreditation or academic achievements that are recognized as part of your time doing DNA analysis?
I mean, the most important things are our publications. That's what we're judged by. So these are sent out for peer review. If 2 of the 3 editors think it's good, we might have to fix a few things and then it gets published. But I consider that the most important thing. And then we have certifications to put DNA in certain databases. There's a Y chromosome database. Of course, I have tenure at the university, which is another hoop. So there's lots of hoops we had to go through.
And this is not, this is Boise, Idaho that we're in, but you're an international, you're sought after in an international capacity. Would that be fair?
I don't know.
Objection.
Thought
argumentative.
after.
It's bolstering the
Hold on.
witness.
All right, first of all, again, I'll be talking at the same time to keep a clear record. When there's an objection made, please pause so the court can roll, and the court is going to sustain that objection.
Have you had an occasion to work with international police?
Yes, I've worked with the French police. My mother lived in France at the end of her life, and I had good relations with them. We actually published a case that we worked on. It was a big national case that had languished for many years. It was the first time that a type of DNA familial searching was used. So we published an article, and I've worked with the Taiwan Forensic Science Lab, and we also published a case, and that was a man who was wrongfully convicted with DNA analysis that we asked to review, and the lab did the laboratory wet work at our request, and then we wrote a report together and then published an article.
So not only is your organization do your own DNA analysis, you peer review others as well. Would that be fair?
Yeah, right now, most of the work is review. It comes in on computer disks, so it's run at independent accredited forensic labs, mostly in America, a few international cases.
You mentioned the French case. Would that have been the Amanda Knox case?
No, Amanda was in Italy, and
That's
that
right.
was, that was a different case. The French case was Elodie Kulik.
Did you have any involvement in the Amanda Knox case?
I did have some involvement in that case. I worked on it for several years with the defense side, starting during the original trial where she was convicted, and then staying with it through to her ultimate exoneration.
And when you say ultimate exoneration, eventually she was, through part of your efforts with DNA, she was exonerated of the charges. Is that right?
Yes.
Objection, Your Honor, bolstering the witness.
Oh, hold on. There's an objection. I'm sustaining the objection, striking any answer that came after.
About how many cases, well, before we get to that, about how long have you been doing this forensic DNA work?
Since about 1989.
Okay. And about how many cases have you worked on?
Work is some of these cases take years and years of a lot of work, and some of them are just quick reviews, but I'm sure I'm in the hundreds by now.
Okay. And you already mentioned that you publish your work in peer-reviewed journals. Is that correct?
Yes, that's required really of the academic position.
And required if as part of being affiliated in some capacity with Boise State?
They generally don't let you stay if you're not publishing. Yeah.
Okay. And then I think I mentioned this before, but I'll mention it again. You do work with the police on these cases as well. Is that correct?
Yes, particularly in cases where the state labs don't have the technology, and we have the technology, or they haven't yet validated the technology, and we can help the police. And a lot of what I'd call difficult DNA cases, where they're over 20 years old, say, and we're reopening them. So we have a lot of officers come to the lab.
You mentioned that, and that was where I was leading next, is there are instances where our own state lab doesn't have the facilities or the understanding to engage in certain testing that you have. Is that correct?
I wouldn't say they don't have the understanding, but they have a very difficult process. They have to validate, you may have heard from their experts, all of the techniques. I mean, it's a public lab. And so we're a research lab. We can kind of get to the newer technology more easily. And that's really the reason why I think people would come to us.
Okay. And you have testified in regards to helping the prosecution in cases as well. Is that correct?
I've been listed as a witness here in Idaho, didn't testify. I did testify in Atlanta, Georgia, and was paid by the Fulton County to testify.
As part of your, I'm sorry, I'll slow down. As part of your employment, is it part of your employment to train students who work in police forensic DNA laboratories?
Yes, I teach the forensic biology course. It's the only one at the university. And so several of my students have gone on and gotten jobs in forensic science in the laboratories. I have a graduate student who works in one of the, with one of the police agencies right now. So a lot of people have come through the lab and end up in forensic science, some of them in state labs.
And as part of your occupation as well, have you had the occasion to instruct and train judges on DNA analysis?
So judges come a lot of times to the additional development that I offer for all lawyers, but specifically, I was invited twice to Montana to train the judges, and then once to Israel to train judges.
Okay. And has it had the occasion where you have helped solve what are referred to as cold cases?
Yes, I'd say the one I referred to in France is a notable example, and then Christopher Tapp, who was exonerated here in Idaho. We worked with the Idaho Falls Police Department to find a new DNA match, who eventually confessed to the crime that Mr. Tapp had served wrongfully for. And there's a case now that's going on in Idaho where we helped the police establish a new match in a murder that was many decades old, but that's not finished yet.
Okay, and so when I when I talk about what is called a cold case, that means a case that occurred sometime previously?
It has several definitions. I like to think them as old cases that, are just not getting a lot of movement forward. And some agencies will refer to them as cold cases. And there's actually special funding you can get from the Department of Justice that are aimed at solving these cases. So there are cases where there's no active suspect, and methods like genealogy, one of the new methods, can be used.
Do you have a DNA lab at your location?
Yes.
And is that a fully functioning DNA lab?
On good days, it's fully functioning. Yeah. It's a, it has the equipment that that's similar to the forensic equipment that the Idaho State Police Lab has. We're not doing active casework, though. I send any evidence now to accredited independent labs, either the state lab or an independent lab. And that's mostly because I don't want everybody in the lab to get subpoenaed to come and work like something like this. And it's just easier. So for somebody writing a check, they can take all the responsibility for everything that happens handling wet lab items.
You mentioned the state lab. Has there been occasions when the state lab has reached out to you, the Idaho State Lab has reached out to you to consult you on issues?
I don't think the state lab's reached out to me. We've talked, and I certainly know some of the analysts, but I can't remember them reaching out to me.
And you do teach forensic courses as well at Boise State?
I teach forensic biology at the law school. I teach a course called Wrongful Convictions that looks at how we reopen cases with DNA. So that's kind of a forensics class. And periodically, I'll teach seminars on forensics.
And how often would you say that you testify?
5-6 times a year, maybe, or less.
Okay. Is there a reason or an understanding as to why you don't testify more often?
I mean, most times if I review a case, I'm getting a bunch of data and I can run it through our software and check on things, and I go through all the records. And if I'm not contributing something new that someone has hired me to look at, they're not probably going to want to pay for more time for me to come and sit in the courtroom. So oftentimes, if I agree with what the lab has done and there's no questions, I'm not called to testify. And that's the vast majority of cases. I'd say.
And would you describe your profession as a specialized scientific profession?
Yes,
And it takes specialized knowledge.
yes.
And with your education and training, are there a number of people who obtain your or have your specialized knowledge in this field?
I mean, I get to meet with my colleagues. I'm a fellow of the American Academy of Forensic Sciences. There's a few thousand people there, and then I'm going to another professional meeting in June, different one, and there'll be a few hundred people there. Hopefully, when I get to speak as well.
And you're speaking there.
Yeah.
Are there any special certifications that are required to do what you do?
Certifications. I mean, I have to, anytime we do anything at the university, there's two oversight boards that we have to apply to. They have questions about our methodology in terms of humans, like are we compromising anybody's rights? Are we doing any experiments that would abuse somebody in some way or abuse their rights? And then I have to go through the biology safety committee, and they also review everything. And then every year we have to go through all of our training again to be certified to continue the research. So
And in order to do what you do, it's important that you maintain those certifications and training. Is that correct?
me and everybody in my lab, yeah.
Okay. Okay. I want to talk to you a little bit about a concept of transferring DNA. Can you, in general, give me a broad overview of what the concept of transfer of DNA means?
So transfer is really at the center of DNA. You've probably heard of latent print evidence. It's very hard to transfer somebody's thumbprint from your glass to, say, a weapon. But DNA can move very easily, and so we always have to be cautious about making conclusions about how DNA got somewhere. So I like to say DNA is really good at telling us something about who may have contributed, but the how it got there, that's really for the triers of fact, for the jury or the judge. And as a DNA analyst, I can't tell. And the reason I can't tell is because DNA does move. It's how we get it. We take a swab, it just is a Q-tip, you wet it, and you rub it on something. And then you take a dry swab and you rub it. And both of those, just like you might clean up a pudding stain or something from a kid on a cloth, you transfer some of that material to your swabs, a wet swab and a dry swab. And then you have to get that material off the swab, and it's as easy as putting it in water with a few chemicals, and the DNA comes off. So DNA moves around all the time. When we talk about touch DNA, a term I really don't like because it implies we know how it got somewhere, someone touched with their hand, but really the way we get DNA on our hands, what the research shows is you touch your face, you're washing your hands during the day, but you touch parts of your body, you might scratch your ear, whatever, and all of those loose cells are transferred to your hands. So even what we call touch DNA is mostly transferred from somewhere else. So that's why I'm very cautious about speculating how DNA got anywhere. I don't know any better than anyone with common sense how DNA got somewhere. It's who could have contributed it.
Okay. So it's an issue of who contributed as to how it actually got there.
For me, yes, that's what I think is the limits of my ability.
And the fluidity of DNA, there's a number of manners in which DNA can be transferred. Is that correct?
Yeah, I mean, we talked about touch and swabbing with a liquid. You could just sweat and some of those cells will roll down with the sweat. So all the ways you can imagine dust, say, moving, DNA can move.
So you just mentioned that the manner in which dust can move, would that be the same manner in which DNA can move?
If it's dry and flaky, but DNA can also be in liquids. So yeah, it has a variety of ways of transferring.
So my touching of this microphone,
Mhm.
potentially I could have placed my DNA on the speaker of this.
Likely you did, whether it will be detected with a single swab or not, I don't know. But yeah, we on contact, our cells are shedding all the time. So on contact, you're probably leaving a few.
So when you say something as likely as touching something, if you were to have any kind of contact with any particular item, is there a high likelihood or a good likelihood that DNA would be transferred to that item?
Several levels to that question. When did I wash my hands? How long did I touch it? How vigorously? Am I a shedder? Do I have psoriasis or dandruff? And so there's a lot of questions just about me and my contact with something or a person's contact. But then there's also the laboratory, what technique they're using. In my lab, we can detect down to a single cell, not 100% of the time, maybe 20% of the time or so, where we can get DNA from a single cell if we want to.
And I'm going to jump around a little bit before
Mhm.
I get back to the single cell analysis. DNA and the transfer of DNA can be in relation to how much friction is involved with the surfaces. Would that be fair?
Yes.
And talk a little bit about that.
Just like when you want to rub something off your body or exfoliate, the more rubbing, obviously, the more raw you're going to make the skin. And the first thing that comes off is just an outer layer. That's all the dried keratinocytes. They kind of link together and they give you waterproofing. So that first layer goes. But if you keep scrubbing, you'll get down to tissue. You'll get tissue fluid, and then you'll get blood, and you'll get other bits of tissue. So it depends how vigorous in terms of how far down you go, how many layers, and then also just the amount of friction. Just like you'd imagine, if you're filing your nails, more friction, more removal of biological material.
For those of us that don't have your significant knowledge in this area, I would like to talk a little bit about this concept of what, and if you could put it into some context, what is a single cell?
Oh, it's very small. You can't see it unless it's a human egg cell. You can actually see they're big enough to see. But the type of cells we're talking about, the epithelial cell, you have to have a microscope to see. And so you can transfer hundreds, or I'm told we transfer pounds of these skin cells. So we're leaving a lot of them, and they're very small.
So and you're leading into my next question, because you can analyze down to a very minute cell that only can be detected with a microscope. Is that correct?
Yes.
But as humans, would it be fair to suggest that we are in a constant process of shedding skin and our DNA at all times of the day?
Yes. Yep.
So in all likelihood, as I walk around, and if I'm shedding, my DNA is being placed all over this table, right?
Yes.
And even if I go to sit down in that chair, as a human, and the fact that we are human beings that are in a constant state of shedding, would my DNA also be transferred to that chair by sitting down on it?
It could, or if somebody else's DNA is on your pants because you sat somewhere where they had their hand down, you can transfer someone else's as well.
And in addition, if you were to pick up or hold an object of any kind, there'd be a high likelihood, a good likelihood. Is there any way to determine what the likelihood is of how your DNA and what DNA would be on that item that you would pick up?
In a laboratory setting, there's studies that are done. We've done them in my lab where you hold something quickly, you grab it and you rub it. We tried a bunch of different things, and I think it's kind of common sense about the trends. The more friction, the more time, the more transfer. But there are shocking things. Sometimes somebody handles something a lot, you get no DNA. Sometimes somebody just taps it and you get tons of DNA. So I don't know how to ascribe a likelihood in a crime situation or a field situation. Just those general rules about time and friction are important.
So if I understand your testimony correctly, there are a number of ways to transfer DNA onto an object. Would that be fair?
Yes.
There would be ways in which you would touch an item and physically have contact with it. That's one way, correct?
Correct.
There would be a suggestion that if you were just around the object and you were, like many humans, shedding your cells would naturally fall on or be present on anything that you might be around.
They could.
Your hair can fall out and be on something if you were to do that as well, just being in the vicinity.
Yes, common sense would.
Or if you were doing something rigorous or doing something in the form of an exercise and some of your hair comes out and falls, that's another way to track DNA.
Yeah, the hair is shedding like the skin, and just more obviously.
So if you're around something, there is a strong likelihood that your hair is shedding, and then you're putting your DNA, again, I could be putting my DNA on that chair by shedding, correct?
You could, and if we looked for what we call environmental DNA, I'm sure all of us who've been in this room, have a high likelihood of showing up if the room is sampled really well.
And aside from DNA that falls off of your hair and falls off of our shedding bodies and skin, is it possible that DNA could also be transferred through our breath?
There have been studies that show that, and now they're having like swabs outside of zoos, and they're detecting all the animals who live in the zoo. So there is a certain amount of DNA that is transferred in the air, and that's really an area that people are developing right now.
Okay, so in other words, the breathing on some object, I'm not talking about any other fluids. We'll get to that in a second. But the breathing on an object, or if you're involved in a situation where you're engaging in heavy exertion, and as part of that heavy exertion, you're breathing onto an object, potentially there would be DNA of you on that as well, correct?
Potentially, yes.
Okay. And then we'll go to fluids. We can get DNA by way of perspiration, by sweating.
Yes.
If you're doing some sort of physical activity,
Yes.
and a drop of your sweat were to fall on an object, perspiration, that would be another way that you would find DNA on an object as well. Is that correct?
Yes.
And then by way of spitting, as much as disgusting as it might be, all of us have been guilty of being involved in situations where fluid comes out of our mouth and places itself on DNA, correct?
Correct.
And then as far as sneezing or breathing out of our nose, if we have any kind of a cold or any sort of issue with that, Again, that's another way that DNA could be placed on an object. Is that correct?
Yes.
So would it be fair to say that there are a variety of ways and manners in which DNA can accumulate on any object that you're around?
Yes.
It could be by way of fluid, correct?
Correct.
It could be by way of air, through the air.
Yes.
It could be by way of hair.
Yes.
It could be by way of having a physical touch with the object, as much depending on the level of how often you touched it, correct?
Correct.
Are there any that I'm missing?
Oh. I mean, I've reviewed all kinds of cases. People leave DNA in a bite mark of a cheese sandwich and a gum wrapper. There's lots of ways you can think of trying to find. And I always tell people, if they say, "Hey, can I get DNA off this thing?" I'm like, "We won't know until we try." And so I've been surprised. We've gotten DNA from bodies that have been submerged in water for days, foreign DNA, and that always surprises me. You just don't know until you try.
So would it be fair to say that there's no real way to take any precautions to prevent your DNA from being placed on anything in particular? Would that be fair?
Oh, I think there.
Objection argumentative.
Sustained.
Okay. I'll rephrase. In other words, DNA has a lot of fluidity,
Movement-wise, yes.
movement.
Mhm.
And there are a number of ways and manners in which your DNA, whether you mean it or not, inadvertently or intentionally, can be placed on items with even the most limited amount of contact. Would that be fair?
Yes, it's not always the case, but you test it and you see, yes.
Okay. And Judge, at this,
Yeah, I apologize. We do have a request for a break. at this
and
point.
Judge, I was going to do that. I'm going to be getting into an area that I think maybe we
All right.
could take our break. I would ask Dr. Hempinking to please show up again after lunch.
Yes, sir.
Okay, we're going to go ahead and take the lunch recess at this time. We'll recess from 12 to 1, be back on for additional testimony at 1 o'clock. Thank you.
All right, please.
Oh, you guys, hold on. I just got some, hold on, let me pause this for a minute. So I just got some texts, or not texts, but some tweets that talks about some rebuttal witnesses for the state. Looks like it's going to be good. And the docket, the hold on. The docket says on Twitter, an audio attempt to contact Emma is about to be entered into evidence. And then it says Emma Daybell caught lying her ASS off on the audio. That ought to be good. Hopefully we can get to that today. You guys, let's get on with it. Let's scooch, right? Let's go. Let's go. All right. They're back from their lunch. That was a quick Zoom. Yeah, right, Henny? Wee. Brenda says, is this thing on a loop on how great this guy is? Dang, move on. So my opinion is the expert he's a good expert. I like the guy. And when I said he's not very convincing earlier, I meant for me, he doesn't really offer anything that proves Chad's innocent of anything. So, but yeah. All right, let's hit the play button and let's go. You guys are awesome. You guys are awesome sauce. All right, let's go.
Thank you. We've got our jurors lined up, so please remain standing. We'll have them enter the courtroom. All right. Thank you. Please be seated. All right, Mr. Pryor, you may continue. We are back on the record on KCR 2221-1623, State of Idaho versus Chad Guy Daybell. We took the lunch recess. We're back on the record with additional testimony. Dr. Hampikian is on the stand. I'll remind the witness you're still under oath for your testimony. And Mr. Pryor, you may continue with your direct if you wish. You may.
Good afternoon, Dr. Hampikian.
Good afternoon.
I think where we left off, is I was going to start talking up the testing procedures that were conducted in this particular group of evidence that you were provided. And before we do that, can you then identify, if to the best of your recollection, what evidence you looked at and what did it did encompass?
I was supplied with a number of documents and electronic files. The things that are most important to me are the electronic files with the DNA data, because we have our own software that we can review that through and do probabilities and interpretations from. But I also receive things like, CVs and laboratory records that we review, and then a list of evidence, a lot of which wasn't tested. So I have, there are dozens of items on these lists of evidence. And what's most important is the things that were tested. And so for those, I have reports from 3 laboratories, Bowie Laboratories, Estrella, and the Idaho State Police Forensic Lab. And along with those, we have electronic records that allow us to reanalyze if we need to, if there's any problems. And I can't remember what other documents. There's a large packet of things that come through, but really it's the biological evidence that I pay most attention to.
And in regard to the state lab, you read a report which described a number of hairs on a piece of adhesive. Do you recall that tape?
Yeah, there were a lot, more than a dozen hairs, as I recall, but a lot of hairs.
And do you recall the different colors of those hairs on that adhesive?
Brown. There was very short, dark hair, a blonde hair. Those are the ones I remember. And obviously there were a number of the dark hairs, and I think several of blonde hair.
And at some point, as a result of on that tape and those hairs, and you said over a dozen hairs on that tape?
I don't know if they were all from that tape, but there are a bunch of hairs listed and only a few went on to testing. So
okay, and when you talk about that, the state lab is not the agency that's going to test that. Is that correct?
the state lab tests hairs generally when there's a root on them, but some of these other tests where there's no root, it's just the hair shaft. There are labs like Bodie and Estrella, both of the other 2 labs, that will process those and get really good results from hairs without roots.
And is it possible to obtain DNA from hairs without roots?
Yeah, just about, just a few years ago, 3-4 years ago, they started advertising this at some of the private labs that police agencies use, like Bodie. And then Estrella is one of the newer companies that specializes in, particularly in hairs that don't have roots.
Okay, so as far as Estrella is concerned, the only thing that you have in terms of Estrella is that of the brown hairs, the blonde hairs, and the short hair, the brown hairs were sent over for testing to Estrella. Is that what you recall?
Not all of them, but for some reason, certain ones were selected.
Okay.
And as I recall, 4 test hairs went to Estrella. Their first test is to do what's called a low depth sequencing. So they're basically just going to sequence parts of the 3 billion bases, not the whole thing. And that's because it's cheaper and it takes less computer time. And they can then tell you if the hairs are sufficient to go on further. So from that first shallow sequencing that they do, they get what they call a mitochondrial haplotype. They get some information about DNA we get from our mothers. And in that short sequencing, and the first thing they can do, they can tell if hairs are different from each other. And so they did that with the 4 hairs.
Did they compare those hairs on the ones that they sent to Estrella against any, and I'm not sure what the proper term is, people or
References?
references. I'm sorry, I struggled for the word.
So there are 3 references that were sent to Estrella: Chad Daybell, Lori Vallow, and JJ. And so those were the only 3 references that went through the type of testing that Estrella does. So this is a very particular type of testing, a sequence testing, different than what the state lab does currently. And so they could only compare it to those 3 samples, the 4 hairs that they had. They determined from the 4 hairs, that shallow sequencing, that 2 of the hairs came from possibly the same person. So they had 3 different people out of 4 hairs, and then they compared it to the 3 references they had. And all of the reference samples were excluded from each of those 4 hairs that represent 3 people. So neither Chad Daybell nor Lori Vallow nor JJ contributed those hairs. And then there's further analysis than they did, but that's the first main conclusion is there's 3 different people who don't match the 3 reference samples who left hairs that were sent to Estrella.
So at this point, what was basically sent to Estrella, the conclusion is that Chad Daybell was excluded as providing any of the hairs that were provided to Estrella as a positive. Would that be fair?
Yes.
Did you find any evidence of anything that you provided that were provided to you through these DNA reports indicating that Chad Daybell's DNA was present on anything?
No.
I want to talk to you about conclusions and what type of conclusions someone in your field of DNA forensics can arrive at. And if you would talk a little bit about that, I'd appreciate it.
Sure. In these common types of tests, there's basically 3 conclusions. I can say someone is excluded. And in other words, there's too many mismatches. And I can just say it's clearly not this reference sample that donated DNA to this evidence sample. So that's exclusion. And sometimes a statistic is provided, but it's not required. You can just say they're excluded and show the data. The other option that's informational is that they cannot be excluded. So that means they could have contributed that DNA on the evidence. And then we have to supply a statistic. Is it 1 out of 2 people would match it? And what's the coincidental match? Is it 1 out of 100 trillion? And the third option is you can say it's inconclusive. So you can have exclusion, cannot be excluded with a statistic, inconclusive. When is it inconclusive? I drop a tube in lab. There's nothing in the tube. The test doesn't work. There's not, I doubt the results somehow. And that's an inconclusive. So those are the 3 options that we have.
And then when you get a conclusion that it's a negative result, what does that mean?
That's a really bad term because it means that what's negated is the hypothesis that was being tested. So for example,
Explain that to me when you say what's negated is the hypothesis being tested.
let's say someone is accused of a crime and I swab a handle of a knife, let's say. I have a reference sample from the accused. And really what I'm doing is hypothesizing that the reference sample matches the evidence sample. And I test that hypothesis. And a negative result means, in some ways, the way a lot of analysts use it, means that I've negated that hypothesis. It is not this person. It is an exclusion. So the unfortunate thing is negative result is used when we exclude someone, which is a perfectly valid result. And it's also used when it's inconclusive. Sometimes people say it was a negative result. You can think of it like a COVID test or a pregnancy test. You can be negative for the pregnancy or the disease, or the test could not work. And some people will sometimes refer to that as negative. There's no evidence. There's no test. But in the case of the labs, what they're really doing when they have a reference sample, as they have in this case, they have 3 reference samples, for example, at Estrella, they're testing the hypothesis.
So what hypothesis in this case are they testing?
Did Lori Vallow contribute the hair? Did Chad Daybell contribute the hair? Did JJ contribute the hair? So they tested 3 hypotheses, and in each case got a negative, a valid, very sensitive and correct answer that none of those people contributed those hairs. So that's how negative is used in that setting.
Is it used in other settings as well?
Yeah, and like I said, it's a tricky term the way people use it. So I sometimes there's a phrase in our field, if I can say it, it's that the absence of evidence is not the evidence of absence. So you can't prove you weren't somewhere just because they didn't find you there. That sounds like it's true. And I've heard experts like myself say it on the stand. And years ago, I was asked on the stand, isn't it true? The absence of evidence is not the evidence of absence. And then I realized, no, it is the evidence of absence. Of course, it's the evidence. And I know that because in cases where we've done exonerations, there's evidence that other people did the crime. And to say that, just because there's no evidence from an innocent person that's meaningless. It is meaningful. Things are tested. You test the
Objection
hypothesis.
narrative.
Yeah.
Sustained.
Sorry.
Okay.
Sorry.
So again, if I could ask a question,
Yeah.
the hypothesis you were talking about is in regards to the absence of evidence and how it relates to the testing procedures. Is that correct?
Sometimes negative results are referred to as the absence of evidence, and that's incorrect. These are well done, carefully done tests that negate a hypothesis. Did this person contribute? And that's important evidence.
Okay, so if I understand you correctly, it's not just showing that his DNA or her DNA is not on anything. It's the fact that the hypothesis suggesting that that person in some way contributed to whatever is being tested has been negated, and that the hypothesis that that person has been involved in that is negated as well.
Objection argumentative.
Sustained.
Is the hypothesis that the person is present is negated by an absence of evidence?
Objection argumentative.
Overruled.
I would state it this way, that every piece of evidence can be weighed in terms of, does it favor one explanation or another? And so when we have a test where someone is excluded, that some people will refer to as negative, when we have a test where someone is excluded, it's up to the triers of fact to decide what hypotheses that favors. But it's evidence when someone is excluded. It's evidence when someone is included. The only thing that's not evidence is the inconclusive. Just forget about that one. But
in this-
positive and negative are important conclusions.
But would it be fair to say that in this particular case, there's an absence of Mr. Daybell's DNA on any of the items that you reviewed?
Yes, there's an absence of his evidence, of his sample, of his DNA.
And before we finish up, I would just like to touch on the fact that were the results that you reviewed in this case, were they valid?
Yeah, we check all their controls. And so they, anytime the lab's running a bunch of tests, they have some blank tubes with just the chemicals to make sure nobody's skin cells from the lab or the police got in there or whatever. And so the controls that we use in this case were standard controls at all three labs, and they all were okay. They were fine controls. So that's trustworthy.
They follow the proper testing procedures.
They follow the proper procedures and they got good results with their controls.
They searched for the smallest or tiniest amount of DNA,
Very small amounts of DNA they searched for.
significantly small.
I mean, as small as they can go. So generally we're looking at just a few cells now. So,
Okay.
20, 40 cells is
Is there any indication that anything went wrong with their testing procedures?
no.
And they had all the proper controls?
Yes.
Now, I'd like to talk a little bit about with your familiarity with these testing labs. Do you have some sort of familiarity with Astria?
Yes. Yeah. I know Dr. Ed Green, who's helped me on on a particular case. His technology, I believe, helped found that company.
Okay.
So I helped him with I gave him his first case. Really.
You gave him his first case?
I believe it was. Yeah.
Okay.
It's here in Idaho.
And you know Bode Laboratory?
I've been to Bodie many times or several times, and I was just on a panel or on a DNA panel with people from Bodie, so I know some of those folks who work there.
And the state police as well.
I know the state police folks pretty well. I see them at professional meetings. I visited the lab on occasion. Yeah.
So if I understand correctly, then you don't have any question about the procedures that they followed. Is that correct?
Not in this case, no.
What you question is maybe the range of what they decided to test.
I don't know who makes those decisions about what's being tested. I just know what ultimately gets tested. And in this case, 4 hairs were sent to Estrella. The very short, dark hair it was called, and then the rest of them were brown hairs, 3 other brown hairs.
And then the hairs that weren't sent included blonde hairs.
That's correct.
Okay. Judge, I have nothing else. Thank you, Your Honor.
All right. Mr. Wood, when you're ready, cross-examination.
Good afternoon, Dr. Hampikian.
Good afternoon.
So you testified, you do run a lab at VSU.
I do.
Is that an accredited forensic laboratory?
Not for the type of evidence the state police run, no.
Mr. Wood, I apologize for the interruption. Could I have a quick sidebar with counsel, please?
Again, the lack of DNA from Chad on those items means, okay, here's what it means. Here's what it tells me. It tells me, you're not going to convince me that this dude was not a part, a massive part, a plan, the teller, you do what I tell you to do. I'm the king, you're the muscle man. I'm telling, nothing. It tells me absolutely nothing except he wasn't there. He didn't get his hands dirty. He told Alex what to do, and Alex did it. Period, point blank. Period, point blank. Oops, sorry. Loud phone. All right.
of the court wanted to clarify the matter, and I am allowing a brief reopening of the direct in order to address that exhibit, and then we'll go back across. So, Mr. Pryor, you may approach. Yes. And this relates to the proposed exhibit 49A.
And Judge, at this time, I'd move, and my understanding is by stipulation, to the admission of Exhibit 49A.
Okay, and that's the Asteria report. Does the state have any objection to the admission of exhibit 49A defense?
No objection.
Okay,
Thank you, Your
exhibit 49A is admitted. Thank you, Mr.
And
Pryor.
I'm done, Judge. Thank you.
All right, and sorry on this exhibit again, do we have a separate 49 and 49A?
I believe there's a 49 and there's a 49A, Judge.
Okay, well, 49A is now admitted, which is a paper copy of an Asteria report. Thank you while we sort that out. Apologies for the interruption, Mr. Wood. You can commence and begin again or continue where you left off on your cross.
Thank you. Dr. Hampikian?
Yes.
Hello again.
Hi.
So you testified, you do run a lab,
Yes,
but for actual testing in a criminal case, you would send that off to someone else.
we do now. Yeah.
Was there a time when you tested it?
Yes, there was.
I believe, correct me if I'm wrong, you testified this lab you run that was not a forensically or an accredited forensic lab anymore, or it is not a
We
forensic.
never applied for the type of accreditation that Bodie and Estrella and the ISP have. We use the same procedure, same equipment, but we're an academic lab, and so we're not required to do that unless we wanted to take in, paid testing, which I don't want to do.
And you have a lot of students in your lab.
Yeah, I think 6 right now that are
Okay.
this summer.
Mr. Pryor spoke with you about the ISP testing.
Yes,
And did you review all of the lab reports for that testing?
I reviewed all I was given. I think I had all the reports. Yeah.
Did you review the test identifying the remains of Tylee Ryan?
Yes.
And you had no issues with that testing?
No.
Okay. Did you review the results of the test identifying JJ Vallow?
Yes.
And to be fair, it identified him to his biological father, Dennis Trahan, correct?
I believe, I can't remember, but it was a correct identification. Yeah.
And you, okay, so you didn't have any problem with that
None
testing?
at all. Mhm.
Did you review the testing of what appeared to be genetic material in the eye of a pickaxe?
Yes.
And did that testing, was it valid to you?
Yes.
On that same pickaxe, there was some testing done on what appeared to be a blood spot. Did you review that testing?
I believe they referred to it as the handle or.
Yes.
Yeah, the handle. Yep.
And that testing was fine with you?
Yes, it was.
Okay. And finally, there was some genetic material on the blade of a shovel. Did you review that testing?
Yes.
And that testing met criteria for you?
Yes.
And you're aware, you spoke about the Estrella lab testing. You were aware of the hair that got sent to Bodie Labs?
Yes.
And do you remember who that hair was tested against?
I don't know who it was tested against. I remember it matched Lori Vallow, as I recall.
Okay. You wrote a report for this case, correct?
I wrote I wouldn't call it a report.
We
I
call
wrote
it a
what I was
summary.
going to testify to.
Okay.
Yeah.
Your Honor, if I may have one moment.
You may.
Thank you. Your Honor, I have no further questions.
All right, thank you, Mr. Wood.
Again, permission, Judge?
Yes, redirect, Mr. Pryor.
And just very briefly, Dr. Hempinky, in regards to the axe and the shovel,
Mhm.
your testimony is that you acknowledge that there was valid samples on those for Tylee or for Tylee on those samples. Is that correct?
That's correct.
But isn't it true, Dr. Hempinkian? There is no accurate way to determine actually how those samples got on those tools, is there?
Not by anything that I can do with DNA.
Okay, thank you, Doctor.
Yep.
Judge, I have nothing else.
Okay. That will conclude the testimony of the witness then. Is he going to remain under subpoena by either the state or the defense, Mr. Pryor?
Judge, he's,
Yeah,
me
cheers.
first. Judge, he's going to be excused.
We don't have him under subpoena.
Okay, that'll conclude your testimony. Thank you for appearing and testifying today. You can step down.
And Judge, could we take a brief sidebar again? I apologize.
Yes.
Henny, that's a very good possibility that he would have been wearing gloves. I just don't. I don't know. I mean, there weren't any hairs found. There was no, like, he could have been. I mean, he could have been right there, but even if he wasn't, it doesn't make him any less guilty in my eyes. Okay, let me see if I can get this to go. Zoom, 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 and a zoom, zoom.
How we're going to proceed at this point is I am going to have the public excused from the courtroom. We are going to discuss some scheduling matters in the presence of the jury, but outside of the presence of the public. And so we'll take that up next. Ladies and gentlemen that are here from the public observing, thank you for complying with the courtroom conduct order today. I will note there won't be any additional testimony provided today. I am going to discuss the scheduling matter though with the jurors and counsel presence, with them allowed to make comments as well. So that will conclude the matter as it relates to the public proceedings in court today. The jury can remain seated. If we could have the courtroom cleared of the public, please. And case agent and the defense agent also are permitted to stay for these proceedings. On this side of the bar, please rise. All of you belong.
I'll be right back. Got to go get the kiddo milk, but I'll zoom it onto this hearing. I remember hearing this hearing, hearing this hearing. I heard this hearing yesterday. Is where they're wanting to open up some additional evidence about the life insurance policy for Tammy Daybell. So I'll scoot you guys over to that, and then I got to go get this child some milk. I'm not sure why they did that, Miss King. But they do allow the live streaming to continue. So I'm gonna mute myself, go fix that, and then looks like they're coming back. I'm gonna grab her some milk.
We are live streaming. Okay, we are going on the record now, and we are live streaming these proceedings, so they are open to public access in that manner. However, just given the way the day worked out at the conclusion here, we've already had the general public exit the courtroom, and for efficiency to take these matters up and also for security, where the defendant is remaining present here, we are going to conduct these hearings on the live stream, but not permit public access, as this will conclude the day as well. So what the court has before it is a motion to reconsider the state's motion in limine related to UPT insurance, quote unquote, filed May 22nd by the state. And at issue is a previous ruling on a motion in limine. I should note the jury is not present for this proceeding. They've been excused for the day. And so on this motion in limine, the court previously determined that a statement made by a proposed state's witness, Janice Olson, about changing the defendant's life insurance, or the defendant's wife's, Tammy's, life insurance policy, I found it was not admissible in a previous ruling, And based on additional testimony now, the state is requesting that I revisit the ruling as it concerns the state's potential rebuttal. And so I will hear argument on the motion. Mr. Wixom, I understand, will argue it. And I have allowed the defense an opportunity to review the motion, and we'll hear argument in opposition if there is any. So Mr. Wixom, please submit your argument as it relates to this motion to reconsider the motion in limine.
Thank you, Your Honor. May I remain seated?
Yes.
Thank you. Your Honor, I again will attempt to be brief. I think the court is very familiar with the arguments made in the prior brief. I do point back to those points of law and authorities.
Could you pull the mic up a little closer?
Certainly, Judge.
That's better. Thank you.
Yeah, you betcha. Your Honor, we're in a situation now where the court has denied our original request to call Janice Olson as a witness, who we anticipate will testify that approximately the 5 or 6 weeks or month, I don't have it in front of me, prior to Tammy's death, that she had lunch at school with Tammy, and that Tammy, in a passing conversation at one of those lunches, had stated to her to the effect of, "My husband wants me to up my insurance. He thinks I should up my insurance." And then, of course, we have an admitted exhibit as to a life insurance policy that did bear the signature of Tammy and Chad Daybell. As I recall, the date of that application was the 8th of September of 2019. It increased coverage for Tammy from $50,000 up to $130,000. It added $80,000 of coverage. There also, as I recall, may have been some request in it to add Mr. Daybell to the policy.
All right, Mr. Wixom, though, before going back, there's a quote in your motion, and that was in the previous motion. You read the first of that, and I'd like you to go back again with the entire quote in context there, because I think the rest of the context does matter in the court's decision here.
Certainly, you bet, Judge.
So please review again on the record the comment you're requesting from the beginning to the end of those quotes on the middle of page 2.
Will do. Sorry, I just have to call it back up here quickly. So, Judge, the proposed statement that we would intend to admit would come from Ms. Olson testifying, and we believe she would testify to the effect of, quote, she'd just say, I think she's referencing Tammy, she'd just say, my husband thinks I should up my insurance here at the end of my career. You know, before I retire, he's thinking I should up my insurance.
Okay, thank you.
You betcha, Your Honor. So back to that, Judge. We know that there's an admitted exhibit now where, in fact, an application was submitted, insurance was upped, and approximately 5 to 6 weeks after that, Tammy was dead. So the court had originally denied our request to have that admitted through Ms. Olson. What's changed from the state's perspective, Your Honor, now is that yesterday, I think is Monday, I'm sorry, when Emma Daybell was called, she was questioned by the defense, specifically asked a couple of questions that have been included on the transcript that we have attached to our motion. And in that transcript, it demonstrates for the court that defense counsel asked Emma about the meeting that both Emma and Tammy had with, I believe it was Taylor Ballard from the insurance company that year, about the benefits. And he asked her a couple of times, very specifically, whether or not she knew if her mother had any conversations with her husband about increasing the insurance. I believe that was asked twice. I'm referencing page 4 and 5 of the partial transcript. Excuse me. The question was, beginning at line 7 on page 4, are you aware as to whether or not your mother consulted with the insurance company, with your father, prior to upping her insurance on that meeting day with Taylor Ballard? Ms. Blake objected, called for speculation. The court overruled. And then Mr. Pryor again asked, are you aware of whether or not your mother consulted with your father on that day to up her insurance? Ms. Blake objected as to hearsay. It was overruled. And then Mr. Pryor indicated that there could be an answer. Emma said, we were sitting at a table and filled out the paperwork together. We both signed to take out more life insurance on ourselves, and we did not consult with our husbands. Next question, at that point, did you take up the maximum amount of insurance that you could purchase at that point? Emma answered, I did not, because I could not afford it. I later did. Next question, okay, at the next period. Answer, yes. Last question from Mr. Pryor on this issue. But it's your understanding that without discussing it with your father, your mother elected to up her insurance to the maximum amount. Her answer was, I saw her check that box on the paper. So, Your Honor, the state believes that the defense has effectively opened the door to the relevancy of whether or not Tammy did, in fact, talk to her husband about the need to up the insurance. We believe that it's now relevant. We believe, like we had noted in our motion before, her statements would come in over any hearsay objection under Rule 803(3) as a state of mind exception. And certainly they've already been allowed to be testified to. That issue has been testified to, not by the defense. So there won't be any prejudice on against the defense and trying to match the evidence because they've already introduced evidence on the issue and called a witness and questioned her about it. So without belaboring it further, Judge, unless you have questions, we do believe that it's now, the door's been opened and the state should be allowed to offer the evidence.
All right, thank you, Mr. Wixom. I don't have any further questions. Mr. Pryor, if you'd like to offer any argument if there's an opposition.
Judge, there is opposition, Judge, and the context of that is simply the words at the very end, before I retire. And if we're going to engage in this situation where we're going to be able to recall witnesses so that they can start muddying the waters and creating a confusion that at some point, Chad Daybell talked to Tammy about upping her insurance before she retires. There was no indication of when she was going to retire, how she was going to retire. And quite frankly, Judge, I don't think this falls under the state of mind exception to the hearsay rule. And the fact is that it wasn't at the present state of mind, and there is no indication from that statement that the insurance was going to be upped on that particular cycle. There was no indication when she was going to do it. And even, I question whether that comment or that discussion ever took place, but that's for cross-examination. Should the court even consider allowing this? But Judge, if we're going to start engaging in a policy where we're going to start saying the state, because now there's one minute statement that seems to suggest something other than what they're saying, and that's going to allow them to reopen, you're going to open the door to the state coming back and basically relitigating their case for another 2 or 3, 4 days, going every little statement that they think they can gain some mileage by doing this. And it is not a definitive statement. And I think the court properly noted that when it said, listen, read the entire statement in its context. Before I retire.
All right, Mr. Wixom, I get there's of course the initial hurdle of relevancy under Rule 401, and understanding your argument about opening a door and letting this in, I guess one extra question I would have is the source of this proposed statement, because there can be a proffer of here's what we think a witness is going to say, and this is a very specific statement as if it's quoted from somewhere. And so I don't know if that's taken from an interview. I don't know where the statement came from. And in determining relevancy, and I may have to have an offer well, before I get there, what is the source of this proposed statement that's so specific in the quotes?
Certainly, Judge. The source is one, the written report of Detective Bruce Mattingly, who did an interview, and there's also a recording of that interview. In my prior motion, I had referenced an offer to the court, should the court want to review that, just to avoid any question about what exactly was said by our prospective witness. And I'm happy to provide that if the court would wish to review that.
Okay, well, I appreciate you clearing that up, clarifying it. That was a long time ago. This has been a long trial, but I do recall the issue. And again, I wanted to determine where that statement was coming from. So the court's noted the objections as indicated both for hearsay or for relevancy. The court would note that under Idaho Rule of Evidence 401, the standard is pretty broad there. Evidence is relevant if A, it has any tendency to make a fact more or less probable than it would be without the evidence, and B, the fact is of consequence in determining the action. When I look at this statement, while I still question the weight of that with the comment saying before the end of the career in a place where she had not worked long, and there wasn't, I agree with the defense, there was no testimony about when or if she was planning on retiring. I still think this gets past the 401 relevancy test, that there may be some tendency to make a fact more or less probable. And so with that any tendency language, we get past 401 in the court's view. The court also, looking at the balancing under 403, would determine that there would be some relevancy here if the state believes this is worth bringing the witness in on that statement. Of course, the statement can be cross-examined and the jury would have to determine what weight to give it. In terms of the hearsay, I have looked at that, and so it's essentially a hearsay within hearsay statement where the proffered testimony would be a person overhearing what Tammy Daybell said Chad was saying, and Chad being Mr. Daybell, the defendant. So his hearsay gets around the hearsay issue because he is the defendant in this case, and it's charged as part of a conspiracy, and a statement in furtherance of is what the rationale would be of the state. So then the question is there another exception for Tammy's proposed statement of what she told Janice Olson. And looking at Rule of Evidence 803, whether or not that is a then existing state of mind, I do think it fits within that 803.3. And in addition, there's the catch-all under 803.24 of the Idaho Rules of Evidence that a statement not specifically covered by those others, if it has equivalent circumstantial guarantees of trustworthiness, is offered as evidence of a material fact, and is more probative on the point for which it is offered than any other evidence the proponent can obtain through reasonable efforts, and for admitting will best serve the purposes of these rules and interests of justice. The notice provision of 24 has been complied with here. And so with those two bases under 803, the court is going to allow the statement if the witness is called by the state in its case in rebuttal. So the previous ruling then, and this is specifically not because anything changed other than what has changed again is the opening of the door through the testimony of Emma Murray, who specifically did testify right on point with the issue, talking about signing the life insurance and that quote, "We did not consult with our husbands." So I think the state's allowed an opportunity to rebut that now that the issue's been brought up in the defense case in chief. And so looking at the rules of evidence under both 400s and 800s with hearsay and relevance, the court is going to grant the motion and will permit the witness to testify as to that fact.
Judge, as an instruction, am I to understand that because this is rebuttal, the state is limited to the question of what this statement encompasses? Is that the scope of what they're going to be allowed to delve into?
Well, on rebuttal on the scope, I don't know right now what they intend to get from the witness. She'll have to follow the procedure of any other rebuttal witness and be limited in scope to what rebuttal would normally allow. But this expansion would be overturning the previous ruling on the motion in limine to permit that specific statement. So I think it may well be limited to just that, Mr. Wixom.
Thank you, Your Honor. At this point, that's all the state intends to do, unless some other issue comes up with opening the door, but we don't anticipate that.
Okay.
We did want to comment on one further thing, Judge, and I apologize as I sit here. I don't remember, I believe that we've left Ms. Olson under subpoena and she wasn't released, but I don't know for certain. I did want to address that so we don't have a problem with this. Even assuming for argument's sake, she has been released and has watched the trial. I would just argue to Your Honor on this very narrow issue. We'd raised this before with the court. It's documented. The defense has had this. The purpose of the exclusionary order is to prevent influence of testimony. But in this situation, we all knew a long time ago what she would testify to. And so we wouldn't be surprising the defense with it. It's not going to be susceptible to influence. So
Well,
I'd raise that with the court.
And Judge, that's where I would disagree. If Ms. Olson has had an opportunity to discuss this, and it sounds like at least she's been approached by counsel with the possibility of testifying, that would qualify as tainting the witness. And the fact that she has been excused and we're going to allow her to come back is problematic for me.
I may have to consider that as she gets here in an in-camera interview, if she has watched, in particular, if she watched that testimony of Emma Murray, which opened the door, and in particular, if she's listening now to this hearing, which is being live streamed, I might tend to agree that she may not be permitted to return because of the, she wouldn't violate the exclusionary order because she's released from the order. However, I might find it impermissible that it could be seen to have influenced potential testimony. So I would just have to take that matter up when she's called. But that's probably the first things I'd be wondering and asking is whether or not she's listened in on the hearing we're having right now and whether or not she listened in on Emma's testimony, which could potentially raise the issue Mr. Pryor's raised. So I won't make any ruling on that at this time. Okay. So that'll be the court's ruling as it relates to the filed motion. All right, moving on then, two other potential witness issues that state wanted to raise as it related to Deputy Cannon, I believe, and Detective Hermosillo.
Your Honor, Detective Hermosillo might be the quicker issue to deal with. The state had released Detective Hermosillo. I believe the defense did as well. We would let the court know that Detective Hermosillo has been hypervigilant about not watching any portion of this trial. We feel it necessary now to call him in rebuttal as to some testimony that has now come in. But he's going to come voluntarily, of course, and his representation is to us, and we absolutely believe he has not watched any portion of this trial. So we wanted to seek leave of the court, given his release from the subpoenas and the exclusionary order, to be allowed to call him as a rebuttal witness.
Okay. Well, I appreciate the parties bringing this up. It's not necessarily any type of a motion. I guess it's just alerting the court and defense that there may be a return of a released witness and whether or not they're permitted to testify or not. Again, witnesses who are released from subpoenas and advised they're no longer under the exclusionary order, not going to be held in violation of the order, whether or not there's some kind of motion to exclude based on potential tainting of their testimony, I think is just an issue we would have to take up. But I appreciate the proffer. Mr. Wixom, is there any comment on that from the defense, Mr. Pryor?
Judge, my concern is this, is that the very witness they're talking about happens to be a law enforcement officer who's involved heavily in this case. And despite counsel's assurances that there's been no discussion, I'm extremely skeptical of the fact that Officer Hermosillo did not discuss the case in any regard with any of the law enforcement officers that he works with. In addition, this officer has been excluded and excused for a reason. The contemplation is at the time when we do this, Judge, is that both parties are not going to be permitted to call the witness back and rehash through the testimony of this witness. Now what we're having now is putting me in the position where I have a case that I put in chief. I'm prepared to rest. The state had every opportunity with Officer Hermosillo to come forward and testify. And suddenly now, after I'm preparing to close my case, they're now bringing this witness back who has now been released, and they're going to open the door to a number of issues that, quite frankly, cannot be adequately addressed through cross-examination with Officer Hermosillo. The advantage is clearly in the possession of the prosecuting attorney, and that I'm putting him in a very, very unbalanced position by allowing the court to bend the rule a little bit and say, well, at this point, we'll let this witness in. They want Coulter Cannon in. They want Hermosillo in. I don't know who else they're going to try to get in, Judge, who's been excused. But the minute you open this door, you're opening the door for them to rehash their entire case in chief. And at that point, Judge, I don't get the liberty of bringing witnesses back and saying, are they telling the truth? Unless this court's going to give me a surrebuttal, which I don't think that's going to be the court's ruling, allowing this to open up creates a number of procedural problems. And just the representation of Officer Hermosillo saying, oh, no, I didn't listen to anything when he's one of the chief officers in this case, I'm not buying it.
Okay, well, I will note that as with any witnesses are placed under oath, and it's up to them to tell the truth if they're under oath or not. So the court's certainly not going to draw any kind of inference or conclusion that already I'm determining that the detective would not tell the truth if placed under oath. I understand the concern raised, but that does not rise to the level to me that would disallow a witness to return to the stand. I guess just procedurally in terms of who gets called back in rebuttal, generally, there are some parameters there. And Mr. Wixom, if you'd like to address the argument of the defense as it relates to Detective Hermosillo, you may.
Certainly, Judge, just a couple of quick points. First of all, we would just remind the court and counsel that Detective Hermosillo was the case agent in the prior case and sat through all of that trial. So he's already heard from the bulk of the witnesses in this case and their very specific testimony, although he has and continues to represent. And the state believes him when he says he has not watched any portion of this trial. Judge, the argument about just calling back witnesses, first of all, we've only brought these few witnesses to your attention that we're requesting. We anticipate our rebuttal case will take a day and a half, perhaps 2 days. It's a very small number of witnesses. Any defense in any case has to understand and does understand that the prosecution has a rebuttal right. We do understand that with that rebuttal right and recalling of witnesses, we have to keep it narrow and focused to things that were brought up in the defense's case in chief, which is exactly what we intend to do. We have no intention of going outside the scope of what was raised in the defense's case in chief. So those are our understood parameters. If the court allows this, we do believe that Detective Hermosillo will testify under oath truthfully. He hasn't been influenced. And we do intend to keep all of our rebuttal witnesses isolated to responding to evidence brought up in the case in chief and keep it under that scope.
Judge, that hasn't been responsive to the court's inquiry as to the direction he was going to go in on cross-examination.
Well, yeah, I really think I don't have a ripe issue before me to decide at this point. If you call somebody and there's a reason to move to exclude or not permit their testimony, I'll rule on that. I mean, motions in limine are helpful in alerting the court to matters that may come up to think about or rule upon to not waste your time. But I don't think I have that here. If he's recalled and there's some reason the defense thinks he shouldn't testify, I can hear argument on that outside the jury's presence, of course, and I will if a motion's made. Otherwise, I'm not prepared to sit here and make a ruling and say he can or cannot testify. So that's the court's final comment on the issue on that witness. As it relates to Deputy Cannon, are we just wandering into the same type of what I think is sort of requesting a provisional ruling without a motion here?
Yes, Judge. He might be a more difficult situation for the state. And so.
Okay, well, I'll keep that in mind. And the best I could say is if there is a specific matter, discuss it with the defense. And if there's a motion with some specifics or particulars that the defense thinks should disallow recall of that witness or any other, bring it up. And I will try to take that up outside the presence of the jurors so they're not waiting. But I am not inclined to make any other rulings at this point without motions pending before me. So we'll go ahead and leave off for there for today. Be back on the record with the proposed schedule we have tomorrow. And if there's nothing further, then we'll be in recess at this time. Thank you.
Just wanted to tell you that after reviewing my notes of the testimony of Katie McLaughlin, my view hasn't changed, but I
All right. All right. He knew he was unbalanced. All right, let me get over here to they like stopped and like flew through here. Hold on to the net, like, because I've got like auto play turned on. So hold on, let me minimize this. Go back.
And Judge, may I have the court's permission to approve?
All right. Let me go.
An active shooter.
To day 29. All right. Full screen. Okay. All right. So we're on day 29 now. Yay. Get to see all the good stuff today. Looks like he has a red tie on today. Didn't he just have that red tie on day before yesterday? Got a full courtroom. Red tie. Yep. Ay, 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 ay. All right. Let's get on with it, folks.
Thank you. Please be seated. All right, good morning, everyone. We're back on the record on CR 22-21-1623, State of Idaho versus Chad Guy Daybell, continuing with the defense case in chief. And if you're ready, Mr. Pryor, we'll go ahead and have the jurors brought in.
Yes, Your Honor.
Thank you. All right, please. All right, thank you, Mr. Bailiff. Please be seated. All right, good morning, everyone. We are on the record on KCR 22-21-1623, State of Idaho versus Chad Guy Daybell. We're continuing at this time with the defense case in chief. The court will note all of the jurors have returned and are present. The court's also received the juror affirmation signed by each of the jurors. So thank you again for continuing to follow the court's admonishing instruction as we break each day. At this time, I believe the defense is prepared to call its next witness. Mr. Pryor, if you'd like to call your next witness, you may do so. Yes. Okay, if you'll give us just a minute, we need to get our FTR working. All right, we're ready to proceed, Mr. Pryor.
Judge, the defense would call Dr. Eric Bartlink.
Solemnly swear or affirm that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Thank you.
May I, Judge?
Yes, and Mr. Pryor, as I understand it, this would be testimony offers as an expert witness. Is that correct?
Yes, Your Honor.
Okay, I will not inquire then on the court's exclusionary order. So if you'd like to commence with your direct examination, Mr. Pryor, you may.
Would you please state your name, spell your last name for the record for me, please?
Yes, my name is Eric Bartlink, ERIC. Bartlink is BARTELINK.
And how are you employed, sir?
I'm a professor of anthropology at Chico State University and co-director of the Human Identification Laboratory.
And what is the Human Identification Laboratory?
The Human Identification Laboratory is a forensic anthropology facility, and we provide services to law enforcement throughout the state of California on the recovery and analysis of human skeletal remains related to death scenes and crime scenes.
Okay. And talk to me a little bit about what is forensic anthropology.
So forensic anthropology is a subspecialization of biological anthropology, and it's specifically focused on the analysis of human skeletal remains, including things like estimating sex, age, ancestry, stature, and also things like defects on remains related to trauma, identification methods, and scene recovery of human remains.
Now, you mentioned identification. Would that include situations where there's been suspected burning of the corpse?
The identification part's more about establishing the identity of a deceased person, but we do specialize in the study of burned remains and other postmortem alterations to the body.
Can you tell me a little bit about your educational background?
Yes, I have a BS in anthropology from Central Michigan University, a master's in anthropology from Chico State University, a PhD in anthropology from Texas A&M University.
Are there certain board certifications that you were required to participate in as part of this specialty?
Although it's not required, it's strongly recommended that practitioners become board certified, and I am board certified by the American Board of Forensic Anthropology since 2012.
Okay. Are there any affiliations or organizations that you're associated with or participate with?
There are several, and while these are not qualifications, these are indicate participation in the field. So I am a fellow of the American Academy of Forensic Sciences, and I'm the chair of the Organization of Scientific Area Committees Forensic Anthropology Subcommittee.
And how long have you engaged in the practice of forensic anthropology?
I have been involved with forensic anthropology for about 21, 22 years.
Have you done any publications or research?
Yes, I have published many articles and book chapters, as well as books related to forensic anthropology and other areas of biological anthropology.
And in regards of training of your specialty in terms of fire-caused issues related to the burning and fire, what sort of training have you had in that capacity?
So, throughout my education, I have learned about burned human remains through coursework and trainings and workshops, but I have personally assisted on over 100 burned remains cases. I assisted with like World Trade Center identification efforts, which involved a lot of burned remains. And so, and our team is the main team who does fire victim recovery for wildfire victims in the state of California.
Okay. Okay. Now, you spoke previously about part of your organization is to help law enforcement agencies. Is it primarily your position in aiding law enforcement agencies, or do you help in defense cases as well?
We don't discriminate between whether we work with the prosecution or the defense. So we have assisted the defense in cases where we thought we could provide useful information and perspective about a case.
Okay. Okay. And how have you testified before in front of a court?
I have.
And how many times have you done that?
I think it's around 7 or 8 times, and then I've had other depositions.
Okay. And I think I've asked this before, but I'll ask it again. Is there any specialized knowledge or training that you would be required to have as part of your title as a forensic anthropologist?
Yes, you'd have to be a specialist in the anatomy and biology of the human skeleton. You would have to be able to identify postmortem alterations, including burning on human remains, and be able to properly categorize those modifications. And you have to have expertise in how to identify evidence of skeletal trauma on human remains.
Okay. Okay. Judge, I previously had marked Defense Exhibit 136. My understanding, and I won't speak for the state, but my understanding is the state has no objection to the admission of 136.
We do not, Your Honor.
All right, and Exhibit 136 then is offered and admitted. And can you explain what the exhibit is, Mr. Pryor?
The exhibit is Dr. Bartolink's report, Judge.
Thank you.
And Judge, for ease of use, and for me and probably everybody else, I'd like to utilize the Elmo. My understanding is the state has a copy of the very document as well. And I'd like, for purposes of publication, to use the Elmo device to publish.
Okay, if you'd like to publish a conforming printed copy of the exhibit on the Elmo without objection from, if there is no objection from the state, you can publish it that way.
Your Honor, we have no objection to that.
All right.
Now, Dr. Bartolink, you were contacted by my office for what purpose?
We were asked to analyze the skeletal remains of Tylee Ryan.
Okay. And I'd like you to go through the process of what steps you took to conduct that review and investigation.
Yeah, so me and my colleagues, Dr. Colleen Milligan and Ashley Kendall, came up to Rexburg, Idaho, and did an analysis of Tylee's remains on December 18th. We worked with the Rexford Police Department to unpack Tylee Ryan's remains and to sort them into anatomical position on a table so that we could conduct an analysis. We performed an inventory, which is a tabulation of all of the bones that were present. We also filled in a skeletal diagram indicating which portions of Tylee's remains were present and absent. Because she was already identified, we did not conduct an estimations of sex, age, etc. But we did conduct a trauma analysis by examining each bone to look for any kind of defects or modifications. And we also recorded the pattern of burning across the skeleton.
And the length of time in order for you to do this was approximately how long?
We conducted this in the span of one day, and it was 3 forensic anthropologists working together. And so we were able to conduct that work in approximately a 6 to 7 hour period between the 3 of us.
Okay. So 18 hours between the 3 of you approximately.
No, a total of about 6 to 7 hours with us working all together simultaneously as a team.
Okay. So but the 3 of you were all engaged in work at the same time, correct?
Correct.
Okay. So, and those folks were associates with your organization, is that correct?
Yes, they are professors that work with me in the Human Identification Lab and are professors at Chico State University.
Both PhDs.
Correct.
And both have similar experience and training as you have, is that correct?
Yes, that's correct.
Okay. Now, as part of your review and investigation, you prepared a report, is that correct?
Yes, that is correct.
And I'm not going to go into every word in the report, but in essence, as part of your investigation, what did you discover in regards to the inventory of the remains?
We found that there were certain areas of Tylee Ryan's remains that were absent, and this included large parts of the vertebral column, most of the left and right arms, and large portions of the legs, kind of from mid-thigh down towards the ankle on at least one of the legs.
And Judge, could I utilize the Elmo device at this point?
Yes.
So I'm showing you a illustration from your report, and there is a laser pointer up there somewhere, if you can find it. And then off to your left is a large screen. And if you could just go through in general, the areas that you found were not present at the burial site of Tylee Ryan, and then just basically describe each one for me, if you would.
Yeah, so the way that this skeletal diagram is labeled is on the left side is a front view of the skeleton, and on the right side is a back view. Anything that's colored in black was absent, which means we could not identify those portions of the body in the inventory. So we were missing a little bit of the skull from the left eye socket, a little bit here from the back of the skull. And then if we move down towards the limbs, we're missing almost all of the right arm, except for just the shoulder and a small piece of this forearm bone right here. We're missing almost the entire left arm, except for the shoulder. We are missing most of the ribs, but we were not able to label those individually because we could not determine which rib was which because they were burned and fragmented.
Okay, I'll have you stop there for just a moment. Please forgive my interruption, but when you say fragments of the ribs, is it your testimony that the majority of the rib cage was missing?
I wouldn't say the majority, but a large portion of the ribs were not represented in the inventory.
Okay.
Mr. Pryor, I apologize for the interruption. Could I have a quick sidebar with counsel, please?
Oh, this is tough, tough, tough. Tough, tough, tough. I do wonder, um, you know, what happened to her. I wonder what happened.
Excuse me, Doctor. Judge, may I proceed?
All right, yes, apologies for that interruption on the sidebar. You can continue, Mr. Pryor.
So I think we were at the last we let off, we talked about, I think my comment was the majority of the rib cage, but you said instead it was a large portion of them.
That is correct.
Okay. And then can you continue with your pointing out the different remains that you were unable to locate?
Yes. So as we move down, we can see that from about the mid thigh area, these are the femur bones, all the way down to just a little bit of the top of the shin bone here, the tibia bone. No bones could be found from those areas. And we had a little bit of the right leg here, missing this section down here. And then on the left leg, we have almost nothing represented from that leg, except for a few small fragments. So we're missing fairly large portions of the skeleton.
You're missing large portions of the skeleton.
That is correct.
Now you are an expert in the area of forensic anthropology, and you mentioned that you are involved in the recovery as it relates to wildfire victims in California as well. Is that correct?
That is correct.
And that you have, and I don't know how to talk to you about this, but the part of your job is scientific testing of remains and the impact that they can have with fire. Is that correct?
That is correct.
And you conduct experiments in that regard, right?
And we have done some training exercises, and colleagues of mine have as well, where we have experimentally burned a willed body donor.
Okay, and I'm going to stop you there. What that is in a situation where someone has identified on their donor card that they would be willing to be part of a testing, a scientific testing, and that's how you obtain the body to engage in your testing. Is that correct?
That is correct. And these are for training exercises for law enforcement and for search and rescue personnel.
Okay. And explain to me the process of what you did to run these tests of the will donor body.
So these tests typically involve kind of building what sort of looks like a funeral pyre out of pallets.
Okay, and when you say a funeral pyre, are we talking about a small brush fire?
It's usually multiple pallets, probably around 4 or 5.
4 or 5 pallets.
Yeah, to create enough fuel to burn the body.
So this is a large fire.
Correct.
Would the expression a bonfire be appropriate?
Yes, it would be similar in size to a large bonfire.
Okay. And would it be
Your
possible?
Honor, at this point, I'd like to make an objection and ask for a quick sidebar.
All right, we'll have a sidebar.
I just all of a sudden got very physically sick to my stomach. Like very, very, very. Oh, geez. Hmm.
All right, at this time, the court's determined we need to make a evidentiary ruling and do that outside the presence of the jurors before we proceed further with this. So The jurors will be asked to just please stand up if you would and line up out in the hall, and we don't need a full break. I don't think this will take very long to get through, but we do need to take up that matter, and I think the most efficient way is to do that. So apologies for the inconvenience, ladies and gentlemen of the jury, but if we could have you please exit the courtroom, we'll take up this evidentiary matter.
All right, please.
Mickey, that's kind of what I'm wondering. I mean, I know that they said in the prosecution's case when they had the
All right, thank you. Please be seated.
people there testifying, we
All right,
knew
Mr. Wixom, I understand the state had an objection to this stage of the,
that there was a lot of Tylee's remains that were missing. But mm, 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 mm. I don't know. All right, let's go.
testimony. If you'd like to lodge the objection, you may.
I'm sorry, Your Honor.
You can go ahead. I understood the state was proposing an objection to this particular line of questioning.
We are, Your Honor, and for the record, we are objecting to the line of questioning with regard to the experiment that appears the witness is attempting to go into. The basis for the objection, Your Honor, is that while we did receive a 27-page report from this expert, nowhere in the report that I can see did it reference the particular experiment that's being talked about. The biggest concern the state has is under Rule 16, we're entitled to have a summary report of his conclusions, including the data and facts upon which he relied. When we received this report, we provided it to our two experts and had them look at the report in preparation for their own testimony. Certainly, I'm prepared here today to respond to and to deal with the conclusions in the summary report as provided, but we didn't have an opportunity to have our experts consider the way and the methodology that he may have used in this experiment we didn't know about in preparation for a potential cross-examination here, nor in preparation for the calling of our own witnesses. And so for that reason, as to the line of questioning, any reference to any experiment, we would object to that being admitted at this time.
All right. And if you'll give me a moment, I'm just briefly reviewing through the report. And so that was admitted as Defense Exhibit 136. And your proffer to the court here, Mr. Wixom, is that contained within that 27-page report, there's no mention of an experiment regarding fires. Is that what you're saying?
That's my understanding, Judge, and I believe that's been confirmed off the record.
All right. Response, Mr. Pryor.
Judge, this was part of a training exercise to show how he analyzed and determined burn marks, deciding when and where a corpse and how it was burned. So if the court would like me to rephrase it, instead of rephrasing it as an experiment, I can rephrase it as a training in order to help aid him and his organization in making the determinations that they do as part of this. I'm not suggesting in any way at this point the manner and type in which the remains of Tylee Ryan were burned. What I'm suggesting, Judge, is this was a training exercise that his organization engages in as part of his wildfire training, and that he's describing that this is the methodology that they use to do that in this particular isolated incident. I don't think it's necessary in that situation. This report would be 100 pages if I had to put in every training exercise this expert has engaged in to gain the knowledge that he has.
Okay. So to be clear here, you're referencing as part of foundation or his basis of expertise that he's done this type of training before, but what you are not intending to proffer here is some specific evidence relating to a scientific experiment that would apply to the remains in this case. Is that what I'm understanding?
That's absolutely right, Judge. This is a foundational question that deals with Dr. Bartling's experience and how he makes determinations in terms of folks who are victims of fire.
Okay. Any further argument or response from the state?
Judge, with that proffer, the state would withdraw the objection. It wasn't referenced in the report, so we didn't have a proper understanding. But if it's limited to that purpose, we withdraw the objection.
Okay. And I would find it proper in terms of foundational for expertise to be established under Rule 702. And so with the state withdrawing that, we'll go ahead. If that's where the testimony is heading, Mr. Pryor, we'll let the jurors back in. Of course, if it were going into a realm of some specific experiment that took place relating to the evidence in this case, then likely the objection could be renewed, and I would then issue a further ruling.
And Judge, for clarity with the jury, I think what I will do is rephrase experiment, and with the defense or with the state's permission, I'll use the word training. And that might alleviate any confusion the state might have with where I was going.
Okay, and I think that would help clarify things. So thank you, counsel. We'll go ahead and have the jurors brought back in and you can continue with your line of questioning, Mr. Pryor.
Thank you.
So for me, yes, QB. Yes, yes, yes. QB says, if this is too much, y'all, please step away. This is hard to hear. No one will fault you. We'll be here when you return. Self-care is of the utmost importance. Absolutely. But I think what made me physically ill at the point when I'm feel okay now, but man, I got like a big whoosh of nausea that came over me. And it was right at the point when they were talking about examples of the sizes of fires. And when he said the equivalent of like a bonfire, it just, oh, I just got sick, sick. Um, so yeah. All right, let's get back to this. Blah.
All right, thank you, Mr. Bailiff. Please be seated.
I'm good
All right,
now,
Mr. Pryor, if you'd
QB.
like to
Thanks,
continue on your
Dave.
direct, you may.
All right, and Judge, I'll start with Dr. Bartlink. We were talking about a training that you were participating in terms of utilizing a donor, a willing donor, and engaging in the intentional burning of that donor for purposes of scientific training. Is that correct?
Yeah, it's a part of a training course.
Okay, and can you elaborate on what that encompassed?
So essentially setting up something that would be similar to a funeral pyre, but having multiple pallets stacked and cutting out sections of those pallets. So you'd have pallet underneath the donor as well as on top. And we're trying to achieve a certain level of burning in the study. And so it requires the use of a fair amount of fuel source. In this case, it was the wood pallets.
Okay, and when you're talking about a fair amount of fuel source, is that a significant amount of fuel source?
You need combustible materials, and so a body does not easily burn without having combustible materials. And so using wood is an effective way of achieving a large fire to reduce a body's mass down to the bones.
You used the expression funeral pyre. That would suggest a sizable fire.
Yeah, like a large bonfire.
Okay. And would the use of just gasoline, would that obtain the same result?
So typically accelerants don't generate enough fuel. They burn away quickly, so they don't generate enough fuel to sustain combustion of a human body for a long period of time. So usually you need other types of combustible materials.
And in regards to in regards to a funeral pyre as such, so if I understand you correctly, just the use of gasoline on a
So, Mickey, I think the reason why they want to get into this is because Tylee's remains were burned. And I think that they're wanting to sort of get to his understanding of why the skeletal remains looked the way they did. And he has that training because he is an anthropologist and he has training in burned corpses. So, okay.
donor corpse would not achieve the burning to obtain the results you're looking for.
In my experience, no.
Okay. It would have to require a significant amount of when you say, I think you used the term fuel, that would be wood.
Could be wood or other types of combustible materials.
Okay. Okay. Something that would burn easily
That's correct.
in a large quantity
That's correct.
to generate a significant fire
Yes.
over a long, prolonged period of time
Yes.
to obtain the same result.
Yes.
Okay. Now I'd like to go back if we could utilize the Elmo again, Judge.
Yes, you may.
You pointed out in black on this illustration, all of the remains that were not present when you did your review and investigation. Is that correct?
That is
Sorry, I keep starting and stopping. Um, Nikki said, I think it just makes Chad look worse. So I'm wondering if, because the vast majority of her remains, skeletal remains, are missing from the burial site, Pryor is trying to um get to the point. I think what the point he's trying to make is that Tylee was not murdered and dismembered on Chad's property. It happened somewhere else. And because of that, Chad didn't know anything about it. Blah, blah, blah. And he's trying to separate that from Chad. That's what he's done through this whole defense. I mean, with the phone pings, with the DNA, now with the anthropology guy here. He's trying to separate Chad from the whole thing. So, the lemon that went to hell by Chad Daybell. The lemon that went to hell by Chad Daybell. It rhymes. It should rhyme. All right, you guys, I'm going to take a quick potty break. This whole donated corpses and fires and burning and stuff is again making me a little sick at my stomach. I'm going to go take a potty break, and hopefully when I come back, they will be done talking about this matter.
correct.
Would the use of a fire be the explanation as to why you didn't have a complete skeleton?
Only partially. So there were bones that could not be identified to a specific skeletal element, but there was so much missing that was not accounted for. So I believe there are a large amount of these remains that are actually missing, but a small amount are bones that I could not identify what they were.
So you reviewed the testimony of the excavation of the site with the bulldozer. Is that correct?
I did review the reports on the excavation of the remains.
And that they used a bulldozer and took care to try to locate all of the remains. Is that correct?
I believe so, yes.
And yet they didn't have the remains.
I don't know where the missing remains are, so I can't comment on.
Okay. But in fact, you don't have all of the remains, correct?
That is correct.
And you believe that the remains cannot be determined to have been burned out or disappeared as a result of a fire. Is that correct?
Not entirely. Yes, that's correct.
And there are bones missing.
Yes.
Okay. Significant amount of bones missing, right?
Yes, you can see from the skeletal diagram, everything in black was not identified in the remains.
Now I want to continue with your report. Were you able to make a determination as to whether the body was burned as being intact?
Based on the burn pattern, I do believe that the most likely possibility is that the body was burned as a whole, not in pieces.
Okay. And would it be fair to say you can't make a determination as to the length of time it would take to burn the body?
We could only provide sort of minimum timeframes, but there's, how much fuel is used, the size of the body, and other factors all can alter those parameters.
So there's no definitive way to determine how long it took to put Tylee's remains in the manner in which they were found. Is that correct?
That is correct.
In addition, there were some fragments, and I want to use the word fragments because in the fire pit, there were some objects that were removed from the fire pit. Do you recall seeing that?
Yes.
Are you able to determine what type of fragments those are?
Most of the bones that were in the fire pit lacked diagnostic characteristics, so they could not be identified as being either human or animal.
Right. So we don't know what those fragments were. Would that be fair?
That is correct.
Okay. You noted that there was a canine mark on part of the remains of Tylee. Is that correct?
That was not something that I noted, but had been noted by the anthropologist with the FBI.
Okay. And do you recall the location of that canine mark offhand?
I believe it was on one of the shoulders, so where the shoulder connects to your shoulder blade. I don't remember if it was on the left or right side, but it's, we made those observations and did not see evidence of scavenging. But sometimes making those determinations is very challenging.
And I said canine, I meant carnivore.
Yes.
So we don't know when a carnivore may have made those marks on the body. Is that correct?
We do not, and I'm not certain if they're carnivore marks or related to the burning process.
Okay. I want to talk to you about whether you can make a determination as to where Tylee Ryan's body was burned.
I cannot make that determination.
So in other words, you can't make the determination that her body was burned on Chad Daybell's property. Is that correct?
I cannot make that determination.
And you can't make a determination as to the day or time that the body was burned. Is that correct?
That is correct.
What you can make a determination is that the body was burned intact to your best opinion. Is that correct?
That is correct.
Okay. And you can't make a determination as to whether the body was burned and then at some subsequent time placed in Chad Daybell's backyard. Is that correct?
That is correct.
Okay. Judge, I have nothing else at this point.
All right, that'll conclude the direct examination then. Mr. Wixom, I presume will be doing cross. Is that correct?
Yes, Your Honor.
Okay.
Good morning, Dr. Bartlink.
Good morning.
Am I saying that correctly? It's Bartlink?
You pronounced it perfectly.
Yes, thanks. So, Dr. Bartlink, you've already, I think, shared with the jury that in preparing and in conducting your own analysis of Tylee's remains, you looked at the autopsy report that had been done on Tylee. Is that true?
That is correct.
Likewise, I think you've indicated that you did review the FBI reports from Dr. Angie Christensen and a report from Dr. Halapaska. Is that true?
I did, yes.
Okay. And you have a professional relationship, or at least a collegial relationship with Dr. Angie Christensen, don't you?
That is correct.
In fact, I believe you both published something together.
We are co-authors on a textbook.
Okay. So is it fair to say that she is a colleague that you have respect for?
Judge, I'm going to object witness bolstering.
Sustained.
When you reviewed her report and Dr. Halapaska's report, didn't you indicate in your own that when you compared your findings with theirs and with the autopsy, that you found no substantive difference in the analysis of Tylee's bones?
That is correct.
And you were asked a question by the defense about the ability to estimate a time with which it took to burn Tylee's remains. And I think you concluded that that's not possible. Is that right?
There are just too many variables that are unknown, so I would not feel comfortable making any kind of determination.
In fact, in your report, wasn't that a question that you were specifically asked by the defense in preparation of your analysis?
Yes.
Okay. And the question was, can you burn Tylee's bones within a 2-hour period? That was the question.
That was the question, yes.
Okay. And as I recall from your report, you said it's possible, but you can't determine that. Is that fair?
That is correct.
Likewise, I think you were just asked a question about the ability to determine whether or not Tylee's remains had been burned on the Daybell property. Recall that question.
Yes, I believe I do.
And I think you answered that it's not possible to make that determination, correct?
That is correct.
So is it fair then to say that it may well have been that her remains were burned on the Daybell property?
Judge, objection, offer speculation.
Well, overruled.
You may answer.
It's certainly possible that she could have been burned on the property, but it's also possible that she could have been burned elsewhere.
Fair. I think you indicated that there were, no, you've already indicated that not all of the bones from Tylee's remains were found by the FBI or the search you conducted, it correct?
That's correct.
And you can't tell whether or not all of the bones have been entirely burned out because you don't have all of the bones. Is that fair?
Yes. In my experience, we still would expect to find large portions of the bones that were missing even after the burning process has completed. But there are some bones that were just too fragmented to identify. So some of those could just be those bones, but there's still quite a lot not accounted for.
And didn't you indicate in your report at some point that it's possible there are still bones that remain on the Daybell property?
It's judge, objection, speculation.
Overruled.
That is a possibility.
And just to be clear, it's true that there were many of the remains that you analyzed that were subject to thermal damage, correct?
That is correct.
They had been burned.
Yes, that's correct.
Yeah. And in fact, you had found a number of the remains to have had blunt force trauma. Is that correct?
That is correct. Blunt force defects consistent with perimortem trauma.
Yes. And with respect to defects, in fact, didn't you find that I believe the left mandible, I'm going to call it the jawbone if that's not correct. Let me know.
That is correct.
Okay. That the left mandible had been fractured. Is that correct?
That is correct.
I think in 6 different places.
I can't remember the number of places, but there were fractures to the left side of the mandible.
And you did determine that that had been from a blunt force trauma.
Yes, although unable to tell if it's before or after death.
So you can't make the perimortem versus postmortem distinction, but you still believe it was blunt force trauma.
Correct.
Likewise, I think you determined in your analysis that there was blunt force trauma on the skull, the sternum, and the ribs. Is that right?
That is correct.
And there were sharp form defects in the innominate or the hip bone. Is that right?
That's correct.
The sacrum
That is correct.
and the cervical spine.
The ones on the cervical spine are possible sharp force defects, but could not make a definitive determination on those.
And with respect to the sharp force defects, you did indicate that you can't exclude as some of the instruments that may have caused those to have been either a shovel or a pickaxe, correct?
That cannot be excluded. I believe I provided a long list of possible implements.
And in fact, I think you confirmed that some of those traumas could have been from a chopping force. Is that right?
That's correct.
And you indicated a machete may have been used.
That can't be excluded.
And I think finally, you had indicated that there had been some rib fractures. Is that right?
Yes, I believe there were at least 2 rib fractures documented in the report.
And you likewise believe that they were likely caused from blunt force trauma?
Yes, consistent with blunt force trauma.
Finally, I think in your report, you indicated that there were approximately a total of 18 sharp force defects in Tylee's bones, as well as a minimum of 16 impacts that were possible perimortem impacts on Tylee's bones. Is that correct?
That is correct.
Thank you, sir. Your Honor, I have no more questions.
All right, thank you, Mr. Rickson. Mr. Pryor, you can conduct redirect if you'd like.
And thank you, Your Honor. There is no distinguishable way to determine the location, I mean, the specific place where this blunt force trauma took place, is there?
And there's not.
Judge, I have nothing else. Thank you.
All right, that will conclude then the testimony of Dr. Bardenlink. So I'll inquire next, counsel, if he's to remain under your subpoena, Mr. Pryor.
He is not, Judge.
Okay, you are released then from the subpoena. Thank you for appearing and testifying. You can be excused. All right, Mr. Pryor, does the defense have a next witness to call?
Judge, could we have a sidebar just very briefly?
Yes.
Sidebar City. Let me check in here with you guys in the chat. Sorry, I was just blowing my nose. Mickey says this witness is an expert brain fart. Witness is falling apart. And Mickey says, I didn't know that. Didn't know what, Mickey Joe? I'll take care, sweet Brenda. Oh. Oh, about her jawbone, her mandible. I don't know. I don't know if I remembered that or not. I don't know if I remember that or not. I don't remember if I heard that or not. All right, you guys, these sidebars are longer than they should be. Stop it. Let's go. Who's the dude standing back there in the blue jacket with the shorts on? Who is that standing next to Larry Woodcock? I can't tell who that is.
All right, thanks, everyone. At this stage of the proceedings, then, we do need to take up another issue outside of the presence of the jurors. And although it's a little sooner than typical, I think given that this will take a few moments, it's just logical to take
Well, Haley.
have the jurors take the mid-morning recess. We'll take this matter up outside of the presence of the jurors. And so we will have that, and then we'll take a break as well at the end of the matter we take up outside the jurors' presence. So if we could have the jury excused at this time for the mid-morning break, we'll do that now.
All right.
Hi, Lee. Thank you for the snacks. Hello, 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 hello. All right, let's zoom through again, see if we can.
All right, we're on the record now. Outside of the jury's presence, the courtroom's still here in these proceedings. After sidebar with counsel, the court's been advised that at this point, the defense does not intend to call any further witnesses. So I guess the remaining issue or question to address would be whether or not the defendant's going to testify. Mr. Pryor, is that the status of where things stand with the defense case in chief?
Yes, Your Honor.
Okay. Mr. Daybell, I will instruct you that there is going to be a jury instruction in this case the court's going to give. It states, and I'm paraphrasing, that you do have a constitutional right not to be compelled to testify. The instruction will say the decision whether to testify is left to the defendant acting with the advice and assistance of the defendant's lawyer. The jury will be instructed not to draw any inference of guilt from the fact the defendant does not testify, and the jury will be instructed not to discuss or enter into deliberations the issue of the defendant chooses not to testify. If in fact you are going to testify, then Mr. Daybell, there's a further admonishment or advisement I would give you going forward. So let me begin with Mr. Pryor and just first just inquire whether or not you have discussed with your client whether or not he intends to testify.
I have discussed that matter with Mr. Daybell, Your Honor.
All right. And does he intend to offer testimony in this trial?
He does not.
All right. Mr. Daybell, have you in fact discussed that issue with your attorney?
Yes,
And has he advised you of your right to either testify or not be compelled to testify in this trial?
he has.
All right. And it's your decision to not testify. Is that correct?
That is correct.
Okay. Thank you, counsel. I appreciate you clarifying that with the court outside the presence of the jury. So with that, then we'll take our morning recess, and I will ask the defense then in the presence of the jury if they rest their case. And again, the court will provide the instruction to the jurors that they may not consider the decision of the defendant not to testify in their deliberations with that instruction that will be provided. So we'll take the mid-morning recess, and let's come back on the record in about 15 or 20 minutes, and we'll continue with further witnesses from the state if there are any in the defense resting.
Yeah, big surprise. Big surprise. Mickey says, good call. Margaret says, Pryor, you're not testifying. Lemonhead, why? Pryor, because you're an absolute nutbag. A banana nut bag. Okay. All right. Let's get on. Let's get on. I had already had a spoiler alert. Thanks, QB, that he wasn't going to testify, but I knew, I didn't figure he would anyway. Didn't figure he would anyways. It's smarter of him to not. Not that he's gonna get, I mean, he's already, I mean, whatever. But it's smarter for him to not.
Thank you. Please be seated.
Okay, let's get on with it. See if the state's putting on, well, the state is going to start their rebuttal.
All right, thanks for your patience, everyone. We've been tending to a bunch of administrative things this morning while the jurors have been in recess. We are back on the record at this time. If you'll give me just a moment.
Oh my goodness. Hey, Patricia, good to see you. So they're going to rest. How long has it been in weeks? Patricia, they are resting defense. State starts their rebuttal. As far as weeks, it's been 29 days. So 1, 2, 3, 4, 5, 10, 15. We're at about what, 6 weeks? Does that sound right? They said 6 to 8 weeks, so I feel like they're right on. Yeah. Billy said he'd probably I love that. He'd probably be afraid he'd burst into flames with his lies, right? Mickey said, "No, I knew he wouldn't testify. He just can't speak. He shows his ignorance." Margaret says, "What would he even say anyways with his non-moving lips when he talks?" Big old lightning bolt come right down through that courtroom, right? You guys are right on the money. All right, we're gonna get on with it. I want to get into this. Rebuttal. Let's see what happens.
So going on the record on CR 2221-1623, State of Idaho versus Chad Guy Daybell. The courtroom's open, public present. The jurors are not here. While the jurors are not present, I understand, first of all, the defense intends to rest, and in order just for efficiency, perhaps out of order here, there was an issue that came up with a proposed state's witness that would be testifying this morning. And I think in the interest of time and avoiding a subsequent break, if the parties don't have any objection, I'd like to take up that matter if we could on the proposed testimony of Deputy Cannon, I believe, is the witness. If there's something to discuss or determine outside the jury's presence, perhaps, I don't know if council's discussed that, but that was the information I got. So Mr. Wixom, is the state intending to call him after the defense rests?
Yes, he would be our next witness if the court allows.
Okay. And where it's going to be your witness, Mr. Wixom, if you could just make a proffer to the court about what you think may be the issue, and then I'll see if the defense has any either motion or response to his further testimony in your case in rebuttal.
Thank you, Your Honor. I might just do 3 things. One is what we think he'll say, why we think it's important that we be allowed to call him to say it, and then some legal authority that we think the court can look to.
All right. And before I guess we get there, I should confirm, Mr. Pryor, any objection to taking up that issue out of order before you rest?
No, Your Honor.
Okay, thank you. So, Mr. Wixom, then if you'd like to proceed with the points you were going to make, I'll hear from the defense after that.
Thank you, Your Honor. With respect to the first point, what we believe that Deputy Cannon will testify to if you allow him to be called again is that back on October 9th of 2019, when he responded to the attempted shooting call regarding Tammy Daybell, he will testify, and I suspect adamantly, that at no time was he ever shown anything on a computer screen, any pictures. In fact, he'll testify he didn't even set foot, as I recall, into the house. If he did, it was just barely through the doorway. That's the first point of factual point. The second factual point that he would testify to is that in responding, he was in fact approached by Joe Murray, who did tell him that Joe was outside and heard Tammy scream. And so those are the 2 factual points. We believe that it's important because we've heard testimony very recently from Garth Daybell and from Joe Murray that we feel like we need to rebut on those very points, to contradict those points. The concern I'm sure the defense and the court will have, and we recognize it as a concern, is that we've already called Deputy Cannon. He did not testify to those points before. Well, he certainly did not testify to the point of be shown the computer screen. I don't have the record of his earlier testimony, so I don't want to speak out of turn, but I don't recall that he testified as to the issue of Joe hearing Tammy scream. Your Honor, with the first issue of not being shown anything on a computer screen, that first came up after we released Deputy Cannon. So he was released. So he's not subject to the formal exclusionary order. We see this as a potential issue for possible taint. When he was released, he went back home. He did listen in part to Detective Kai Kamano's testimony. And I think there was a second witness that he had listened to. During Detective Kayakamano's testimony, I think it was cross, he was asked about the issue of whether or not a picture of a paintball gun on a computer screen had been relayed or shown to Deputy Cannon. Deputy Cannon heard that, and Cannon contacted our office immediately and wanted to come set the record straight. Well, he just heard testimony. So we saw that as an issue. I think we may have even approached that off the record of the court. We didn't call him back in our case in chief. But now the defense has put on this evidence. And on the first point, if the court might recall, and again, I don't want to mischaracterize how the testimony came in, but when I was cross-examining Joe Murray on the point about whether or not Joe had heard Tammy scream and had been outside, I had even opined, leaving the door open directly in my questioning, to the fact that Deputy Cannon may simply have misheard or got something wrong as a mistake. And the witness was very adamant that he did not accept that as reality. He thought it was intentionally inaccurate information. So effectively, Deputy Cannon, his character has been attacked. He's been called a liar in front of the jury. So he wishes, and I think understandably so, whether that's a big factor for this court, he wishes to be able to come and to offer what he believes is the truth, which is simply that that never happened. Now, going to the Tain issue, I should further tell Your Honor that when he contacted us after his testimony, we instructed him to stop watching the trial and listening, and he did. After so much time passed and then our case rested, he began listening again, and he listened to Garth Daybell's testimony as well as Joe Murray's. So I need to disclose that. As is being pointed out, in our case in chief, we did try to formally call him back, and I think we addressed it with the court, and we were not allowed because he had been listening to testimony, and we understand that. Why we think it's different and why it would be unusual, Judge, is first of all, we looked to Idaho Rule of Evidence 615. It says, at a party's request, the court may order witnesses excluded so that they cannot hear other witnesses' testimony, or the court may do so on its own. But the court has full discretion to decide what to do in this instance. Then I would further just point to the court to a rule I don't often hear cited in legal proceedings, but it's nonetheless there, Rule 102 of the Idaho Rules of Evidence. Stands for the very basic proposition that these rules should be construed so as to administer every proceeding fairly, eliminate unjustifiable expense and delay, and promote the development of evidence law to the end of ascertaining the truth and securing just determination. The state's position is that, particularly with that first point, it simply is not true that Deputy Cannon was showed any pictures of a paintball gun on a computer screen. And frankly, on the second point, Your Honor, Deputy Cannon his character has been attacked. He's been called a liar. And so we feel like in the interest of trying to ascertain the truth and to secure a just determination on these very narrow issues that we should be allowed to call Deputy Cannon. I will note to the court, I did go back and look at an October 9th report from Deputy Cannon and then a further subsequent report of an interview of Deputy Cannon by the AG's office. And there's nothing in there that contradicts what he might testify to. Frankly, if it never happened, there'd be no reason to see any reference in the report that he was shown any pictures in a computer screen because it said it never happened. So that's really where we're at, Judge. We understand that there's an issue. He has watched testimony. We do think on these very narrow points that the court should allow us to call him.
All right, just to clarify there, Mr. Wixom in prior testimony, and I'm of course thinking back over it as well, but you said a couple of times he's been called a liar. I don't know that the term he's a liar came out in testimony, did it?
No, I agree. That was just a characterization of
Okay, so there's been a clear contradiction, you could say, in testimony between two witnesses. I wanted to make sure I didn't recall hearing anyone refer to him as a liar other than an argument here. Is that accurate?
He never used that word, Judge, but as I recall, his characterization of Deputy Cannon's version of the facts was that there had been some intentional inaccuracy. I'll leave it at that. But he did not use an inflammatory word like liar. He did not do that.
Okay, thank you. All right, Mr. Pryor, then there's a proposal by the state in their rebuttal case to call witness Deputy Cannon. You've heard the argument and understand, I'm sure, the issues here, and also that he's also been listened to subsequent testimony. What's the response from the defense on this proposed witness testimony?
Well, Judge, there's a couple of things I'm still a bit confused about. They're going to suggest that at no time, one, that Deputy Coulter viewed a video that was claimed that he viewed. Is that one, Mr. Wixom?
Yeah, I'm not sure that there's a video, but I think the testimony from your witness.
Computer.
Yeah.
It was a Google search of
Google search. Yeah. And two, at no time that Deputy Coulter was inside the home. Is that what the other one?
I believe that what he would say is he had just put his foot into the door and just barely crossed the threshold, but he didn't go inside the home to talk to anybody other than Tammy.
Okay, so Judge, one of my concerns is that we went over his statement at the time of his testimony on cross.
And one other point there, there's a second also statement about him talking to with Joe Murray and whether he heard a scream, I think, that someone said that she screamed or he heard a scream. So that's a separate issue as well that you can address if you'd like. Sorry to interrupt.
And Joe, and Judge, one of the difficulties, Your Honor, is this, is that, you know, in reviewing Officer Coulter's report, the very first sentence of his report, and I quote, "On October 9th, 2019, at 21:40 hours, I was talking to Tammy Daybell in her front room of her home." So for Officer Coulter now to say, well, you know, I only just stepped in. Well, that's not what that's suggesting. The first sentence says he was talking to her. And lo and behold, Judge, that computer is in the front room of the home. And he was there long enough to then identify the fact that Garth and his son, or Garth and Chad, were at the front door leading into the kitchen. The concern I have is this, Judge, is that this witness was called, he was cross-examined, and then there was the ability to recross. And now what's happening is they don't like the tone of what was testified to, and the evidence isn't favorable to them. So what they're going to do is engage throughout this rebuttal in a process of trying to discount everything that we've presented in our case in chief. And they're going to start with Officer Coulter and pick these little things that they can differentiate. And they shouldn't be allowed to do it. That's not what rebuttal is all about. They can challenge evidence, but they've excused this witness. They've excused this witness, and this witness has now been tainted by looking at all of this other evidence, by reviewing all of this other evidence. And Judge, you're right. I never called Deputy Coulter a liar. Did I challenge his accuracy of what he said? Absolutely. That's my job, to challenge witnesses as to what their statements are. And the state had a chance to recross, and they elected not to go forward any further and inquire. And now after the case is over, it's sour grapes, and they don't like what has been presented, and they've got to figure out a way to try to punch holes in any little thing they can. The only problem is this witness has already been tainted. So tainted, Judge, that he's offended by Mr. Wixom's own statement that in some way I've somehow called him a liar. Well, that sounds to me that we don't have a witness who's going to get up there and say, you know, anything that's consistent with his report. What he's going to try to do is prove that he's not a liar. And that's not what this was designed to do. Rebuttal is a whole other purpose. And on the issue of 615, Judge, and excusing witnesses, that's designed when a case starts, and by motion, either party can make a motion to excuse witnesses. That has nothing to do with after the state rests their case, and suddenly they decide that, oops, we shouldn't have released Officer Coulter, and now on second thought, let's bring him back and let's take another crack at the defense's presentation of evidence. I wholly object to this tactic. And if the court opens this door, you're going to open the door to a litany of rebuttal that could go on for days, and it's highly inappropriate.
All right, Mr. Wixom, any responsive argument before I make a ruling here?
Very quickly, Judge. Frankly, Judge, it's certainly not a tactic. Rebuttal is something built into the rules, built into the system. It's part of the litigation of a criminal case. With respect to some more specific points, the state can't anticipate when we do release a witness that inaccurate testimony is later going to be offered by the defense. And that's what we think happened, particularly at the questioning of Detective Kayakamano. In fact, as I recall, I think it was defense counsel who offered that. No witness did. He offered that in a cross question. This idea of being shown something on a computer screen. We can't anticipate that coming in. And so certainly not a last minute tactic. What we have is a situation where evidence has came in that our witness was not directly cross-examined on or directly examined on. We couldn't foresee that these kinds of questions would come up because our positions, they simply aren't true. And so we believe that we're simply applying the basic function of rebuttal, which is to consider evidence that's presented by the defense and then responding to it. That's what rebuttal testimony is. I will acknowledge again to the court, I think the fair concern is whether or not his testimony may have been tainted now by the fact that he's listened to more other portions of this case. We don't think he will be. If the court has questions, he's available for questioning by the court on the stand to explore whether or not he's been tainted, and to voir dire him or the defense counsel if the court permits that. So we certainly, we do believe that these are things that need to be addressed. We didn't have a fair chance to address them. That's what rebuttal's for. We don't think he's been tainted. And so we simply ask the court to give us the opportunity.
All right. Well, I'm considering this. I will note a couple of things. First of all, in terms of the propriety or impropriety of calling him in rebuttal, I do agree with the state's argument here that in a case, the state bears the burden. And so it is the state that's allowed an opportunity for rebuttal witnesses to come in and testify. In this instance, there were some narrow topics that came up in the course of the defense case in chief, which are subject to rebuttal, including this issue of whether or not there was, showing of pictures on a Google search in the residence, as was testified to contradictorily between the witnesses. and also comments that the deputy said, including whether someone said they heard a scream. So it's not improper in any way to allow for rebuttal of those statements. The thing the court is weighing a little more cautiously here is whether or not now the court should permit the witness to return after the witness has been observing or listening in on the testimony. And the court would note that the exclusionary rule under 615 governs that. It's discretionary with the court. There's a lot of cases out there that say that. State versus Slauson 124 Idaho 753, the granting or denying of a request for exclusion under 615 is a discretionary decision of the trial court. And whatever the remedy is also up to the court in its discretion, according to State versus Christensen 100 Idaho 631. So I don't have any hesitation determining that this would be appropriate rebuttal. The real question then is whether or not the witness testimony has potentially been tainted, where the witness, having been released by the state, observed the trial proceedings, and the witness would be placed under oath and sworn to tell the truth. So I'm not making any speculation that Deputy Coulter Cannon would not just come in and tell the truth, but the observation of that trial testimony on those very points is somewhat concerning, where the court ordered an exclusionary order for the witnesses when this case started because of the manner in which public access has been provided and the whole case has been live streamed. And essentially, when witnesses are permitted to view and listen to other testimony, whether they do it intentionally or subconsciously, there's certainly an opportunity for a witness to know exactly what they're going to be asked about, how they would respond to that, think through what some other witness said. And in a typical trial, you just wouldn't be allowing the witness to sit in and watch other witnesses to prepare for additional testimony. So quite honestly, I have vacillated back and forth on this second part of whether or not his observation of the testimony should result in him being excluded from offering this rebuttal testimony. Clearly, the door was opened by the testimony that was given in the defense case in chief. But upon weighing out the discretionary function the court has here and looking at whether or not I think there might be some prejudice that could result from allowing the witness to return and testify after hearing the contradictory testimony does cause me some real concern. And so and I very much appreciate the candor of the state in revealing that Deputy Cannon has listened to the testimony, which further goes to me indicating I think he's clearly and honest in the testimony he's provided at trial in terms of at least what he's testified to under oath in his recollections, as well as notifying by proffer to the state and again to the court that he has in fact heard some of this testimony. So I have no reason to personally question his credibility, but again, the ability to have heard that testimony, and even if it's subconsciously just being allowed to prepare for that, I think ultimately is at least an appearance of impropriety or perhaps an unfair advantage a witness would have if they took the stand on those very issues, knowing exactly what somebody else testified to. So the court is going to not permit his testimony in the case in rebuttal on those topics, not because they're improper rebuttal, but because in this particular instance on these particular topics, he was able to know precisely what was testified to. And with the defense objection, I think it is proper that the jury will be just left to consider not which version of the events they do believe. So for that reason, I am going to grant the motion of the defense to exclude the testimony of Deputy Cannon. So that's going to be the court's ruling on that issue. Mr. Pryor, do you have any questions on that?
No questions, Judge.
Any questions from the state?
No, Your Honor.
Okay, thank you, counsel, for bringing that up to my attention outside the presence of the jurors. At this time, then, we'll go ahead and bring the jurors back in, and then is the state going to have additional rebuttal witnesses today?
Yes, Your Honor, we're prepared to call another witness.
Okay, thank you, counsel. We'll have the jurors return to the courtroom then, and then Mr. Pryor, where we left off is without you having yet rested, so I'll bring up that issue in the jurors' presence, and then we'll proceed if there's rebuttal witnesses by the state this morning.
Thank you, Your Honor.
I'll see you later, Gail. Thanks for coming and hanging out with us today. Yeah, I agree too that if he hadn't had looked at the previous testimony or watched the previous testimony, then that would be a different story. But mm-mm-mm.
All right, thank you. Please be seated. Okay, we're back on the record now on KCR 22211623, State of Idaho versus Chad Guy Daybell. We had a morning recess, went much longer than anticipated, but we were conducting some court matters outside the presence of the jurors and as well as other matters that led to the break being extended. So I appreciate everyone's patience as we move through the morning. When we left off, I had inquired whether or not the defense had another witness to call at this time in its case in chief. Mr. Pryor, does the defense have another witness at this time?
There will be no further witnesses, Your Honor. Defense at this time rests its case.
All right, thank you, Mr. Pryor. At this time then, what occurs next is an opportunity for the state to present any rebuttal testimony through rebuttal witnesses. Does the state intend to call any rebuttal witnesses?
We do, Your Honor. At this time, we're prepared to call Lisa Marie Jensen.
Very well. If you want to call your rebuttal witness, then we'll have that witness brought in and sworn.
Solemnly swear or affirm that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God. Yes. Okay.
It's a little bit weird.
Thank you.
All right, at this time, Ms. Jensen's been sworn. Before we have further testimony on rebuttal, Mr. Wixom, I am going to inquire on the court's exclusionary order. Ma'am, have you observed any of the trial testimony that's occurred since this case started?
No, I have not.
Okay, have you talked to anyone else about any testimony they have given in trial?
No.
Okay, thanks for your responses. Mr. Wixom, if you'd like to inquire on direct, you may.
Thank you, Your Honor. Ma'am, will you please state your full name for the record and spell it?
Lisa Marie Jensen, LisaMarieJensen.
Thank you. And can you please tell the jury, where is it that you live?
I live in Sugar Salem, Idaho.
And what do you do for a living?
I am an educator at Central Elementary
Okay. And where is that school at?
in Sugar Salem,
Yeah.
Sugar City.
Do you know a Tammy and an Emma Daybell?
Yes, I do.
Tell the jury how you know them.
I run our Title I department and I supervise paras, and I hired Emma as one of my paraprofessionals before she was hired as a third grade teacher. So we worked together, and Tammy Daybell was our librarian and computer specialist.
And I want to draw your attention back to 2019, particularly the beginning of the school year. During that time frame, was Tammy someone who you would regularly interact with or see at the school?
Yeah.
Can you explain what occasions you'd have in the line of your work to interact with her?
Yeah, we didn't, our jobs didn't align necessarily. She was the librarian. Many people often think, oh, you're the reading specialist, so you must work closely. But we just were mostly friends and colleagues at the school.
Did you see her do her work at the school?
Yeah.
How often would you see her doing her work?
A couple times a week.
Okay. And what kinds of things do you recall observing her do while she was working?
She ran our library. She did our computer specialist. She was our go-to if there was something that needed to be done and we didn't know who to do it. Tammy was our girl.
Did you have a chance to observe any physical activities that she did in her work?
Judge, I'm going to object at this point. It's going beyond the scope.
Overruled.
You may answer.
Will you repeat the question?
Did you have an opportunity to observe any physical activities that Tammy did at her work?
Just normal day-to-day physical activities, yes.
Could you describe some of those things to the jury, please?
As educators, we're just on our feet a lot. She was back and forth between the library and the computer lab. She also did recess duty, so she was just all over the school a lot. She was busy.
Overall, do you feel like you had the opportunity to make general observations about her health and wellness?
Sure.
What did you observe about Tammy?
About her health,
Yes, ma'am.
that she was well and healthy, and she strived to keep herself that way.
Judge, I'm going to object at this point without any additional foundation.
Overruled.
Any other observations about her health?
She was well.
You just used the word, she strived to keep herself that way. Can you explain to the jury what you meant by that word?
Yeah, she, every day, even if she had on a dress, she would wear her tennis shoes. I loved that. She, she aimed to get steps in. She participated in exercise
Judge,
classes.
I'm going to object at this point without some additional foundation.
I'll sustain that.
You just mentioned something about steps in. Can you explain to the jury what was the observation that you made and when did you make it about seeing Tammy get her steps in?
I don't know when I would have made that observation, just in the time that I knew her, but she would wear a Fitbit. She exercised frequently.
Judge, I'm going to object at this point and move to strike. There's no foundation to support that.
It's overruled. You can cross on that, Mr. Pryor.
Did Tammy ever, particularly during that last few weeks before her passing, did she ever complain about being sick or feeling unwell?
No,
Do you remember her missing work at all?
no,
In the context of observing her do her work, the physical aspect, did you ever notice her to get tired or exhausted?
no,
Did she ever seem winded to you?
no.
Your Honor, at this time, I have a line of questioning that may involve an evidentiary issue. I think it can get resolved in a sidebar. I don't think it should be brought up in the presence of the jury, but may I ask to have a sidebar?
Yeah, we can have a quick sidebar, counsel. Give me just a moment, counsel. All right, in a sidebar, the court was shown a potential statement that counsel for the defense has been able to review. I don't want that statement published to the court in the objection, but Mr. Wixom, is the proffered statement going to be elicited through a question to this witness?
It would be, Your Honor, yes.
And Mr. Pryor, is there an objection to that proffered statement?
Judge, I do have an objection. It's not only hearsay, double hearsay. Judge, it's also improper impeachment.
Okay, Mr. Wixom, what would be your response, knowing that counsel has reviewed that as well as the court, without again referring to any specifics of the statement? What exception would the state argue would apply to have this not be a hearsay statement?
Certainly, Your Honor. In fact, the state takes the position that we don't need an exception because it's not being offered to prove the truth of the matter asserted. It would be offered for the purposes explained on the sidebar. We certainly don't offer the particular statement or its substantive proof. It's contrary to what the state believes. We offer it as an evidentiary point that we think, frankly, is rebuttal to testimony given earlier.
All right, the court's considered this proposed statement in the hearsay rules. Looking at Rule 801C, the court would determine that for the purposes stated by the state, that it's not being offered to prove the truth of the matter asserted, that it isn't a hearsay statement. So for that reason, the objection's overruled, and you can continue with your direct, Mr. Wixom.
Thank you, Your Honor. Ma'am, again, calling your attention to the time after Tammy died in 2019. Did Emma ever make a statement to you about why she believed or how she believed that her mother had passed?
Yes.
What did she say to you?
She said that it was related to a blood clot. That's what the doctors were suspecting.
And that was the reason she gave you for her mother's passing?
Yes.
Your Honor, I don't have any further questions.
All right, thank you, Mr. Wixom. Mr. Pryor, you may cross.
Good morning. Pam, can you tell me on a weekly basis how often you'd have contact with Tammy Daybell?
A handful of times.
What's a handful?
I worked in that building 2 to 3 days a week, so 2 to 3 days a week.
And for what length of time, the 2 or 3 days a week that you would work with her, would you have contact, meaning more than just a casual walk by?
Probably one time a week.
And when you had the one time a week, actually, that you would have this contact, was it just a brief hi or was there a discussion?
There was discussion,
And how long would that discussion take place once a week?
anywhere from 5 to 20 to 30 minutes if we were eating lunch together.
And you had a habit of eating lunch with Tammy, is that right?
No, I did not.
Okay, so when would the 20 to 30 minutes, if you didn't eat lunch with her, come from then?
It was not a habit, but it happened in our time together.
Okay, and how often during your time together did you have time to sit down for 20 or 30 minutes and have these meaningful talks with Tammy?
If on the rare occasion that we ate lunch together, we would do that. She would come into my room in the mornings more often.
Okay.
I have 5 other women that work in my room and she enjoyed spending time with them as well. We're all readers, as was she, and she loved to share book ideas with us, and she enjoyed to chat with the other women in my room and myself.
And in this relationship then, would Emma also be one of those to go in the books and do this as well?
Not when no, she was not working for me at that time. She was a 3rd grade teacher at that time.
Okay, and Tammy was the librarian, is that right?
Correct.
And would you agree with me, this is a relatively small school?
Yes.
And when I say small, how would you define small?
15 teachers of regular classes, myself, librarian, PE teacher, principal.
So not a significant amount of distance between one end of the school and the other end of the school. Would that be fair?
That would be pretty subjective, I guess.
Okay. And would it be fair to say that you didn't share the same relationship with Emma that you shared with Tammy in terms of contact?
I probably have a closer relationship with Emma.
Now?
Yes, I still consider Emma my friend.
Okay. But at the time, these once a week meetings of a significant amount of time were with Tammy though, right?
Correct.
And you would describe Tammy as someone who was a bit of an introvert?
Objection, Your Honor. In the state's testimony.
Overruled. It's just a leading question.
Would you consider Tammy a little bit of an introvert?
No, she was a very friendly person. She felt very comfortable in our school, and among our colleagues, we're a very close, tight-knit school, and she always felt very comfortable around all of our colleagues.
So you would then say she was an outgoing person?
At school, yes, which is where I knew her.
Okay. And this outgoing person who had met with you once a week would talk about books, right?
Yeah.
Okay. Would talk about what's going on in the school.
Sure.
And then at that time when you were having meetings with and doing these once a week meetings with Tammy, you weren't at the same time doing the same thing with Emma, right?
Not at the same time because Emma was in her classroom.
Okay. But at some point, were you doing the same thing, meeting with Emma once a week and spending these deep, meaningful discussions with her as well?
Emma is my friend. So
Okay.
I would have discussions with her like I would any other friend.
Okay. And this close friend, you describe Emma as a close friend?
Yes.
And this close friend decided with another person that she works with at a school is going to confide in her a very private issue about her mother's.
Objection, argumentative, Your Honor.
Sustained.
So are you suggesting that Emma would share with you a very private issue about her mother's death? Is that what you're suggesting?
It wasn't a private issue. Her mother had passed away and she was sharing the cause.
Well, don't you consider that a private issue?
Objection, argumentative,
No.
Your Honor.
Okay, nothing else, Judge. Thank you.
All right. Well, I'm not going to rule on that objection. Those questions and answers will stand.
Really, Pryor? You consider that a private issue? So, when your neighbor across the road passes away, or I don't know, the guy that lives down the road passes away, and you are talking about it with your other neighbors, and somebody says, "What happened?" Or what are you supposed to do? Be going, "Shh, we don't want to talk about it. It's a private issue. It's private." No, you don't act like that. You say, "Oh, he died of a heart attack. Oh, he died of an aneurysm. Oh, he was murdered." Right? Good grief.
Mr. Wixom, if you'd like to redirect, you may.
Your Honor, I have no further questions.
Okay. That will conclude the testimony of the witness then. Is there any reason she'd remain under subpoena from the state?
No, Your Honor.
Not
Okay.
from the defense, Judge.
All right, you're released. Thank you for appearing and testifying today. You're welcome. All right, the state can call its next rebuttal witness.
Thank you, Your Honor. The state will call McKay Abaglin.
Oh, you guys, this is going to be a good one. This guy right here is a friend of Garth Daybell, who apparently this guy is going to say that Garth told him that Chad wasn't home when Garth found his mom dead. If I'm not mistaken. If I'm not mistaken.
I swear or affirm that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Okay, thank you.
All right, the court will note now the witness has been sworn. Before we begin with direct examination, I'll just inquire, Mr. Baglin, have you listened to any of the testimony that's taken place in this trial, either through the live stream or any other way observed any trial testimony?
I've not. No,
Okay, have you talked to anyone else about anything they've testified to in this trial?
no.
Okay, thank you for those responses. Ms. Blake, you can inquire on direct.
Thank you, Your Honor. Would you please state your name and spell it for the record?
Jason McKay Abeglin. That's JASON MACKAY ABEGGLEN.
And do you go by McKay?
Yes.
Mr. Baglin, do you know an individual named Garth Daybell?
Yes, I do.
How do you know him?
We worked together at a haunted attraction called the Haunted Mill.
And where's the Haunted Mill located?
It's in Teton, Idaho.
And when you say Teton, Idaho, is that the city of Teton?
Yes.
Do you recall approximately when you worked there with Garth?
I started working there, I think, in 2016, and we had worked together for quite a few years. But I worked like right next to him the year of 2019. We worked, yeah, really close.
And when you say you worked right next to him, can you explain a little bit what you mean by that?
He was just one room over from mine. And so if it was slower, we could like talk to each other and stuff. So,
And with the Haunted Mill, typically how long is that open? Is it a seasonal attraction?
yep, it's open for roughly the month of October.
And so in October of 2019, you were working in close proximity to Garth.
Yes.
At some point, did you and Garth develop a friendship?
Yeah, we did.
Did you sometimes hang out outside of work?
We went to a few haunted houses together after the season had ended. Yeah.
Did you hang out when you were at work and associate with each other?
Yes.
Did Garth generally talk to you about any issues within his family?
Nope.
Do you recall an occasion when he did share something with you about some family issues?
He told me it was the following weekend after his mom's passing. He talked about that.
What do you recall him telling you about that?
I remember he said that he found her when he got home from work, and he didn't know where his father was. And I don't remember if he said that she was in the bed or next to the bed, but she said she was kind of pale and her lips were blue.
On a typical night, when would work end at the Haunted Mill?
We usually left work around 12:30ish. Depending on how busy it was, we would go later. So some nights we'd go until like 1 or 1:30. But
And your understanding from what Garth told you was when he got home, he found his mother.
yeah,
And at that time, her lips were blue and she was pale,
yes,
and that he did not know where his father was.
correct.
I have no further questions.
All right. All right, Mr. Pryor, cross-examination.
Thank you, Your Honor. Sir, what was the work schedule at the Haunted Mill?
We would open around 7:30 and then it would go to midnight, but we weren't able to leave until the rest of the customers made it through the attraction.
And what days of the week would the Haunted Mill be open during the month, just the month of October, correct?
Correct. And it would be open. They changed their schedule. I think the last 2 weeks of the month it was full time, and then the rest of the month it was just on the weekends.
So if I understand correctly, that the last 2 weeks of October would be every day?
Yes.
Did that include Sundays?
No.
So it was Monday through Friday or Monday through Saturday?
Monday through Saturday.
And the day that the Haunted Mill would close would be the 31st of October,
Correct.
Halloween.
hmm
Okay. And do you know the day that Tammy Daybell died?
I do not.
Okay.
Hey, Morgana.
So when you
Hey,
told the
hey.
prosecuting attorney that it was the week after her passing, if you don't know what day she died, how do you know it was a week after her passing?
Garth he took a day off after it happened, and then he was back the following weekend. So it's just when I saw him next.
Okay, so it was the following weekend after the date that Tammy allegedly passed away.
Correct.
Did he mention anything about attending funeral services or any memorials the following weekend?
No, he did not.
Did he say anything about having to do visits with his church or anything like that as part of any program the weekend after that?
No, he did not.
Okay. Did he, so he indicated that she had blue lips and she had already passed, is that right?
Correct.
Did he indicate to you that at that time he played video games until 3 o'clock in the afternoon?
Objection, Your Honor, misstates testimony.
Overruled.
Did he say anything to you about the fact that he was playing video games until 3 o'clock that evening? Sir,
No, he did not.
did he say anything about hearing snoring coming from the room that night as well, sir?
No, he did not.
Okay. And you and Garth would be such close friends, you went to 2 haunted houses in 3 years?
Objection, Your Honor, misstates the testimony. Argumentative.
Sustained.
Move to strike.
I'll strike that question.
So how many, you mentioned that you went to a couple of haunted houses, is that right, sir?
Yeah, we did that all on the same night.
The same night as what?
It was, I think, the following weekend after our attraction had closed. We just went and visited some other places that were still open.
On the 31st. Who went with you?
It was myself, Garth, Kara Briggs, and Emma Moss.
And this revelation that he supposedly made to you
Objection,
occurred,
Your Honor, argumentative. Move to strike.
Sustained.
and this statement that he made to you supposedly occurred when during this visit?
Objection, Your Honor, again, argumentative with the word supposedly. Move to strike.
I'll sustain that as well, Mr. Pryor.
Can you tell me when and time, date the statement was made to you, sir?
I was still at work at the Haunted Mill. There were a few other scare actors around us at the time. It was a little bit closer to the end of the shift. Garth was pretty quiet most of the night, and then I kind of went up to him and gave him my condolences, and then that's when he told me that he had found her.
So you weren't particularly close friends, would that be fair?
Yeah, more like close coworkers.
Okay. And this close coworker disclosed to you something very personal about his mother's death, is that right?
Objection, Your Honor, calls for speculation.
Overruled.
This close coworker decided on one day just to disclose a very personal matter about his mother's death to you, is that right?
Correct.
Okay, nothing else, Judge. Thank you.
All right. Ms. Blake, redirect.
Mr. Baglin, when Garth talked to you about finding his mother, how did he appear?
He did seem sad, so I could tell something was affecting him.
And was he clear to you in his statement that he's the one that found his mom?
Yes.
And was he clear in his statement that his dad wasn't there?
Yes.
I have no further questions.
All right. That will conclude the testimony then of Mr. Baglin. I don't know if he was here under subpoena from the state, but if so, can he be released, Ms. Blake?
Yes, Your Honor, he may be released.
Yes, Your Honor.
Okay, thank you for your testimony. You can step down. All right, does the state have another rebuttal witness to call today?
Yes, Your Honor, the state will call Detective Bruce Mattingly.
Okay, question. So, do you guys feel like tell me your thoughts in the chat, okay? Tell me your thoughts in the chat. Do you feel like Chad was not there? That he like didn't want to be there and Alex came in and did it? Or do you feel like Garth said that Chad wasn't there because he didn't want Chad to be a suspect? Like, do you think that Garth had sneaky suspicions that something that his dad had done? You know what I'm saying? Like, what are your thoughts? What are your thoughts? I don't know how I feel. I don't know which way I'm leaning on this one.
Solemnly swear or affirm that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
All right, before we proceed with direct on this rebuttal witness, Detective Mattingly, have you observed any of the trial testimony that's taken place since you were last here?
No,
Have you talked to anyone else about the testimony they've given since you were last here?
no.
All right, thank you for responding to those questions. Ms. Blake, if you'd like to inquire on direct, you may.
Thank you. And Detective Mattingly, since it's been a moment since you've been here, would you please remind the jurors where you currently are employed?
Fremont County Sheriff's Office,
And how long have you been employed there?
about 23 years,
What is your current title or position?
Detective Sergeant.
Have you held other positions within the Fremont County Sheriff's Office?
I have, I worked patrol and school resource officer.
And at some point, did you personally become involved in an investigation into Tammy Daybell's death?
I did,
Do you recall approximately when you became involved?
about mid-December
And was that of 2019?
2019.
And again, is it fair to say that you also were involved in the investigation into the whereabouts of JJ Vallow and Tylee Ryan?
Yes,
Were you also involved in the investigation regarding their deaths?
I was.
At some point, do you recall receiving the results of the autopsy for Tammy Daybell?
Yes,
Do you know if anyone of any of Chad and Tammy's children reached out to the sheriff's office?
Judge, I'm going to object without some sufficient foundation.
Overruled.
And specifically in relation to the autopsy?
I do.
And who reached out?
Emma Daybell or Emma Murray.
Do you know at any point if anyone attempted to make contact with Emma Murray in relation to her request?
Yes, I learned that Detective Kaika Kamanu had attempted to reach
Judge,
out.
I'm going to object without foundation.
Overruled.
I learned that Detective Kaika Kamanu had reached out to, or attempted to reach out to Emma and Garth with no response or callback.
Based on that, at some point, did you do something in relation to the autopsy results and Emma Murray?
I did.
What did you do?
So where none of the family members were able to,
Judge, I'm going to object as non-responsive.
Overruled.
where none of the family members were contacted or had been found, we formed a team and we split up to make contact with most of the Daybell children.
And was that to make contact in relation to the autopsy?
That specifically, yes.
And who specifically were you going to attempt to make contact with?
I was attempting to make contact with Emma.
Do you recall approximately when you attempted to make contact with her?
February 18th, 2021, or after school had let out, so maybe around 4:30.
And where, well, you said after school had let out. Do you know where Emma was working at that time?
She was working as a teacher at Central Elementary in Sugar City.
And did you attempt to make contact with her at the school?
Yes,
And you said it would have been after school let out?
yes,
Did anyone else go with you to try to make that contact?
yes. That would be Lieutenant Ron Ball with Rexburg Police Department.
And prior to this attempt to make contact, had you personally had any involvement with Emma Marie?
Not personally, no.
You'd not had personal contact with her prior to this?
No.
Were you ultimately able to make contact with Miss Marie that day?
Yes, we did.
Did you have some kind of a recording device on?
Yes,
And was a recording made of that attempt to contact her?
there was.
Your Honor, I have what's been marked as State's Exhibit 427, and defense already has a copy. And the state's intent would be to ultimately ask to publish a portion of that for identification purposes unless there's a stipulation for admission.
There's no stipulation.
Okay, so without stipulation, you may just publish just enough without any content, obviously, that would influence the jury if it doesn't come in, just enough to establish foundation. I'll permit that.
Thank you, Your Honor. And if I may have that, and I'll play from the exhibit for the court.
Very well.
Been a while, Rick. Yeah. How you been? It's been.
And I'll pause right there. Detective Mattingly, do you recognize the voices in that recording?
I do.
And who are those voices we're hearing?
Myself and Principal Rich Garner.
Does this in fact appear to be a correct depiction of the audio recording that you made that day?
Yes.
Your Honor, based on that, the state would move for the admission.
Any objection?
No.
All right, exhibit 427 is admitted.
And Your Honor, the state would intend to play the exhibit partway through.
All right, if you'll please identify the portions you play when you publish.
And Your Honor, the state will begin to play from minute mark 5:50.
I hit the wrong door. Thought you were going to go to the front. I apologize.
Hold on a second, you guys. Let me go and change this to normal speed so we can hear it more clearly. And then let me rewind it just a smidge. All right, now let's go.
No.
All right, exhibit 427 is admitted.
And Your Honor, the state would intend to play the exhibit partway through.
All right, if you'll please identify the portions you play when you publish.
And Your Honor, the state will begin to play from minute mark 5:50.
I hit the wrong door. Thought you were going to go to the front. I apologize. I'm Bruce Mattingly with Fremont Sheriff's Office. And the sheriff said you've been working at trying to get a hold of us.
Yes.
And to talk on the autopsy results. We've been trying to get a hold of you and other family members, but probably been a comedy of errors. We haven't been able to do so.
Okay.
And which is why we showed up here, because we'd like to be able to talk with family, you, because I know you were the one that made a request,
Yes.
right? So we'd like to be able to do that. And
I'm going to pause here momentarily. Do you know who that female voice is that we're hearing?
That was Emma Daybell.
And did you hear in there where she confirmed she was the one that had requested the autopsy results?
Yes.
I'm going to continue playing. I stopped it at 6:31 for the benefit of the record, and I'll continue playing from 6:31.
because you're here, and we're here, want to take a few minutes and talk about that and go over that? Or? Okay. Who is the attorney so we can contact?
So we've worked with Josh Garner before, but right now we don't have an attorney-client relationship with any particular attorney.
Okay. So we
decided we're gonna wait to learn what it is when you're ready to release it.
Okay. That is a choice, but we usually just let family, we always let family know. Personally, I've not had anybody really say that they want to wait. That's a little.
We're just not interested in interviewing, answering any questions. We just want to see it.
Sure. We'd like to at least let you know what's in it, and tell you about it. We're not asking for an interview.
I'm gonna pause right there, Detective Mattingly. Did you hear Emma again decline to see the results?
Yes.
And what did you tell her in relation to whether or not she would have to be subjected to an interview?
I told her she didn't have to do an interview.
For the record, stopped at minute mark 7:35, and I'll continue playing from there.
So, and of course, like now, if you're always free to leave, you can tell us we're done, anything. We're not looking to ask questions. We do want to just let you know the findings.
And again, stopping at 7:45, Detective Mattingly, did you again hear yourself confirm she would not have to provide information?
Yes.
And starting again from 7:49.
And then later, the report will, attorneys will get everything. But where we know it's back, you know it's back, we want to let family know.
Okay.
And let people know what the results are. We can't go in depth on the report, but we can talk and give general findings, at least for now. So would you like that? Would you like to do that? What are your, okay, do you want me to set that up with Josh?
I'll have him call you.
Okay, can I give you my card so he knows who to call? That'd be great. This is an Embrace, right?
Yep.
So, I said that, he knows me, he knows my number. I also, just for preparatory, I was hoping to find you, and I'm glad I did. This number on the back is for victim services, which helps with counseling and anything else because you lost your mind. That's what this number's for, is to help with that. Okay? It is our prosecutor's office. You don't have to talk to the prosecutor. Just say, hey, I'm looking for help with victims services. Here, I'll give you that. And that's for you, for the kids, the rest of your siblings. Okay?
Okay.
And then Josh, he can. You have Josh's number?
Yeah.
Okay.
And pausing at 9:23, Detective Mattingly, did you in fact offer Miss Marie contact information for victim services?
I did.
Did you also offer her contact information for the prosecutor's office?
Yes.
What did you expressly tell her in relation to the prosecutor's office?
To call the prosecutor's office for the help with the victim services. And more specifically, she didn't have to talk with anyone with the prosecutors.
And playing from 9:23.
All right. Are they building a new school over there?
They are. We're
Which one is
growing.
that?
So that's gonna be a junior high, and then they're taking third grade out of this school. This is K-3. They're moving
Wow.
third grade over there. That's 4 through 6 right now, and
So
then
you're moving over there?
sixth grade. Yeah, I'm moving over there across the field, and then they're moving 6th grade over there. There's a junior high down the road that they'll move over there, and then the high school will stay the same. So we're just
Okay.
trying to wait until it's finished. It was supposed to be done by this fall, but you know how
It was. Especially these days. For sure. So, are you increasing the principal?
no, it'll be the current principal of the junior high. I'm not sure what they'll use that building for.
Okay.
There was
Alright.
talk about it being a YMCA, but that was just a Sugar City rumor.
I know how small town rumors go.
Yeah, I think they just want a swimming pool, but yeah, so it'll be mostly just rotation.
All right. So I do want to let you know, because we've been having difficulties trying to get a hold of people. Today was the day that we were able to get other deputies, officers to go out and try and find and make contact one way or another.
Okay.
So, if you hear from other family members or you don't, it might be dependent upon if we were able to find them or not. Okay, so I don't want that to be a big blame for you. I just want to let you know, hey, if we haven't been able to get hold of anybody, it's important to let people know or have that opportunity. That's what we were working on. So, okay.
Thank you.
I'm pausing at 11:13. Detective Mattingly, You were informing her that other family members were going to be contacted. Do you recall that?
Yes,
Do you know who some of the other family members that contact was going to be attempted with?
Judge, objection on foundation.
Sustain.
Based on the investigation, did you discuss things with other investigators?
yes,
And you indicated that you had met and talked about going out to try to provide results to some of the kids, the autopsy results.
yes.
Do you know who some of the other individuals from the family were that contact was going to be attempted with?
I do.
And who was that?
Judge, objection, still insufficient foundation.
Overruled.
Garth Daybell, uh, Seth, and Leah.
And was the attempt to reach out to some of those kids going to be done around the same time you were attempting contact with Emma?
Yes,
And at the end of that, did you hear Emma tell you thank you?
she did.
And there was some conversation between you, Emma, and Lieutenant Ball. Did you also hear that?
I did.
I'm going to continue from 11:13.
Josh knows how to get a hold of me. We've talked before, worked with Vince, he knows how to get a hold of Vince, our office, we're not that big. So have him give us a call, then we can go out and sit down with him and you and talk about it. That is true. He did reach out and he said, Emma called, we were gonna do a schedule, but he says, as far as I know, I'm not representing, but maybe things have changed.
Okay.
So, get that ball rolling. I'd like you to know about that,
Okay.
okay? But that's, I'm not gonna make anything up or make you do anything. I do wanna let you know.
Okay. Thank you very much.
Yeah, thank you. Yep.
And stopping at 12:14 or 12:15. Detective Mattingly, at the time you were attempting to share these results with Miss Murray, was this still an active investigation?
It was.
And is it fair to say you were not going to provide her a copy of the autopsy at that time based on that?
Correct.
But you were willing to sit down and go over some of the results with her?
Yes,
There was some talk about an individual named Josh. Do you know who that was in reference to?
I do. That was in reference to Attorney Josh Garner.
At any point, did you attempt to make contact with Josh Garner about this?
We did.
What did you learn?
Judge, objection is going to call for hearsay.
Sustain.
Your Honor, and I would argue it's not coming in for the truth of the matter, but for why the officer did what he did next.
Judge, it's absolutely coming in for the truth of the matter.
I'm gonna sustain that as hearsay, Ms. Blake.
In the recording, did you hear yourself reference that he'd indicated he wasn't actually representing the kids?
Yes.
And was that in reference to Josh Garner?
Judge, I'm going to move to strike.
It was in the recording.
Overruled.
Yes.
Did Emma ever reach out to the Fremont County Sheriff's Office again in an attempt to get the results?
No.
When you met with Emma, did she tell you anything about concerns regarding her mother's health?
Judge, objection.
Overruled.
She did not.
At the very end of the recording, you say something along the lines of, I do want to let you know. What was that in regards to?
It's in regards to the findings from the autopsy result.
So you wanted to make sure that Emma Marie had access and knew the results of that autopsy.
Yes,
And again, Emma Marie declined to hear those results.
she did.
I have no further questions. Thank you.
All right. All right, Mr. Pryor, cross-examination.
Good morning, Detective.
Good morning.
Would you characterize Emma as being polite on that day?
She was.
Responsive?
Yes.
Okay. Now, the autopsy was performed on December 11th of 2019. Is that correct?
Yes.
Okay. And you obtained the results on February 18th of 2021?
No, we had to obtain those earlier.
Well, how much earlier did you obtain the results?
I don't recall.
Okay. Well, was it a week?
Probably a little longer.
Was it a month?
Could be about close to that.
Was it possible it was a year you had the results?
No.
Okay. So we know it was close to a month. Is that what you recall?
Thereabouts, yes.
Okay. And you held the results, correct?
Yes.
And then at some point you elected to go notify the family. Is that right?
Yes.
Okay. And at the time of the autopsy on December 11th, 2019, well, let me go back. On February 18, 2021, providing the family with the results, that wasn't any kind of an investigative concern, was it?
No.
Okay. And a month earlier, when you had the results, was there some sort of investigative concern with providing the family notification of why their mother was exhumed and an autopsy was done? Officer?
Yes.
What?
Would you repeat the question?
Yeah. The month before, while you held on to the autopsy, is there some investigative concern as to why you didn't let her know right away?
Yes.
And what was the investigative concern?
On whether or not we can release the autopsies, whether we can provide a copy,
Okay.
and how best to go about doing that without violating any rights or with the investigation going on.
So you were concerned about the investigative and not concerned about the rights of the family to know why you exhumed the
Objection, Your
mother?
Honor. This is argumentative and it misstates the testimony just given.
Sustained.
So was there a concern about protecting the investigation? Or was there a concern about holding on to the results until you chose the time to let the family know?
Objection, Your Honor. Argumentative.
Overruled.
You can answer that.
Repeat the question, please.
Was the concern over an investigation, officer? Or was the concern for a month that you wanted to figure out how you were going to tell the family and when?
Both, I would say.
Okay. Now, at the time that Tammy Daybell was exhumed, were there concerns about the Daybell 5 children knowing about why you're exhuming their mother?
Objection, Your Honor. Beyond the scope.
So at that time, I was not a part of the investigation.
Okay, so you're not aware of any reason why they just didn't tell Garth, Mark, Leah, Emma, Seth about why their mother was exhumed. Is that correct?
Objection, Your Honor. This has been asked and answered. He said he wasn't part of the investigation at that time.
Sustained.
Okay. I listened to the first part of the tape, officer, and it seems to mention at about 5:50 that Emma says to you, 5:50 on the tape. And if we need to go back and listen to it, it may take me a little bit, but we can do it if we need to.
Okay, thank you.
You're welcome. And at 5:50 on the tape, she makes some statement, Emma makes some statement about trying to get a hold of you folks. Do you remember that?
Yes,
How many times did she try to get a hold of you?
I'm aware of one time.
Are there possibilities that she called other people within your agency or other agencies to get a hold of them about this autopsy results?
Possibly.
Okay. And then you made something comment shortly after that. I believe it was at the 6 or 6:02 mark where you said something about it's been a comedy of errors. What was the comedy of errors?
I made that statement trying to lighten the situation about where I knew Detective Kai Kakamanu had attempted to reach out, left messages. We hadn't heard any returns.
Okay. So you previously testified that you're aware of at least one instance where Emma Murray reached out to find out why you exhumed their mother and what the results were. And then,
Objection, Your Honor, mischaracterizes the testimony. There was nothing about exhuming.
Sustained.
Okay.
Move to strike.
Strike that.
so you're aware of one phone call where you're discussing with Emma, or trying to discuss with Emma the results of the autopsy. And you're saying that because of all this difficulty communicating with the family, the expression you use to Emma is a comedy of errors to lighten the situation about telling her why her mother died, right?
Objection, Your Honor, asked and answered and mischaracterizes testimony.
Overruled.
It's a light situation to tell it.
Mr. Pryor didn't even answer the question yet before you,
I'm going to withdraw the question, Judge. And I'll ask another question if I may.
go ahead.
It's a light situation to notify a daughter as to why their mother died. Is that what you're saying?
Objection, Your Honor, argumentative mischaracterizes testimony.
Sustained.
Move to strike.
Strike that.
Okay. You made a comment about to take a few minutes and talk about the autopsy results, correct?
Yes,
Okay, so it wasn't just a matter of letting her know what the results were, right? You wanted to talk to her about it.
about the autopsy results,
Right.
yes.
You couldn't just tell her what the results found, right?
I didn't want to just throw that out there, no.
Okay.
Hmm.
You wanted to talk about it, right?
Yes,
Now, as a detective, there's been previous testimony about carrying body cams and recorders. Was it your normal policy to have a body cam and a recorder on when you interview witnesses?
we don't have a policy on that.
Okay. So you chose in this instance to wear a recorder, is that right?
I did,
Did you take an instance to wear a body cam as well?
no.
So there's no policy on it, but in this instance, what you were really trying to do was to capture what her reaction would be when you told her about the results. Isn't that true?
Objection, Your Honor, argumentative.
Sustained.
Move to strike.
Strike that question.
Isn't it true your motive to talk to Emma Murray was to gauge a reaction on tape?
No,
So with this discussion about her wanting to get a lawyer, well, let me strike that. So from the time she's exhumed to December 11th of 2019 to February 18, 2021, approximately 14 months. In the interim during that time, let's start in December of 2019 when she was exhumed, and for each and every month, at any time, did you go over and try to talk to Emma Murray about what the results of her mother's autopsy was?
what were those dates again?
Well, the day she was exhumed, December 11, 2019, and the day you approached Emma for the first time personally was February 18, 2021, right?
Correct.
And during those interim times, did you, or anybody from your office to your knowledge, go up to any member of the Murray family and say, we're waiting on the results? Did you do that?
No,
Did you go up to anybody in the Murray family or the Daybell family other than Chad and say, there's been some delays in us getting the report, but we really would like to talk to you and we'll do some pre-planning to do that? Did you do that?
I did not.
Okay. So after 14 months, your organization decided en masse that you're going to hit all of the kids and wear recorders and try to go tell the kids about what's going on, correct?
Objection, Your Honor, misstates the testimony, argumentative.
Overruled.
Correct?
Yes, sir.
Okay. And then at some point, you know who Josh Garner is, right?
I do.
You've had encounters with him, correct?
Yes,
And at some point, you were aware that Emma had retained Josh Garner, correct?
we learned that she had not.
Prior to that time, were you aware that she had had representation through him?
Yes,
Okay. So you knew that there was a potential connection there, correct?
correct.
And would you really blame her, Emma, if after 14 months of not hearing anything from your organization, she's a little skeptical to talk to you folks about what you're wanting to say to her?
Objection, Your Honor, argumentative.
Sustained.
Move to strike.
Strike that question.
You did mention that you weren't interested in interviewing her and asking any questions. You did say that though, right?
Yes.
Okay. So your explanation is that you wanted to be more sensitive to her about letting her know what the results were, correct?
Absolutely.
And you wanted to sit down with her and have an opportunity while the recorder's on to gauge her reaction, right?
I wanted to sit down and discuss that with her, not just for any reaction.
And then at the end, when you're talking about the school, was that also a police tactic to sort of soften her a little bit so that maybe she would open up and talk to you about things?
That was Lieutenant Ron Ball who had made that statement and questioned her about that.
Well, I don't care who made the statement. I asked whether it was a police tactic.
Objection, Your Honor, calls for speculation.
Sustained.
Move to strike.
Strike that question.
And then you suggested to her that she get information from the victim services, correct?
Yes.
Okay. And the victim services, is that an office within the prosecutor's office?
The prosecutor's office helps manage victim services.
So in the fancy way of saying that is the prosecutor has the authority over victim services, or when you say manage, they supervise the victim services program, correct?
As I understand, correct.
Okay. So the prosecutor's office, that would be the same prosecutor's office that issued the order to exhume Tammy Daybell, right?
Objection, Your Honor. This is misstates evidence. Prosecutor's offices don't issue orders.
Well, all right, Ms. Blake, this is part of the reason why I don't like speaking objections, because now you put that out there. I'm overruling the objection. If the witness knows the answer, he may answer that, and you can correct that on redirect.
Would you ask that again, please?
Well, the prosecutor's office was the organization in Madison County and Fremont County to pursue trying to get an order to have Tammy Daybell's body exhumed, correct?
That was done through a prosecutor's office, I believe, in Utah.
Okay.
Mm.
And the information was to obtain, or the purpose was to obtain information surrounding an investigation of Tammy Daybell in this area as well, right?
Yes.
Okay. So would it surprise you if Emma Murray would be quite hesitant to approach an organization affiliated with the prosecutor's office when she wasn't told her mother was being exhumed?
Objection, Your Honor. Argumentative calls for speculation.
Sustained.
So you gave her information from organizations that are managed and organized by the prosecutor's office, correct?
Yes.
And the purpose of that was that they could utilize those services to maybe have someone talk to them about what's going on in the case, right?
Among other things.
What are the other things?
Such as counseling.
Okay. And you're very concerned about the counseling with the Daybell children 14 months after their mother was exhumed, right?
Objection, Your Honor. Argumentative.
Overruled.
Yes.
Well, why weren't you so concerned on the day their mother was exhumed and and the whole family on both sides wasn't notified that they were taking their mother out of her burial site?
Objection, Your Honor. This is argumentative.
Sustained.
I have
Move to strike.
nothing else, Judge. Thank you.
All right, that last question of counsel is stricken. That concludes cross. Ms. Blake, you can redirect.
Detective Mattingly, counsel asked you about Emma being polite. Is that fair?
Yes.
From what you heard in the audio, were you also polite?
I believe I was.
Was Detective Ball polite?
He was.
Were any threats made to Emma?
None.
I think you testified the autopsy report, maybe the results had come in approximately a month before, give or take.
Yes.
And you, in fact, were there to try to share the results of that report with Miss Murray. Is that correct?
Correct.
And she declined.
She did.
As part of your employment and work in law enforcement, have you ever been involved in death notifications?
Several.
Do you generally just go and blurt out what the cause of someone's death is?
No,
Do you generally want to sit down and have that conversation?
I do.
And in this case, you were trying to share autopsy results regarding Emma Murray's mother. Is that correct?
Yes,
Would it be fair to say in your experience that you would want to sit down and discuss with someone when there's been a finding by a medical examiner that the death was homicide by asphyxiation?
I would.
I have no further questions.
All right, thank you, Ms. Blake. That'll conclude Detective Mattingly's testimony then. And where this is rebuttal, I don't believe he would be recalled for any reason. Is that correct?
He would not, Your Honor. The state would release him.
Okay. You are released from any subpoena you had, Detective Mattingly. Thank you for coming in and testifying today. You can go ahead and step down.
Thank you.
All right, does the state have another witness to call today?
We do not have additional witnesses for today, Your Honor.
Okay, thank you, counsel. The court was advised, as was the jury, of our likely schedule for today. So we are going to recess for the day. We've also got tomorrow off and we'll resume on Tuesday with additional rebuttal. Is that correct, Ms. Blake?
That is correct, Your Honor.
Okay. Ladies and gentlemen of the jury, then we are going to recess for the day. This is a long break for you. You've continued to comply with the court's admonishing instruction. I wanted to put some special emphasis on that just because in the likely event, being this a holiday weekend, you might be around lots of friends and family. Please advise anyone that is curious about your jury service that you're simply not permitted to talk about the case. I think people generally are pretty good to understand and respect that if you are telling them that that's simply the order of the court. I do appreciate your attentiveness. We'll return on Tuesday for additional testimony. And again, I'll admonish you, please don't discuss the case or talk about any of the testimony with anyone else or with each other. You can only do that during deliberations, and please don't do anything to investigate anything about this case while we have this long recess. So we will return for further testimony starting Tuesday morning. And I appreciate all those in attendance today complying with the courtroom conduct order. With that, then we'll be in recess until Tuesday.
Roy, please.
Hey, hey, Mary Lou, how are you, doll? Sounds like it, Margaret. Sounds like it. Sounds like it. Oh, let's see. Yeah, they're gone. All right, let me stop sharing this screen. Exit out of there. All right. All right, you guys. Today was a good day. Today was a good day. Yeah. That's for sure, right, Margaret? A case for the ages. Ah. Well, I appreciate you guys joining me today. I'm going to call it an early day. I know that there's supposed to be a Brian Koberger hearing in like an hour. I'm not sure what it's about. But we have a big day tomorrow. I got lots of stuff to get done today before it gets too late. So I'm going to go ahead and skedaddle out of here. And tomorrow, QB will be your hostess with the mostest. And yeah, I'm sure she'll have lots of words because apparently there's something going on with Brian Higgins, who's supposed to be on the stand tomorrow for Karen Reed. So we will see. We will see. Patricia says probably another hearing to accomplish very little for Koberger, right? No, it's a nothing burger for Koberger, right? Uh. All right, I will see you guys. If not tomorrow, which I might try to pop in tomorrow, just depends on timing and stuff. I don't know. If not, then I'll definitely see you back probably Tuesday because Monday is Memorial Day. So, yeah. I don't know what would be going on Monday. So, but thanks you guys. I appreciate it. And absolutely, Henny. Yes, Sherry. Yes, ma'am. Yes, yes, yes. It'll probably be a short one though. Not a very long one. But I will see you guys soon. I love y'all. Bye.